Welcome. I'm AdaKay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Whoa, that got loud. My apologies. Good morning, everybody. It's an early morning. It's 8 o'clock here in my neck of the woods. We are awaiting for the Donna Adelson trial to start. Woohoo! Day one. Day one. Well, sort of day one. Sort of day one. We got opening statements today. Hopefully, we'll get into trial. Welcome, June, my first in chat. Lady Jane, my second in chat. Thank you guys so much for joining. Oh my gosh, it's going to be a day. It's going to be a good day. I got Mr. Pickle. I got Mr. Pickle in a place of honor over here because when it gets deep, we will be using Mr. Pickle. I hope everybody had a good rest last night. We did, and I'm hot. I'm going to turn me down. There we go. I think that's better. Lady Jane or June, give me a thumbs up if the volume now is a lot better because I think that was a little hot. I think it was a little hot. But we are sitting here with the proverbial seal of Florida. It's a pretty one, though. It is a pretty one. I've got my cup of coffee, which, so needed. I actually got 7 hours sleep last night, y'all. 7 hours! Considering the last 3 nights before, I only got 10 hours total. Okay, it looks like the court is getting ready. So with that, let me do a quick rundown. Not guilty versus innocent is what we do not want. Okay. Welcome, everybody. This is August the 22nd of 2025. This is day one in the Leon County Courthouse, Tallahassee, Florida. Judge Stephen Everett for Donna Adelson has been charged with first-degree red room, conspiracy to commit red room, and soliciting to commit red room. Victim is Dan Markel, a Florida State University professor, and Donna Adelson's former son-in-law. So the prosecution is claiming that framed Donna Adelson as a matriarchal architect of the Red Room to Hire plot to eliminate Dan Markel. Alleged she is coordinated with her son, Charlie Adelson, and the middle woman, Catherine McBonwa, to carry out the hit. Highlighted Donna's motives are anger over custody rulings and desire to relocate her daughter, Wendy, and grandchildren to Miami. Previewed evidence including wiretapping financial records, Donna's post-arrest attempts to flee the country on a one-way ticket to Vietnam. The defense is arguing that Donna was a grieving grandmother caught in the web of circumstantial suspicion, claimed that the prosecution's case relies on guilt by association in the actions for her son, emphasized the lack of direct forensic evidence tying Donna to the crime, and suggested that the state is overreaching based on family dynamics and media pressure. The family loyalty and criminal intent is Donna was protecting her daughter and orchestrating the Red Room. She is a flight risk because she was ready to actually, at the airport, getting ready to walk on a plane to be going all the way to Vietnam with no extradition agreement with the U.S. So that is a quick breakdown into what we're going to get into today. And there she is. Oh, what is it with her in the striped shirts? What is it with her in the striped shirts?
Everyone can be seated. Good morning, members of the jury. Thank you. Everyone recalled. Good job. Juror number one, how did I do on the snacks?
Ah! Juror number one asked if they could bring snacks. I love that. You know, this guy, he's got a good sense of humor. I really like him. He's good. So, love him. I really do. He can be all rough and gruff, but he does have a good sense of humor. They were asking if they could bring snacks, and he goes, yes, and I will provide some.
You're welcome. Before we get started this morning, I'm going to give you some preliminary.
That's their sound in and out, not mine.
How the trial will take place, and also an instruction on note taking. Does everyone have a pen and notepad? If you can hold those up for me so I can see. For the record, each juror has a pen and notepad. After I've given you these two instructions, at that point, the parties will have their opportunities to give their opening statements, and the state will proceed with its case. Once again, throughout.
Okay, guys, I got to warn you, the sound sucks in this courtroom, that in and out noise and all that. There's nothing I can do about that. I've got this gained and put as best as I'm going to be able to. But guess what? If I'm struggling, so is everybody else. So yay, I'm not alone. I'm in good company.
This trial process, I will be reading to you quite a bit. Again, it's not that I just do not wish to speak to you in a normal fashion, but the instruction that you are to receive from the court concerning the law during this case is to be specific, and it is to be uniform. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Donna Adelson. This is a criminal case. Donna Adelson is charged with first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. The definition of these offenses will be explained to you later in this trial. The state's charging document, which is called an indictment, is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Donna Adelson in accordance with the law that I will provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they believe are proper. When an objection is made, you must not speculate on the reason why it has been made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer that question. During the trial, it may be necessary for me to confer with the attorneys out of your hearing to discuss matters that require my consideration alone. It is impossible to predict when such a conference may be required or for how long such a conference may last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of this case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you choose not to. This is going to be an individual choice for each juror. You have been provided with a notepad and pen for your use if you do wish to take notes. Any notes that you take will be for your personal use. However, you are not to remove your notepads from the courtroom. During any recess or break, you are to leave your notepads in your seats. When the trial reconvenes, you will have access to your notepads once again. After you've completed your deliberations in this matter, my bailiff will deliver your notepads to me. From there, your notepads will be destroyed. No one will ever read your notes. If you choose to take notes during this trial, please do not get so involved in note-taking that you've become distracted from the actual proceedings. Your notes should only be used as an aid to your memory. Is the state prepared to give its opening statement at this time? You may proceed.
Good morning, everybody. Again, I'm Sarah Catherine Dugan. Georgia Kappelman and I are representing the state of Florida in this case. And this is the defendant, Donna Adelson. We see her here at the defense table, and this is how she appeared back in 2014 when this crime occurred 11 years ago.
Actually, no, she was a lot less than weight, and she didn't have gray hair. That was strange.
And the reason that we're here today is because this defendant, Donna Adelson, was part of a conspiracy to hire a hitman to kill her former son-in-law, Dan Markel. This murder was set into motion because back in 2014, this defendant's family had a big problem. And the big problem was Dan Markel. And the solution to that problem was the defendant's son, Charlie Adelson. Charlie Adelson was the solution because he had a girlfriend with connections to the type of people who were willing and capable of pointing a gun at a complete stranger and pulling the trigger. The victim in this case, Dan Markel, was known as Danny to his friends and family. He was a loving father to 2 little boys, and he was a highly respected law professor at Florida State University College of Law. Tragically, on July 18th of 2014, Dan Markel was shot in the head in broad daylight in the driveway of his home in the Benton Hills neighborhood here in Tallahassee. The last day of his life began like any other day of his that summer. He woke up, he took his 2 young sons to preschool, and then he went to the gym to work out.
Okay, guys, give me a second. There's a weird clicking, and I'm trying to solve it.
And he opened his garage. But little did he know that throughout his entire routine that morning, he was being followed by 2 hired hitmen who traveled all the way to Tallahassee from Miami for the sole purpose of taking his life. And like something out of a horror movie, when he pulled into his driveway, the killers pulled in right behind him. Moments later, Dan Markel's neighbor heard a gunshot, and he looked out the window and saw a light-colored Toyota Prius back quickly out of Dan Markel's driveway and speed away. The neighbor thought that was very unusual, very suspicious, so he waited a second to see if Dan Markel also backed out of his driveway or came out of his house. And when he didn't see him, the neighbor got, a very funny feeling. And he went over to Dan Markel's open garage to see if there was anything wrong. And he found a gruesome scene. Dan Markel's car window, his driver's side window, was shattered. His glasses and his phone were on the ground next to his car. And Dan Markel was behind the wheel. He was unresponsive and moaning and terribly injured. The neighbor called 911 and law enforcement arrived to find Dan Markel with a gunshot wound to the head. He was taken to the hospital where he survived for about 14 hours before he was pronounced dead. Dan Markel was only 41 years old. And his little boys, who were deprived of their father after this murder, were just 3 and 4 years old. Bless you. Law enforcement began to investigate to try to figure out who did this, who shot Dan Markel. The scene there, the crime scene, left no trace of the killers. There was no fingerprints, no DNA, no bullet casing, nothing was stolen. And so police began to suspect that this may be a professional killing. The little evidence that they do have sends them down 2 separate paths. One path is to track down that light-colored Prius that the neighbor saw fleeing from the scene. And the other is to identify who was inside that Prius. And the other path relates to motive. Who in Dan Markel's life would hate him enough to hire a professional killer to kill him? And after years of tireless investigation, both of these paths led directly to this defendant. So first, let's talk about the path involving motive. We'll go down both paths this morning. Police investigated Dan Markel's personal life to try to figure out a motive in this case, to see who might want him dead. And they learned that Dan Markel was entangled in a very nasty divorce with his ex-wife, who is the defendant's daughter. And his ex-wife is named Wendy Adelson. A review of the divorce case file reveals that Wendy Adelson had asked the court to allow her to relocate to Miami, where she was from and where her parents lived, with her children and Dan Markel's children, in order to be closer to her mother, Donna Adelson, to her father, whose name is Harvey Adelson, and to her brother, whose name is Charlie Adelson. The victim, Dan Markel, as y'all can imagine, is adamantly opposed to this, to his children being relocated to Miami. He works here in Tallahassee. He's a law professor here in Tallahassee. This is where he lives. This is where his kids have been raised. He wants his children here with him. A review by law enforcement of Wendy Adelson's emails made it clear that her mother, the defendant, hated Dan Markel and was the relentless driving force behind Wendy's relocation efforts to South Florida. And, being a caring and involved parent is great, but the defendant's participation in her children's lives went beyond mere involvement or even meddling. She was extremely controlling. She had very strong opinions about all the decisions in Wendy Adelson's life, whether it be about her career, her relationships, or even purchasing a home. And if Wendy Adelson would not do as the defendant wanted her to do, the defendant often then enlisted Charlie Adelson, her son, Wendy's brother, to solve the problem by getting him to kind of go to Wendy and persuade Wendy until Wendy ultimately agreed to do what the defendant wanted her to do. And while the defendant had always been controlling of her children's lives, the emails uncovered by law enforcement showed that this defendant was desperate to find a way for Wendy and Dan Markel's children, her grandchildren, to be able to relocate to Miami. The defendant told Wendy that she deserved more than just a life teaching in Tallahassee without her family, and that Dan Markel was essentially holding her hostage in Tallahassee because of his job. During the divorce and custody battle, the defendant's email showed that she was heavily involved in Wendy's court case, even going so far as to draft and edit the documents that Wendy and her attorney were filing in court, and emailing Wendy instructions for her attorney on arguments her attorney should make and what her attorney should do. The defendant would guilt trip Wendy Adelson about how much time she and her husband, Harvey Adelson, were having to spend away from their dental practice to visit Wendy and the grandkids in Tallahassee, and complain about how the family was losing income, losing patients because of their constant absences from the practice. And the defendant instructed Wendy Adelson that relocation to Miami was the most important priority in this divorce, and if it had to be her non-negotiable in the divorce. In June of 2013, the judge in the divorce case ended up ruling in Dan Markel's favor. And not only did the judge deny Wendy's relocation motion, but the judge dismissed it in a way that prevented Wendy Adelson from requesting the relocation again. So Wendy would not be permitted to move to Miami to be close to the defendant and her husband with the children at that time or ever, unless of course something happened to Dan Markel. After the judge denied the relocation motion, after that was denied, the defendant told Wendy Adelson in emails that Dan Markel has not beaten the Adelson family yet. She let Wendy know that the Adelson family is a team and they are trying to win. Donna Adelson suggested in her emails several bribes to get Dan Markel to agree to relocation, like plane tickets, paying for her grandson's education, and the defendant even suggested offering Dan Markel a $1 million bribe to allow the relocation, to let Wendy move to Miami with the boys. And if the bribes didn't work, the defendant also suggested several ways that Wendy could threaten or bully Dan Markel into submission. The defendant told Wendy to aggravate Dan Markel like he aggravates you. And the defendant set out a plan of action that the defendant told Wendy would make Dan Markel absolutely miserable. And she's detailing all of these in her emails. So, for the plan of action, the defendant knew that Dan Markel was devoutly Jewish. So she came up with the idea for Wendy to pose Dan Markel's sons for pictures in front of a Catholic church, and then post the pictures to social media, and even announce on social media she was getting the children baptized just to make it appear to Dan Markel that she was changing their religion. The defendant assured Wendy Adelson that this would all be an act to get Dan Markel to agree to let her move to Miami, but told Wendy Adelson that in order to pull off this stunt, she had to put on the acting performance of her life. The defendant said that it did not matter to her if Wendy had to dress her two little toddlers up in Nazi or SS uniforms, as long as she was able to get them to South Florida and show Dan Markel that he was not in control. The defendant repeatedly told Wendy Adelson that the rest of her life, meaning Wendy's life, as well as the defendant's life, Harvey Adelson's life, and Charlie Adelson's life, depended on Wendy Adelson and the boys being able to relocate to Miami. And the defendant said that she would never, never, never give up and never stop fighting for Wendy and the boys to be relocated to Miami. And she never did. The evidence in this case will show you that this defendant's closest confidant was her son, Charlie Adelson. She and Charlie Adelson talk multiple times a day, every day. And he was the person with whom she would constantly vent and complain to about Wendy's situation here in Tallahassee, having to live in Tallahassee with her sons. And she would often, the defendant would use very dramatic life and death terms to describe it. The defendant portrayed Dan Markel to Charlie Adelson as a crazy person who was impossible to deal with and was causing an extreme amount of stress to Donna Adelson and her husband, Harvey Adelson. And Charlie Adelson was also the person that Donna Adelson relied on to solve her problems. And her daughter and grandsons having to live 8 hours away in Tallahassee was a big, big problem for this defendant. And this defendant made it Charlie Adelson's problem to solve. And although the divorce between Wendy and Dan Markel was final a year before the murder, throughout that year, litigation is still ongoing, to say the least. Each side is continuing to routinely file violations of the custody agreement, violations of the settlement agreement, and that continued right up until Dan Markel's death in 2014. A few months before the murder in 2014, Dan Markel alleged that the defendant, Donna Adelson, was disparaging him to his children. He was very worried about her trying to alienate him from his children. She was doing this by calling him stupid in front of the boys and telling the boys that Dan Markel was trying to take them away from her. Dan Markel asked the court to prevent this defendant from having unsupervised contact with her grandchildren. And this motion was still pending in court when Dan Markel was killed. And the murder of Dan Markel ensured that not having access to her grandchildren would never be a problem for this defendant. And what do you know? About 48 hours after Dan Markel was killed, after the shooting happened, Wendy Adelson and the little boys relocated to Miami, moved into the defendant's home with her, and the boys started school down the street. And just like that, their father was effectively erased from their lives, and the Adelsons' big problem had been solved. You'll hear during this trial that the Adelson family is a very tight-knit family. The defendant, her son Charlie Adelson, and her husband Harvey Adelson actually all worked together at their family's dental practice. The defendant, Harvey Adelson and Charlie Adelson are dentists there, and the defendant managed their accounts at the office. She was the details person. And this defendant, though, she managed much more than just the office for the Adelson family. She was the matriarch, and a domineering one at that. She ran the office, the home, and the lives of the Adelson family members. After Dan Markel was killed, law enforcement interviewed Wendy Adelson. Wendy Adelson told police, and the police confirmed this, that she was at home having her TV fixed, at her home in Tallahassee, having her TV fixed at the time of Dan Markel's murder. And when police asked her, well, do you know anyone who would have a motive to kill Dan Markel? Wendy Adelson acknowledged that her family had a motive to want Dan Markel dead, and said that her parents had more reason to dislike Dan Markel than anybody else. At one point in the interview, police allowed Wendy Adelson to make a phone call to her parents to let them know that Dan Markel had been shot. And after she got off the phone with her mother, the defendant, Wendy Adelson said to police, well, they acted surprised, so that's a relief. And when asked by law enforcement if anyone could have killed Dan Markel on her behalf, she also told the police about her brother, Charlie Adelson. Wendy admitted to police that her brother, Charlie Adelson, had joked that he looked into hiring a hitman to kill Dan Markel as a divorce present, but decided to buy her a TV instead because it was cheaper. And what do you know? The same TV that Charlie Adelson bought his sister as a divorce gift would be Wendy Adelson's alibi the morning of the murder. An alibi, the TV repair appointment that was set up by her parents, Harvey Adelson and Donna Adelson, the defendant. So this path of looking into Dan Markel's personal life to see who would have motive to kill him leads law enforcement to the Adelsons, including this defendant, a woman who vowed to never, 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 never give up on getting her daughter and grandsons to Miami, and her son, Charlie Adelson, who told his family that he'd looked into hiring a hitman to kill Dan Markel, as Wendy said, was just a joke. But if Charlie Adelson was just joking about hiring a hitman, that joke, that stopped being funny when Dan Markel was actually killed by a hitman. While the police are trying to investigate motive, they are simultaneously following that second path of the investigation by tracking down that light-colored Prius the neighbor saw fleeing from the scene. When law enforcement retraced Dan Markel's steps on the morning of his murder, they uncovered some very chilling surveillance video of that light-colored Prius fitting the description given by the neighbor, following Dan Markel into the Premier Gym parking lot and waiting for an hour while he was inside, and then following him home from Premier Gym back to Benton Hills. And these surveillance images, coupled with a massive amount of phone and SunPass records gathered in this case, help police track down the exact car used to commit this crime. But police still had to figure out, okay, we got the car, but who was in this car? And why did that person kill Dan Markel? So law enforcement did a painstaking review of digital evidence in this case. And when I say painstaking, finding this Prius and finding evidence in these phone records was not an easy task. And it took much longer than your average investigation of a shooting, as you'll hear. But law enforcement eventually found that needle in the haystack. They found a number that communicated with the cell tower that services Premier Gym at the exact time when the Prius was there. And it was a number with a Miami area code. And that number belonged to a man named Sigfredo Garcia. Law enforcement examined Garcia's call logs and they saw that he was in frequent contact with another number that was present at Premier Gym that day. And that number belonged to a man named Luis Rivera, who is a longtime friend of Garcia, and he's also from Miami. They both are. Police then looked at Garcia and Rivera's phone records, which showed that their phones left Miami 2 days before the murder, so July 16th. They came to Tallahassee, and on the day of the murder, on the 18th, they followed Markel to Premier Gym. The phone data shows that these men turned their phones off just minutes before the murder took place, and their phones then stayed off for about an hour or so after the murder until they were well southbound to Miami. I think around the Gainesville area, the phones turned back on. And then once they got back to Miami, a bank's ATM camera caught them in the light colored Prius at a bank drive-through and caught both of the men in the Prius. So police figured out the identity of the two men responsible for following and killing Dan Markel. But they continued to look for evidence to explain why these seemingly random men came all the way to came all the way to Tallahassee to kill a man that they'd never met. What or who is the connection between the killers and the victim? The defendant in her emails obviously had demonstrated ample motive to want Dan Markel dead, but how do we get from these two random and hired killers to her? Well, those phone records that I talked about, they revealed that one of the shooter, Garcia's, most frequent contacts was a woman named Catherine Magbanois. She goes by Katie. The shooter and Magbanois have a long history of an on-again, off-again relationship, and they share 2 kids in common. This is Garcia and Magbanois. And lo and behold, these 2 paths of the shooter's car and the motive, they converge when law enforcement sees that Catherine Magbanois is also one of the most frequent contacts in the phone records of Charlie Adelson, the defendant's son, the same son that she had been nagging to death about his sister being stuck in Tallahassee. Law enforcement also learned that at the time of this murder, Catherine Magbanois was dating Charlie Adelson. So Dan Markel was a problem the defendant needed to solve. The defendant's son, Charlie Adelson, was looking to hire a hitman to kill Dan Markel. Dan Markel is killed by a hitman. And who ended up being the hitman? The hitman that killed Dan Markel? Someone with a close relationship to Charlie Adelson's girlfriend, the father of her children. So you can see how both paths, followed by investigators, charted the way to this defendant. Not only by looking into the motive, led law enforcement to the defendant because of her hatred of Dan Markel and her son's apparent efforts to hire someone to kill him, but also looking into that car fleeing the scene led law enforcement to the defendant through her son's girlfriend at the time. So 2 investigations, 1 conclusion. Law enforcement also tried to follow the money in this case, and that was a 3rd way that the evidence in this case pointed to the defendant. Law enforcement reviewed bank records, employment records, DHS-MV records of all the suspects, and saw that in the months after the homicide, Garcia, Rivera, and Magbanois all acquired some big-ticket items. Rivera and Garcia both bought motorcycles and cars. Magbanois got a breast augmentation surgery and later received a black Lexus sedan whose previous owner was Harvey Adelson. Catherine Magbanois's bank records were analyzed, and there was no check ever written or matching cash withdrawal for the car or the breast augmentation. Bank records also showed that Magbanois's account had a huge spike in cash deposits around the time of the murder. She deposited more money in her account in the 5 weeks after the murder than in the entire year before the murder. And this was during a time when there was no record of her being employed anywhere. And also, about 2 months after the murder, this defendant added Catherine McBanois to the payroll at the Adelson family's dental practice, the one that she kept the accounts for, the defendant kept the accounts for. And the defendant started issuing her regular checks from their business account every 2 weeks, despite the fact that she did not work there at the time. McBanois didn't work there. Law enforcement noticed that each one of the 44 checks that were written to Catherine McBanois every 2 weeks over the course of the next 2 years after the murder were signed by this defendant, Donna Adelson. So the money was talking, but what about the suspects? Law enforcement wanted to know what they were saying. In examining the phone records in this case, law enforcement noticed a distinct pattern of communication surrounding important events, or dates in this case. The phone calls always went from this defendant to her son, Charlie Adelson, and then from her son, Charlie Adelson, to his girlfriend, Catherine McBanois, and then from his girlfriend, Catherine McBanois, to the shooter, Garcia, and then back the other way, like train cars. They only seem to touch the car directly in front and directly behind them. The defendant never calls her son's girlfriend, Catherine McBanois, or the shooter, or vice versa. Charlie Adelson never calls the shooter, or vice versa. So, if this is a murder for hire conspiracy, as law enforcement suspects, could it be that the defendant and Charlie Adelson are wisely insulating themselves from the actual shooters by having McBanois act as the middleman? Law enforcement decided to launch an undercover operation designed to clarify who are the members of this conspiracy and how information was traveling within the conspiracy. Police applied for and received court authorization to listen in real time to the phone calls of Charlie Adelson and Catherine McBanois, the people in the middle of this train car. And this is what's known as a wiretap. By this point, though, it was April of 2016. It took about 2 years to do this investigation to find out who was in the car and to get this wiretap going. So at this point, it's been 2 years, almost 2 years, since the murder. And at this point, in April of 2016, Charlie Adelson and McBanois are no longer dating. They've been broken up for over a year. Catherine McBanois at this point is actually back together with Garcia. We heard they're on again, off again, and have these kids together. Charlie Adelson has moved on he's had many other girlfriends at that point since McBanois. And Charlie Adelson and McBanois, though, they are still friends. They remain close friends since their breakup, and they're still in regular communication by April of 2016, even though they're not together anymore. Rivera, the second hitman in that Prius, was in prison by this point, doing time on an unrelated charge. And the defendant is happily taking care of her grandkids all day, every day. So all the members of this conspiracy have presumably gone on with their lives, believing they've gotten away with murder. So what reason would they have to be discussing the murder at that point if police are listening in? They wouldn't. So police needed to stage an event that would generate some conversation, some activity between the members of the conspiracy so they could see who the members of the conspiracy were. Their plan was to send an undercover agent posing as someone on behalf of Luis Rivera. He was the hitman who was incarcerated by April of 2016, to walk up to the defendant, Donna Adelson, on the street. There's a fly right in front of me. It won't leave me alone. To walk up to Donna Adelson on the street and try to blackmail her for money. Law enforcement refers to this as a bump. So this undercover agent posing as a blackmailer, and this is an actual picture from the surveillance cameras, that this is the undercover agent passing a piece of paper to Donna Adelson back in 2016. This undercover agent is posing as a blackmailer. He hands the defendant a piece of paper, and on the piece of paper is a news article about Dan Markel's murder. And written on the piece of paper is a phone number and the amount of $5,000. He tells the defendant that he knows the Adelsons are taking care of Katie, and he's basically there to blackmail to get more money out of them or out of her on Rivera's behalf, to even things out, because he knows they're taking care of Katie. He never says Charlie Adelson's name or anything about Charlie Adelson to Donna Adelson. The defendant then puts the piece of paper in her purse and walks away without ever looking at the piece of paper, because she knew exactly what it was about. Then law enforcement listens in to see what will happen next. Will the defendant go straight to the police to report the blackmail, or will she do something else entirely? And as suspected, based on the previously observed communication pattern, the first person that this defendant calls is Charlie Adelson, despite the fact that the blackmailer never mentioned Charlie Adelson to her. On that first call, you would think the first thing that Donna Adelson would say to Charlie Adelson is, "Oh my God, so crazy. Some man just came up to me, handed me an article about Danny's murder, and he's demanding money from us." But she never says any of that. In fact, the defendant never says Dan Markel's name at all. Instead, she tells Charlie Adelson that she needs to talk to him in person about some paperwork that was just delivered to her. She said that it involves the two of us, and that he should know what she's talking about. The defendant and Charlie Adelson continue talking, and she says that he should bring cash to their meeting. And she says, the TV is probably about 5. The defendant tells Charlie Adelson that the man who approached her mentioned an ex-girlfriend. The defendant never says which ex-girlfriend of Charlie Adelson. She never says Magbanwa's name to Charlie Adelson in that phone call. She only says that the blackmailer mentioned an ex-girlfriend. Charlie Adelson never asked his mom, "My ex-girlfriend? Which ex-girlfriend?" He's had a lot. He never asked that, because as the evidence will show, he didn't need to. He knew the TV is probably 5 meant that she was being blackmailed about Danny's murder, where the TV was the alibi, and he knew that the ex-girlfriend in question was the only ex-girlfriend that he had solicited to find a hitman for him, Catherine Magbanwa. And we know that because after this call with his mother, the defendant, Charlie Adelson, calls Catherine Magbanwa. He does not call his most recent ex-girlfriend or even the one before that. He calls Catherine Magbanwa. And his call to Catherine Magbanwa is the only call he makes to any ex-girlfriend after getting the information from his mother that the blackmailer mentioned an ex-girlfriend. And he hadn't dated her for about 1.5 years at that point. And although they threatened to do it very often, neither Charlie Adelson nor the defendant ever reported this attempted blackmail to the police. You all will hear the calls between the conspirators, and as you listen to these, you'll notice that they're being very cautious about what they say. It's apparent that they're being very careful about the words they use because they are all immediately suspicious that law enforcement could be behind the bump. Law enforcement could be the person who came up to them on the street and gave her the paperwork. And law enforcement could also be listening to their conversations. After Charlie Adelson's first call to Catherine McVanois, Charlie Adelson then meets up in person with his mother, the defendant. And in person, she gives him the paperwork that this blackmailer gave to her and makes it Charlie Adelson's newest problem to solve. And naturally, what does Charlie Adelson do? He goes to the next train car, Catherine McVanois. Charlie Adelson and Catherine McVanois meet in person at a restaurant called Dolce Vita in Miami. And while they sit at their table in this busy, noisy restaurant, an undercover FBI agent is sitting at a table nearby with a camera hidden in a bag, recording the conversation. So this is an image from that video recording the conversation. And in the recording, we hear Charlie Adelson discussing whether the man who walked up to his mother could be an undercover police officer, or he could be someone trying to legitimately blackmail them. And if it's a blackmailer, is it somebody who just saw a way to make a quick buck? Or is it another situation entirely, which would be much worse for the Adelsons? Is it actually someone with inside information about Donna Adelson's role in the murder of Dan Markel? And that person could tell police what they know. Charlie Adelson reassures Katie, Catherine McVanois, that if it is the police, that is a good thing. Charlie Adelson thinks that, hey, if it's the police, that means the police don't have enough evidence to charge anybody. You know, they're just fishing for information. And in fact, Charlie Adelson tells her, hey, if they had any evidence, we would have already gone to the airport. It's important to note that at the time of this conversation at Dolce Vita, no arrests had been made in this case. And the only thing that police had released to the public at that point was a photo of the light-colored Prius that fled the scene. Police knew at that point that it was Garcia and Rivera who were in the Prius, but the public didn't know that yet. So that fact is interesting in light of some of the things that Charlie Adelson started saying to McVanois. He starts giving her several analogies involving rental cars being used to commit crimes. He reassures her that the police can't prove a person committed a crime just from someone's DNA being in a car that was used in a crime. In order to prove someone committed a crime, you have to be able to put the person at the scene of the crime at the time it was committed. So he's trying to reassure her that even if they identify who rented that car that fled the scene, they still would not have enough evidence to hold anybody responsible for this murder. Charlie Adelson also says that crimes are tough to prove unless someone actually witnessed the suspect commit the crime, or the suspect confesses to the crime, or a suspect is caught on a wire talking about the crime. So he's trying to reassure her about the lack of evidence in this case, about no witnesses, and trying to let her know that, hey, as long as we all stay quiet and nobody confesses or gets caught talking on a wire, then we don't have anything to worry about. And he begins educating Catherine McVanois about how blackmail works. He tells her that, hey, if this is a guy who knows information, there's two ways of dealing with this guy. You know, we could call the police, but then the guy blackmailing us could be charged, and then that blackmailer is going to start talking, and the police are going to be asking questions about what happened. The other option is to pay the blackmailer, but let him know that this is just a one-time thing. And we'll try to scare him off by saying, if you come around again, we'll go to the police. Charlie Adelson gives McVanois very precise instructions on how to deal with the blackmailer. He tells her to call the blackmailer and tell her that my friends meaning the Adelson family, have no idea what you're talking about. And I'm just going to give you this money as charity, but don't contact these people again or they'll go to the police. And Charlie Adelson said he would give Magbanua the $5,000 to pay off the blackmailer who approached his mother, except that he's concerned that this guy won't go away. He'll get that $5,000 and then he'll just keep coming back for more money. We'll see him as an easy target. And so Charlie Adelson then offers that the best solution might be to have the blackmailer killed and that he's willing to pay whatever it takes. He says, "So help me God, if they F with my family, it's going to be Nazi shit because this will be done. I mean, Katie, I don't care what I spend." And after hearing that Charlie Adelson wants someone killed and is willing to pay whatever it takes to get it done, Magbanua then asks Charlie Adelson to help her out. And Charlie Adelson reassures her she'll be taken care of and reminds her she's on salary at the parents' dental practice. After Charlie Adelson finishes this meeting where he's getting Magbanua to then solve the problem of the blackmailer, he gives her they say goodbye. He gives her a big hug that's captured on camera outside by the FBI. And then Charlie Adelson immediately calls the defendant to let her know everything's fine and he has handled the situation. He does this using some pretty obvious code words that you'll often hear these conspirators use to mask the meaning of what they're talking about in case law enforcement's listening. Magbanua then, also using code words, calls Garcia, and she tasks him with calling the number on their paperwork and finding the identity of the blackmailer. And in the series of recorded calls that y'all are going to hear later this week, you'll hear these conspirators talking and using words like TV, relationship advice, false leads, listings, patients, properties, clients, rap songs, CDs, pigs, all these terms that are obviously normal words, but they're used in context that if you're listening to the conversation don't make sense. So after that undercover operation was over in 2016, Luis Rivera and Sigfredo Garcia are arrested, and they're charged with the same charges before y'all on this trial. Luis Rivera, who was the second person in that Prius, cut a deal with the state and told law enforcement the truth about the murder of Dan Markel and the people responsible for it. He told police that he was hired by his longtime friend Garcia to help kill Dan Markel. Rivera described how Garcia told him that this was a job that Magbanua was able to get for them, and it was in Tallahassee, and it paid $100,000, and that Rivera was going to get a third of the money. Rivera said that during the trip to Tallahassee, Garcia had a piece of paper with a picture of the man that they were hired to kill and some handwritten notes. And during that trip, Rivera said that the first call that either of them made after the homicide was from Garcia to Magbanua, where Garcia told her that the job was done and Magbanua assured them they would get their money the next day, which they did. That Magbanua brought the money the next morning to Rivera's home. And law enforcement checked cell phone records, which corroborated Rivera's information. Law enforcement told police that the money that he received from Magbanua the next day was packaged in a very unusual way. The money was basically in stacks of 1,000. Each stack was made up of $100 bills that were then stapled together. And after each stack was stapled together of 1,000. And after learning this from Rivera, Magbanua was arrested, and that was in October of 2016. During this trial, you'll hear that the Adelson family had access to a lot of cash because their family gave cash discounts at their dental practice. Like if you paid in cash, you would have to pay less than if you paid on a card or check. And they kept the cash that they received in stacks, and they stored it in a safe. Law enforcement also learned from Charlie Adelson's friends that Charlie Adelson had a very unusual practice of keeping his money in these $1,000 stacks that were stapled together, just like the money Rivera received. And over the last few years, since the 2016 arrests of Garcia and Rivera in May, and then of Magbanua in October 2016, law enforcement has not stopped working on this case. 3 years after Garcia's arrest in 2019, he was convicted at his trial. Law enforcement continue, though, to gather evidence. They continue to interview people who may possibly have information and to clarify all of these recordings the FBI did that couldn't be clearly heard. And thanks to their tireless efforts, in March of 2022, Charlie Adelson was indicted. 2 months later, in May of 2022, Catherine Magbanua's case went to trial, and she was convicted. During Magbanua's trial, Catherine Magbanua took the stand, and she insisted, this is back in May of 22, she insisted she had no knowledge of the murder. The Adelsons must have just gone around her to hire the hitman directly. That's what she testified to. Her defense team insisted that the state's theory was correct about every co-conspirator except for her, for Catherine Magbanua. That Catherine Magbanua was just this victim of bloodthirsty and desperate prosecutors and investigators, and just a victim of this set of circumstances that appeared to prove one thing, but was actually, the truth was something else entirely. However, after being convicted at trial and sentenced, Magbanua finally decided to testify about the plot to kill Dan Markel and admitted that she was the connection between the Adelson family and the killers hired to kill Dan Markel. Magbanua testified in Charlie Adelson's trial in October of 2023 and said that Charlie Adelson wanted to hire someone to kill his sister's ex because his mom was stressed out over all of the problems his sister was having with her ex-husband. Magbanua said Charlie painted a picture that Wendy's ex was this terrible man causing his mom so much stress that she couldn't sleep or eat. Magbanua agreed to help him and ended up recruiting her children's father, Garcia, and also Rivera to kill Dan Markel. She says that the night of the murder, she went to Charlie Adelson's house to pick up the payment for the murder. And when she arrived, Charlie Adelson said that his parents had just been at the house and that Charlie Adelson had the money for her there. Law enforcement was able to corroborate this claim with phone evidence showing that Donna Adelson went to Charlie Adelson's house the night of the murder. Magbanua then spent the night with Charlie Adelson that night, and the next morning, on July 19th, he put the money that she was to divide up into the trunk of her car. Magbanua says several things about the money stood out to her. She said it was stapled together in stacks of $100 bills and that it was damp like wet. She then delivered the money to Garcia and Rivera afterwards. When Catherine Magbanua said that when she asked Charlie Adelson about the money being damp, he said that his mother the defendant had actually washed the money, and that she and Charlie Adelson kind of laughed about the fact that the defendant had literally washed the money so it couldn't be traced. In Charlie Adelson's trial, Charlie Adelson took the stand, and he testified that Magbanua, Garcia, and Rivera were all in on this crime together, but that the Adelsons had nothing to do with it. They were the innocent ones. He crafted an elaborate story in which Garcia and Rivera came to Tallahassee on their own, killed Dan Markel without his knowledge or his family's knowledge, and then these killers colluded with Magbanua to play he and his mother for fools and extort money out of them. And for many reasons, which will be revealed to y'all in this trial, Charlie's interpretation of the facts was not reasonable to believe, and he was convicted. Charlie Adelson was convicted in November of 2023. And within hours of his guilty verdict, this defendant began to plan to flee the United States to a country that she could not be extradited from in order to avoid being arrested for Dan Markel's murder. The defendant on her phone researched countries that did not have extradition treaties with the United States, and she applied for an emergency visa to Vietnam. She was overheard planning to put her money in trust for her grandchildren, and she and her husband purchased one-way tickets with a fast-track emergency visa to Vietnam. And Vietnam does not have an extradition treaty with the US, as she would have learned from her searches. And just days later, she was stopped by law enforcement on the jetway in Miami International Airport, where she was boarding her one-way flight to Vietnam, and she was then charged for her participation in the murder of Dan Markel. After the defendant was charged, law enforcement received information from women who said that the defendant, Donna Adelson, was offering them bribes in exchange for false testimony in this trial. They said Donna Adelson promised them money, housing, veneers, prescription drugs, if they were willing to testify that Catherine McBanois told them a completely different story about the crime than the one that she would be testifying to. One informant was even able to show law enforcement a script, a question and answer session for a direct examination in trial that Donna Adelson herself wrote, and that Donna Adelson wanted this informant to memorize and come into court and perjure herself by reciting it to you here in trial. Please listen to all of the evidence that y'all are going to see and hear in this trial. I know it's been a long week already, and we have a lot of evidence for you in this case, but when you do, you will see that this defendant conspired with her son, Charlie Adelson, who solicited his girlfriend, Catherine McBanois, to get this murder done. And then this defendant paid her with cash, with checks for the job once it was completed. The defendant acted in furtherance of this murder plot that went beyond just thinking about it or just talking about it. And these acts make her guilty as a principal to first-degree murder, just as if she was the one pulling the trigger in the garage herself. And while the defendant's choices helped solve a problem within her family, they came at a very high price. She took the life of a loving father of 2 little boys and caused a lifetime of grief for Dan Markel's loved ones. And at the conclusion of the evidence in this case, you will be convinced beyond any reasonable doubt that this defendant is guilty. And at that point, we'll ask you for the only verdict that does justice in this case, which is a verdict that this defendant is guilty as charged. Thank you.
All right, briefly approach.
I kind of like that opening. That was a really nice, clear path opening statement compared to some of the stuff we've seen in the past. Other trials. What do y'all think about her opening statement? There's a few things I didn't even know about. Hello, Miss or Mr. Iced Coffee. Hello, Siba. Long time no see. Welcome to my channel, all you new people. Yanni Wine 33. Thank you. You are watching on Twitch. I appreciate you so much. Angela, thank you. Aaron E. Welcome to my mods. I got 3 fabulous mods on. I got June Tinkitude and K Swan. Thank you guys for all being here today. I know this has been a long wait. We've all been waiting for this trial to come in, so yay! Coffee and trials are the way to go. Be online, yeah. It is. I had to make me some eggs. I apologize, guys. I got up this morning and bolted and didn't have time to do anything.
Before the defense gives its opening statement, we are going to take a brief break. The bailiff will take you to the jury room.
Something has happened, y'all. Why are we taking a break? She's got the prison bra on. Look at that. Look. There's the prison bra. Or jail bra, actually. Yep. I did like her opening. Clear path, clear plan, clear, no confusion. How are y'all liking the graphics? Oh, I got some unread messages.
Gallery or the observers need to use the restroom, please do so at this point, so that way when the defense is ready, we can continue moving on seamlessly. We'll resume again at 10:20.
Okay, okay. So, which Florida county is this? I knew you were going to do that. Leon County. And by the way, I'm going to be throwing up jokes every once in a while. So if you guys have some fun jokes, let us know. Yeah, let's see if they can back that up. And yeah. So what, Angela, was new for you? What was something that you had not heard? Yep, coffee and crime goes together. Ain't that the truth? Yeah, very clean. You know, I think this year, out of all of the opening statements I have heard, I like hers the best. I really do. I like hers the best. I think that it is to the point. It's not too long. It wasn't about them showboating or loving to hear themselves talk. Get to the point. Tell us what you're going to provide for us and move on. I think sometimes lawyers put a lot of work in their opening statements, which they should. But I also think they go too deep, too far into the weeds. I'm sorry about snagging some eggs, but I took some medicine and my stomach wasn't very happy and I had to get something on it. The stapling, I think I heard yesterday about that. That is kind of weird. Tom Baker, hello. Yeah, I know, right, Tom? What a lovely family. What a lovely family. So, I had heard about the money laundering, literally washing the money. Now that's what caught my ear was the statement for somebody to memorize like as if they were being interrogated. I was like, that's unusual. That's not what I know it to be. That was strange. Kind of caught me off guard. Iced coffee you do. Well, wonderful. Please share information with us because do you know what? I wasn't doing this then. I was not following court cases like I am now back then. So I don't know very much about his case other than the review that we did. We did watch Wendy Adelson's testimony in the case, so that was good. Brussels, Belgium, welcome. We love our friends across the ocean. Yeah, just drop information if you want to, Iced Coffee. And Iced Coffee, where are you from? Yeah, that's true too. Very much true. Very much true. Very true. Yeah. We love our people. We really do. I love having people from all across the United States, but I also love having people from across the ocean. I'm going to center me a little differently. It's making me crazy. There you go. Yes, she was on the Wheel of Fortune. We watched that yesterday. I was like, all the Sarah Boone, Donna Adelson, Lori Vallow Daybell, all of them were on the Wheel of Fortune. What is it with all these crazy ladies? Ooh, the crazy ladies. Yes. You're on Discord. Where do you live? What state? What state do you live? Yeah, it was, Iowa. Iowa. I had a friend from Iowa. They moved to New Mexico, but they were in Iowa. Yeah. There's a lot of these people on game shows. I guess if you're a narcissist, you love yourself that much, you want to see yourself live on TV, I guess. I don't know. Yeah. And by the way, for those of you who are just joining, I'm AdaKay. This is your first time here. Thank you so much for joining. Share a little bit about myself. I grew up hearing. I've become deaf as I've gotten old. I am fully deaf without my hearing aids. If you see me just start signing real fast, scoot back and sign, it's because I have a deaf person that's popped into the chat. You followed the Karen Reed trial with us? You looked familiar. But welcome back. Welcome back. You're the one who challenges me. Iced coffee. I thought that was you. Yes, I like to be challenged as long as it's respectful. Challenge me all you want. Who knows? We may be on the same side. In Britain, there was a bull-eye game show, and one serial red rummer won it. Oh, that is so funny. That is hilarious. That's funny. I love it. I love it. I love it. I love it. Well, it's kind of interesting. The Karen Reed trial, everybody was about innocent or guilt. And do I believe that she was guilty of drinking and driving? Yes. Do I believe all of them were? Yes. But June and I had a good, deep conversation, and I agree with June. Just because, hello, it's Breed. Hello, I'm sorry, I haven't been here much. I'm just going through it. Well, thank you so much. And I don't know why we're getting this wheel of proverbial wheel. Why is this? There we go. So anyway, what I was going to say is that we June and I had discussed this. A lot of people think if you've been found not guilty, that means you're innocent. And in fact, that's not true. I think a lot of it was. But did the state prove beyond a reasonable doubt that she is guilty versus being innocent are two totally different things. There's so many scenarios that could have happened that night that she could have been involved in or could not have been involved in. And in that, we will never know. But do I believe the state proved beyond all reasonable doubt that she did this? Absolutely not. And that's where I was standing. Um, I believe everybody at that bar and party that night should all be charged with drinking and driving because they admitted to it. And then the homeowner, Albert, should be charged with providing alcohol to minors because they had a party with a bunch of minors and a bunch of alcohol was involved. And they all admitted to drinking because they weren't going to be charged. So anyway, just because you're found not guilty does not mean you were innocent. It just means there was not enough evidence to convict. And that's where I stand. And June and I had a healthy discussion about that, and I'm glad we did, because that is something that I think a lot of us forget. Innocence is hard. It's hard, to prove. Unlike if you had a video that proved that you were standing with your boyfriend in a gas station, your boyfriend's the one that pulled the weapon and shot the sales clerk, and both of you run out and you get charged with doing it. Well, the video is going to prove you innocent. That's a rarity. Hello, it's Brit. Yes, she is from Britain. She's English. She's my Brit. I always give it a little Brit. I always have fun with names. I do. And guys, it's kind of weird. I'm looking at some jokes. I like to tell jokes. So I'm going to throw up a joke right now. It's a stupid one. JMO, welcome. I like watching a video to see if I can understand the signing. I have taken a few classes and fallen in love. Unfortunately, I don't have any place to practice and hone the skill. Well, thank you so much. I probably will be interpreting shortly. I know a deaf person will be hopping in today. I have sent a little shout out to my interpreter who's been dealing with a lot. Her sister has been gravely ill, survived what we call a widow's maker's heart attack, which is rare to survive. And then her kidneys shut down. So she's been a little busy, but I will be interpreting. If you see me throw my hands up, that's because a deaf person, they don't usually, I'll be honest, they don't necessarily pop in YouTube, but they do watch on Twitch or X. And I have viewers from both places today, as well as YouTube. I wanted to do Facebook, but the problem is when I do Facebook, it doesn't do live anymore. But welcome. We love to have you. Thank you so very much for joining. We are in a small courtroom break. So while we're in break, let's go ahead and go over to the Wolfenberger trial just for a moment. Don't panic and kind of watch what's going on there. We're finishing up with this trial. So let me put a little stream disclosure up. Okay.
General understanding is that the sheriff's department prefers to have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters?
Okay, y'all, we're going to pause here because they're coming back already. But when we have a break, we're going to watch the witness in the Wolfenberger trial because guess what? The witness that refused to show up in court that was brought from out of state via a sheriff department is in court today. So if this is not one of those bang up witnesses that's going to drop a lot of craziness on us, then honey boo, we going to have a problem because the last two have been duds. Yes, the hostile witness is there and they look like a hostile witness. Good morning. No, I don't know about the John Cooper case. Do I? I have to look. Yes, the witness is on the stand. Already probably taken the stand because I have it on pause. Yes, we need to get this closed. I mean, everything was delayed because of this witness, which to me was just asinine. And Donna Adelson is wearing headphones now, which she has not in any of the other hearings or trials. We are waiting for the jury to arrive. I can't wait to see her spill the beans. Well, let's see what beans she does spill, if there is any beans to spill. That's the key question. Yes, Nightbot, please leave your DNA, give a thumbs up, keep the channel growing, subscribe, and click the bell so you never miss when the stream is live. Also, put the comment ILIKED in there for a chance to be entered into the giveaway. Do it just like that. At the end of the month, we do have a giveaway, and it's free merch. And I just purchase it and ship it directly to you. If you are over the pond, then I will do an Amazon gift card, or other gift cards of your choice that I can purchase online and email to you. Thank you, Angela. Same with I shared. If you shared, put I shared. If you're new here and sub for the first time, put I sub. I'll show you. And just like that, put I sub. If you are new here and you have subbed with us, thank you so much for your sub. I love subs, and we appreciate you being here. So they are waiting to bring in the jury, and my mouse is getting a little mousy. Let's see if it will catch up. There we go. So we're going to have exhibits. Look at the easel. Oh, iced coffee. Would you like to share it? I'd love to see it. Yes. Can you send it in Discord? Oh, thank you so much. And I will give you credit if I put it up on live. Don't worry about that. The officer is obviously having a little chat with somebody. PowerPoint is great. I do PowerPoints, so can do. I did answer you, Mandy, in Discord. I am wrapping myself today in a bunch of, by the way, I want to say this. For all of you who have really loved on me since November with the loss of my sister, the loss of a relationship that I had, and the loss of my service dog who died, and then recently, a month ago, the loss of my brother-in-law, it has been a very, very, very stressful few months. I want to say thank you so much for all your well wishes, your prayers, and support. And it has been a difficult journey. We are moving my studio out of the office and into my home, hopefully this weekend, which I'm scared to death to do because I don't want anything to break, and I want to be able to reconnect and everything and it work. Because Monday we back live. I'll come back here if I have to. But anyway, I'm going to be leaving my little fabulous room that I have created and I love so much. I will be grieving the loss of my room, but I'm accepting the new changes, and it's going to be lighter. There's 4 windows in the room. This has no windows. Their sound is turned off on their end. Well, it does have a window, but it's hidden behind me. So, for me, it is going to be a huge change, but a happy one. Happy changes. Happy change.
Defense prepared.
I'm looking forward to being able to not have to travel to work and roll out of bed. That means I can get a little extra sleep. I get to I'll get to bring my monkey on sometimes. I'll be able to, hey, y'all, look at Nala. We'll have our little Nala, our mascot, on live with us sometimes, and I'll be able to let her, I'll be around my baby girl more. For those who don't know, I have a capuchin monkey, and I'll be able to be home more, and she won't be alone as much. So yeah, there's going to be a lot of great things. It's just that packing everything up and moving is like, All right, here we go.
To give its opening statement at this time. Yes, Judge. You may proceed.
Thank you. Your Honor, counsel. Good morning.
She is, by the way, she has been wrenching in pain. When she's sitting there, she's moved, she's done this a few times. It looks like by her hands, I can tell she has arthritis. I'm presuming it's arthritis because of the way her hands look. But she has not been walking well, so I don't know what's up with her.
Jackie Fulford and I, along with Mr. Zellman, represent Mrs. Adelson, and I don't think you've heard my voice yet. Well, I'm going to try and talk slow because if I don't, the court reporter is going to scream at me. I just want to start by saying this. Remember, during the course of the proceedings, that the state always gets to go first, but the defense has a right to be heard too. So please keep an open mind until you hear from us as well. You just sat.
Yep, she's got arthritis.
The presentation was pretty cool. I'm old fashioned, so I don't use that kind of stuff, but for an hour you heard about this killing. And we're going to talk about that in a minute. And you heard an awful lot about why they think Donna Adelson has the motive to kill Danny Markel. And you heard an awful lot about what other people did in this case. But not a single piece of evidence was discussed that shows that Donna Adelson planned this, hired anybody to do this, or intended that this happen. And I just want you to be mindful that when we're at the end of the case and the judge gives you the instructions, and he gives them, I won't do that. When he gives you the instructions, he's not going to give you an instruction that says the state has to prove motive. He's going to give you elements of each offense, and he's going to say that each element of each offense has to have actual evidence to prove that. Not motive, actual evidence that those things happened. We're going to have a long trial, and I know you all are kind of prepared for that, at least in your mind. You know it's going to happen, and it's going to be long, and we're going to have days. And you're going to hear a lot of evidence and phone calls and text messages and emails. But I want to ask you to never, ever stop thinking for the 2 weeks or 2.5 weeks that we're here about why it is we are really here. Not just because Donna Adelson is on trial, but because 2 men killed Danny Markel. Don't forget Danny. He was an amazing professor. He was very well educated. He had 2 degrees, I think, from Harvard, one of them from law school there. He was a professor. He had students. He was very well respected by his peers, his colleagues. He traveled all over the place to talk at conferences. They wanted him there for him to come and speak. Very, very intelligent man. And I can't say I know because I never met him. I wish I had. But I know he had to be proud of all that he had achieved. It was his career was important to him. Him continuing to educate himself so that he could get tenure at the law school as a professor. He worked very hard. He earned a lot. What he did not earn was for somebody to do this to him.
Okay, guys, I see that you're talking about the court being low. I cannot gain it up any more than what it is. This has been a problem that we have. Let me see what I can do. Hold on. This has been, I'm going to put everything up and then adjust it because here's the problem. We have a super low microphone feed from the court. Super, super low. I'm working on it. And on top of that, you have an AC and you have static, and each mic is different. So I'm working on it. But we have captioning.
You're going to hear that Wendy Adelson.
Okay, that is the normal sound right there. It is difficult to listen to. Just FYI. I have taken away everything and just put it back to normal. This is, I'm going to guard your ears. Everybody, guard your ears. This is their raw feed. I'm trying to take out all the air and the static. So listen carefully, guard your ears.
The daughter of my client was married to Danny. And I'm not trying to be informal when I say that. I respect Mr. Markel.
Okay, that's the fixed. I'm sorry. That's the fixed.
Dr. Markel. But because so many people in the trial are going to refer to him as Danny, I'm going to do that if that's okay. But I don't mean any disrespect by doing that. More important to Danny Markel than anything in the world were his little boys. He had 2 little children when this happened to him, a 3-year-old and a 4-year-old. When the divorce first happened, when Wendy moved out, he did not want the divorce. That was in 2012. And they squabbled during the divorce. They did. Each side argued for their side. The other side argued for their side. That's what happens to divorce. Divorce is not fun. Divorce is not usually friendly. Some of us have had friendly divorces, but not everybody does. And a lot of things were said. But moving forward to 2014 is where we're going to concentrate on, because that's when Danny was killed. And in 2014, with these little boys that he had, the divorce had been over for a year. Relocation, the opportunity, even discussion about it, ended. On July 31st, when the final judgment was entered, relocation was over. The state told you that. The court denied it with prejudice. She could never raise it again. Nobody was fighting anymore about where these little boys would be. Danny.
No spoilers.
For not only.
No spoilers. Hi, it's not real. No spoilers, please. We're going to watch it during break. Thank you. And guys, let me know about the sound. I have gained it. I've done everything I can. This is, I just pushed 100%. I just pushed 100% across the board through the computer, through their program, through my soundboard, and through a booster.
Himself
Can't do anymore.
In the divorce, he advocated for his children. They are an important part of his life. He wanted as much time as he could get with them. They ended up splitting the time equally between Wendy and Danny. Their schedules changed a little bit on how they worked that out, but it was 50%. This bug is driving me crazy too. What in the world is that? Sorry. He continuously, from the time Wendy moved out till the time that he was killed, spent as much time as he could get with his children. He loved being with them. If it wasn't his time to have the children, he would go to their little preschool and spend time with them there. He wanted to talk to them on the phone as much as he could. You guys are way younger than me, so maybe you don't even know about this, but I guess there was a thing called Skype. I don't even know if it still exists, but I guess it's like FaceTiming, but doing it on your computer. And that's how he wanted to talk to his kids, so that he could see them when he wasn't with them while he spoke to them. Now, at 3 and 4, it's kind of hard to wrangle them to sit down in front of a screen. So Danny came up with a really good idea. When he Skyped the children, it would be most of the time after the kids had had their dinner and had their baths, where they're kind of calmed down. They're not in their little running around state. And he would read bedtime stories to them. And he didn't have his little kids. He still wanted to know that when the children went to bed, they didn't forget about Daddy. And he made sure that didn't happen. These kids are not deprived of their father. Their father was brutally taken from them. Not just when they were 3 or 4, or 5 or 6, or 7 or 8, but up into their teens. They lost the opportunity because someone took it from them to grow up with a father, to have his involvement and influence in their lives, to talk about what he did as a kid and share his experiences. All of that was stolen from him. That's very important. This Skyping that he did with his kids, Mrs. Adelson, when she had the little boys, actually arranged so she could do that with him. And she would keep the kids in front of the screen while he talked to his children. You've heard a lot about how she hated him. She said some ugly things during the divorce. Pretty foul things, actually. But you're going to learn through the evidence why that was occurring and how she was actually interacting with Danny. They're two very different things. I want to talk to you now about my client, Donna Adelson. She is a normal person, just like all of us. At the time that this happened, she was 64 years old, married to her husband, Dr. Adelson, a dentist. Now they've been married 54 years. It was somewhere in the 40-year range when this happened 11 years ago. And she got up in the morning and went to work, not at her and Harvey's business, like you were just told. She went to the business owned by her son. Every morning, they got up and they went to work. She did the books. She kept the books. She greeted patients. She got charts out. At 7:30 every morning, she was there and organized and had everybody ready to go because they had a little staff meeting. So everybody can know what to expect, what patients they were going to see, what they were going to take care of. She was there working, sometimes late into the evening, just like all of us. She's a normal person. People who know Donna
We'll see.
will tell you that she is not the person that the state is portraying her to be. She's kind, caring, loving. She cares more about people than she does about herself. Now, what happened on July the 18th of 2014? You've heard the state describe it, but I want to talk about it for a minute. The state is going to be able to prove to you some of the things they were talking about. Can everybody see it okay? No? Oh,
Clearly. Thank you.
thank you. Thank you. So the state told you that he got up every day, just like he normally did, on July the 18th of 2014. And I just want to say this also. Throughout the trial, you may hear me say that he was murdered on that date. somehow he survived for another 11 hours. But in my opinion, all the evidence is going to show that what killed him took place on the 18th, and he was just able to survive long enough into the next day. So on that date, July 18th of 2014, these two men, Sigfredo Garcia and Luis Rivera, followed Danny all over town. Started at his house, followed him to the school where the little children were going to school, the preschool where he dropped them off, watched him drop those kids off, followed him to the gym, waited outside the gym for him, followed him to his house, pulled up in the driveway. Mr. Markel is talking on the telephone to someone, and he notices someone's coming into his driveway. And while he's talking on the phone and says something about needing to see who this is, he turns and looks in the direction. And this man, Sigfredo Garcia, is holding a revolver. And he points it at him. And you may hear testimony that there's some evidence that maybe he tried to, well, you know what you do in defense when somebody's going to hit you or whatever, you put your hands up. He saw this man pointing a gun similar to this at him. And in that instant, I cannot fathom how terrified he must have been when this man shot him. Not one time, but twice. One of the shots is almost right between the eyes. He was brutally murdered by this man. This man, Luis Rivera, who you've heard them mention in the State's opening, traveled with this car. This is an actual picture of the car, and the State's going to show it to you. This is the Prius that they were traveling in. This is surveillance photo that the investigators were able to find to know that it was a Prius that they were looking for. This man supplied the gun and drove the car following Danny, drove it up into the driveway less than 3 feet away from Mr. Markel, whose engine is still running, and he's on the phone, and he waits while this man kills him. He hears the shots. This guy, Mr. Garcia, runs back to the car where Mr. Rivera is in the driver's seat, and he's the getaway driver. Supplies the gun, knows what they're going there to do, kill him, and drive off. They drive off. The State can prove that about Sigfredo Garcia and Luis Rivera. But they're not on trial here, right? You heard they've already been on trial. Then you're going to hear, as the State said, that they can prove that, everybody can see okay? They can prove that Katie Magbanawah, her name's Catherine, some people call her Katie, they can prove that she's the one who set it up. This is the father of Katie's children. This is his buddy that was recruited to go along on this trip to kill Danny. They can prove that she arranged these guys to do it and that she's the one who paid them the money that was in stacks, stapled, $100 bills, all $100, well, there may have been something other than $100 bills, but each stack was $1,000, stapled together. And you're going to hear testimony that that's exactly what he did with his money. He kept it and saved it for a long time. And you're probably going to hear testimony that this happens on July 18th, and on July the 19th, Mr. Adelson, Charlie Adelson, which is her son, gave approximately between $130,000 and $138,000 that he had in his safe that he collected and stapled together. His money went to her, not Miss Adelson. They can prove and have that he paid her to get them to kill Danny Markel. That's what they can prove. And they've done it 1, 2, 3, 4 times. This case is really a lot about theory and motive and not evidence. The state has a theory, and for the past 9 to 11 years, in fairness, probably 9 years, they have told the whole world that Mrs. Adelson was the reason that this happened. Mrs. Adelson was the reason that this happened. They've told this story, and it's outrageous. It gets people's attention. It's made a lot of money for the media, interviews, specials. Some people in jury selection said they had watched these specials. Lawyers on there, investigators on there. They made a lot of money for the media, and it got big attention because this is outrageous, what happened. It is truly outrageous. But what's more outrageous is, without any evidence, only motive and theory, they put her at the top of this pyramid. She's the matriarch. She's the matriarch mastermind behind Danny being killed. And they don't have evidence of that. That's what's outrageous. It's outrageous that he got killed, but it's also outrageous that we're sitting here with a jury, and you're going to hear a lot of theory, a lot of motive, and a lot of what they believe the evidence means. They don't get to decide that. The evidence is what the evidence is, and I ask you to patiently sit here and really pay attention to all of the evidence that you hear, every witness that they put on, every piece of evidence that they present to you, all of it. Don't, for 1 second, I'm not asking you to ignore any of that. Please listen to all of it closely. Look for what they actually have as evidence that Mrs. Adelson planned. She planned Danny Markel's murder. That she engaged these men to kill him. And that she gave the money to her son to give to Katie to pay them. You won't find evidence of that. The evidence about the $3,000 a month, I have that here on this board, $3,000 a month. Charlie Adelson gave $2,000 a month, and he instructed his mother, for reasons you're going to learn in the trial, out of his business account to put her on payroll. She worked for him, and she paid that money. It's this man's money, not Donna Adelson. At the end of listening to all of the evidence, we're going to have an opportunity to make closing arguments. And the judge is then going to give you, well, he's going to give it before, he's going to give you all of the instructions on what it is that you have to decide. Did the state charge and then prove that Mrs. Adelson committed a conspiracy? Not one of the elements, all of the elements, proven by evidence, not theory, not motive. For each count, then solicitation, all the elements. So while you're listening to the evidence, you don't know what those elements are, but think about what each thing it is that the state has alleged. She planned it. She got people to do it. She intended that he die. That this woman wanted to take away the father of her grandchildren for the rest of their life because of relocation that happened a year ago and was done and over. And at the end of the case, because there's not going to be evidence that she did this, keep an open mind. Listen to all of it. We're going to ask you to find her not guilty of every single count. Thank you.
Of course you are.
Thank you, Ms. Fulford. Ms. Zeldin, if you could take down the easels at this time. Is the state prepared to call its first witness?
Okay, here we go, y'all. Dun 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 da 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 dun 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 da 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 dun dun dun. Witness one. I'm sorry, I'm in a mood. In the mood, ba-da. I am in the mood.
Yeah, reposition the lectern, Judge.
Husband. Oh, no, that's not husband. Sorry. Sort of looked like husband. He looks like. I'm sorry. Is this going to be the? I'm sorry.
Right hand to be sworn, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You may take your seat. Please speak loudly and clearly for the jurors.
Yes, sir. Perfect. Thank you. Please say your name and spell your name.
My name is James Geiger, Geiger.
Sir, where do you live?
I live at 2122 Trescott.
How long have you lived at that residence?
It's getting pretty close to 50 years now, I think 48 or 49.
All right. I want to take you back to July 18th of 2024. Now I've got an ad on me. Do you recall something unusual that happened that day? I'm sorry, I said 2024, 2014, sir. You know what case we're here about. Do you remember what happened on that date?
Yes, I do.
All right. Could you please tell our jurors how something unusual first got your attention?
It was a Friday morning, about 10:30. My wife and I were sitting in our living room looking out towards Trescott Drive out to the street. And as we were sitting there, we were doing something with our iPads, and we heard a noise, a popping, loud sound, bang sound. And we immediately got up and walked to the front. We have a big picture window, walked up to see if we could determine what had happened and where it had come from. We weren't sure it was to the right or to the left. And
all right, let me pause you right there and show you a couple photographs that I have as marked as states 1, 2, and 3.
okay.
Do you recognize these photographs?
Yes,
sir?
I do.
Are these fair and accurate photographs of your residence at that time, as well as the view from the window you've described?
Yes, it's true.
Judge, at this time, I ask to admit 1 through 3 and publish.
Any objection?
No objection, Your Honor.
Statements 1 through 3 are admitted.
If we could publish states 1.
There's a hum. Please tell me that's not the air con. Went away. We'll have to look into that.
All right, sir. So if you could just explain, give me that pointer, please. What we're looking at in this photo, and I've got a pointer here. If that's of any assistance to you, push the middle button, you get a red dot. You don't have to use it. Oh, if you are going to use it, though, use it on the big screen, please, sir. All right, so just describe what we're looking at in this photo, states 1.
This is taken from Trescott Drive. The house on the right is my house, and the house on the left was Danny's house.
Okay. And the bay window that you've described, is that's what?
Nice house.
Is that what is pictured in this portion of the photo right here? Yes, sir.
That's correct.
Published states too, please. Sir, is this the view from that window?
Yes,
All
this
right.
is what I saw as I looked out.
Okay, and the driveway that we can see there on the right side of the window, is that Dan Markel's driveway?
Yes, it is.
All right, so you've described that something got your attention. Can we have states 3, please?
Well, as I mentioned, I wasn't sure where the noise had come from, and I looked to the left and to the right. And as I looked to the right, there was a car that was rapidly backing out of the driveway and immediately headed down in that direction towards Benton Road. It caught my attention because it seemed to be going so fast. And I noticed what it looked like, and that caught my attention, although quite frankly, it was out of the corner of my eye. It appeared to be a Prius, a light colored Prius, maybe silver or white.
Okay, so if something got your attention, what was that?
Well, that was what got my attention. And then
Was the vehicle itself?
excuse me?
Was the vehicle itself or some noise preceded the, you see in the vehicle?
Well, initially we had heard this loud noise, which we weren't exactly sure it was. It could have been a gunshot. We weren't sure. And then when I saw the car back out, that prompted me then to walk next door. There had been in the neighborhood a few break-ins, burglaries, and my first thought was that somebody was trying to break into the Markel house. And so I went out the front door and walked across over to Danny's house to see if anything had been damaged, maybe tried to be broken into the garage or something.
Yes, sir. When you looked out, you said you saw the car back out and then exit toward Benton Road. Would that be going this direction to the right of the photograph or toward the left of the photograph?
It would be towards the right.
Okay, so out this way. And you said you walked over there just to sort of look around, make sure everything was okay. What did you see?
As I approached his garage, I noticed that the garage door was open. His car was inside and the motor was running. And so I thought then, well, I guess so much for a burglary. I don't think that's happened if Danny's there. So I turned around and walked back to my house.
Okay. What happened next?
After that, I can't tell you why, but I just stood at my front window and looked out and waited for a few minutes, maybe 3 or 4, up to 5. And for some reason, it just didn't quite seem right. Danny hadn't backed out. And I thought by this time he should have backed out of his driveway, and he didn't. And so I said to my wife, I think something just seems wrong. I'm going to walk back over. And so I did that.
All right. And what did you see when you got over there?
Excuse me?
What did you see when you got over there the second time?
Well, when I went back the second time, I noticed that the garage door was still up. The car was still running. And this time I thought, maybe I better walk on into the garage. He's probably in the driver's seat. He's probably on the cell phone talking, but I just wanted to make sure everything was okay.
Yes,
And
sir.
so I walked into the actual driveway then, and I saw that the window, the driver's side window, had been shattered, and I stepped on glass at that same time. As I looked inside, I saw a bloody head, and the head was slowly moving back and forth, rolling back and forth, left to right. And I hollered immediately, "Danny, what happened?" And I didn't get any response other than the head rolling. And so I hollered again, Danny, what's happened?" Still nothing. And at that point, I knew that I had to get the emergency medical team there as quickly as I could. I reached into my pocket to pull out my cell phone, which is where I normally keep it. And it wasn't there. And I thought, gee, I've left it back on the couch at the house. So I quickly dashed back to the house, got the phone, and called 911.
How many minutes do you estimate elapsed between the time you saw the Prius backing out, or really I should say the time you heard the loud bang, to the time that you were able to reach 911?
Less than 10 minutes, more than 5 minutes, somewhere in there, I would say.
For those of you who are new, because I'm deaf, even though I have hearing aids and it's Bluetoothing, a lot of times you see me looking here or here. I'm reading captioning. It's so big that it covers too much of the screen for me to look forward. So please do not take it personal. I am paying attention, especially if I'm looking here. This is my normal spot. Sometimes I look over here. I'm also following the chats over here. I have 3 monitors in front of me and a 4th one above me. So this 4th one up here right there has nothing but captioning on part of the screen so I can see. So just want to explain to you why my eyes may be bouncing. And I'm also keeping an eye on the Christopher Wolfenberger, which we have paused. No spoilers, because when we go to regular lunch breaks, we're going to zoom and get caught up in that. Yes, I grew up hearing. That's why I can talk so well, but I'm now fully deaf without my big bad boys, which I'll be getting some new ones in the next couple of months. But I just wanted y'all to know that and know, because if you see me looking around and doing this a lot, I'm not ignoring you. I'm not ignoring the live. It's just I'm reading so I can understand what's happening. Thanks for the understanding.
I'm going to approach and show you what I've marked as State's Exhibits 4. And then I also have 6 and 7.
I'd love to follow a trial overseas that's live, but they're not.
Number 4, and then also 6 and 7.
Mm-hmm.
Do you recognize these
Guys, that's a packed courthouse.
photos?
Yes, I do.
All right, Judge, at this time, I'd ask to move into evidence 6 and 7.
Any objection?
No objection.
States 6 and 7 are admitted.
Publish State 6, please.
You may.
Sir, is this how the vehicle was positioned when you went over there and found Mr. Markel so badly injured?
Yes, that looks correct.
Publish State 7, please. Was the doors to the vehicle are open in this photograph? Were they open or closed when you went over?
No, they were all closed.
Okay, closed, and the only window that was damaged was that the driver's side window?
That's the only one I saw. That's if there were some others, I didn't look at any other windows. I just simply saw the driver's side that was completely shattered.
All right, yes, sir. And State's Exhibit 4, is this consistent with the type of vehicle that you observed in the driveway backing out that day?
Yes, it was, although I didn't quite see that angle.
Okay. Judge, at this time, I'd ask to introduce States 4.
Objection, States 4. No objection. Admitted at this time.
All right, and you described it as a light-colored Prius. You weren't exactly sure of the color, maybe white, maybe silver, right?
Yeah, silver came to mind first, I guess, but certainly a light colored vehicle.
I'm going to approach and show you State's Exhibit 5. Recognize States 5?
Yes,
Is that Mr. Markel?
yes, it is.
All right, may I introduce States 5 here?
No objection. States 5 is admitted.
Publishing States 5. What did you know about Mr. Markel?
Well, this occurred in 2014, and Danny and Wendy were newlyweds and had moved in about 5 years earlier than that. They moved next door. We were not particularly close to either one. We would see them occasionally out on the street. The memorable thing, and the other neighbors would tell you, is that when they first moved in, they had a housewarming event and they invited all the neighbors in, and we attended it. That was our first time to see them and visit them. They seemed like a nice young couple, and But after that, we weren't particularly close.
Did they have a couple little children living there?
Well, when they first moved there, they didn't, but after a year or two, they had a first child and then later a second child.
All right. And at the time that Mr. Markel was shot, had his wife, Wendy, moved out? Had they separated?
Yeah, we had understood that they were going through a divorce, and Wendy had left. And after that, we rarely saw Danny. And I don't think we ever saw the kids either, but
Were you familiar with Mr. Markel's profession?
yes, I knew that he was an attorney. Both of them were, and they were connected with the FSU Law School, I believe, but I didn't know their exact positions there.
Yes, sir. Publish 4 again, please. Are you able to tell the jurors anything about the occupants of this vehicle on that day?
No, I only saw it just briefly, and to notice what kind of car it was. I couldn't tell you who was inside. The windows were dark as far as I could see. I didn't even know if it was 2-door or 4-door. I just didn't see anything like that.
During the time that you were present at the scene of the shooting, did Mr. Markel ever regain consciousness or ever say anything that you heard?
No, I never heard him say anything. The only notion was that his head kept rolling back and forth during the 911 call, which it took forever to try to get the emergency vehicle there, the emergency medical team. They would occasionally ask if he was still breathing. And I would walk back up into the garage and his head was moving still. And I said, well, his head's moving. So I assume he's still breathing.
Yes, sir. Have you had an opportunity to review that recorded call that you made to 911 that day?
Yes, I have.
All right. And was it a fair and accurate recording of that call?
Yes.
All right, Judge, at this time, I'd ask to move into evidence states 88.
An objection.
Objection.
States 88 is money.
May I publish?
Go ahead.
What's your emergency? It's right next door at my house, which is 2122 Trescott Drive. Can you repeat that for verification? 2122 Trescott Drive, T. Okay, and the phone number you're calling from? I'm calling from 8502. Okay, tell me exactly what happened.
Somebody who may be having a migraine or could be triggered by ultraviolet lights. I've worn sunglasses inside if I'm in a room that has UV lights and they trigger migraines for me. They could be blind. I don't know.
We heard a loud bang and a car pulled away from next door. I came over and looked in, the garage door was up. And I thought the gentleman was backing out, and I went back to my house, but he never backed out. And I came back over, and his driver's side window was shattered, and he's battered, and can't answer. He's inside. I don't know if somebody tried to shoot him, or if he shot himself, or what, I don't know.
And it was at this location, correct?
Right next door. I'll give you mine. I don't know if the address is next door.
Okay.
He didn't send an ambulance in a hurry. EMG. He's still alive. He's moving.
Okay. What's going on with it?
I don't know. The driver's side.
Okay, if y'all are struggling to read this, I'm going to read it. I'll read the captioning, so hopefully it's close. I came over and looked and the garage door was up and I thought the gentleman was backing out. When I went back to my house and he never backed out. And I came back over and his window, driver's side window was shattered and you can't answer his, I don't know. Somebody tried to shoot him or he shot himself or what, I don't know. So it was at the location correct next door. I don't know if it's just he's still alive. He's moving. Okay, what? Okay, so yeah, it's very garbled. It's very difficult. I'm doing the best I can.
The window was all bashed in. He's inside the car running, and he's got blood all over his head. He's not responding to me. That number, by the way, is 211-21.
All right, that's the first few minutes of a 14-minute call. Is that how long it took them to get somebody to you?
Seemed to me a lot longer,
Seemed like 14 hours, didn't it?
long time.
Nothing further, Your Honor.
Cross-examination from Mr. Geiger. Mr. Geiger, you may step down, sir. Is he released from his subpoena? Will anyone need to recall him for any purpose?
He's released, Your Honor.
Have a good day, sir. Please call your next witness.
The state calls David Sims.
Please approach.
Okay, so witness number 1 is up and off the stand. We're going into witness number 2. I'm going to try. Somebody asked if I could do a counter on the witness. I said, sure, I'll do counters on the witnesses. Hopefully I don't get it wrong, but if I do, we'll be corrected. They have muted court. Okay, that is not Donna's husband. That is the neighbor to Wendy and Dan Markel, the victim, and her daughter house. My banky fail. My banky fail. Okay, sidebar is over.
Please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth? I do. You may take your seat. Please speak loudly and clearly for the jurors.
Sir, please introduce yourself and spell your name.
David Sims, S-I-M-S.
How are you? Go ahead.
Retired sergeant from Tallahassee Police Department.
How long were you with Tallahassee Police Department?
28 years.
Okay. And were you employed with them back in 2014?
Yes.
Did you respond to a scene in response to a 911 call 2116 Trescott Drive on July 18th of 2014?
Yes, I did.
Is that location in Leon County?
Yes, it is.
All right. And do you know what time you were dispatched to the call?
I was not dispatched. I was actually at the station working on paperwork, and I heard the call go out, so I just responded.
Okay. And were you the first or?
First on scene.
You were first on scene.
Yes.
And did you make contact with Mr. Geiger, the neighbor?
Yes, I did.
And did Mr. Geiger indicate something going on in the garage next door to his residence?
Yeah, he said his neighbor, he thinks it was his neighbor in there, and he heard a loud noise, and there was broken glass in his car.
All right, I'm gonna publish states 7, please. It's in, right? Yeah. Has the vehicle been moved from the position it was in when you first arrived?
No.
Okay, other than the doors being open, right?
Correct.
Okay. When you got there, was the vehicle running?
Yes, it was.
All right. What did you do when you first arrived and observed the vehicle?
I walked up to the driver's side window. Mr. Geiger had told me that the homeowner's name was Daniel, and I saw someone in the car, and I spoke his name and said, Daniel. There was no response, and I got a little closer and found that the driver's side window was broken kind of at an angle. Some of the glass was in, some had come out, but there was also a small rounded spot in that glass that was still in there. I said, Daniel, again, no response. He was slumped over and kind of gasping for air, and it was just a sucking sound. I noticed that he had a set of eyeglasses. Half of a set of eyeglasses was laying in his lap. He had a cell phone in his left hand. He had a business card in his right hand. I walked around to the other side of the car. Well, first I reached in and unlocked the door, and I went around to the other side, and I opened the door and reached in and shunned off the car, so the car wasn't still running. And then I noticed the other half of the eyeglass is laying on the floorboard of the car. I
Let me
removed
pause you there and approach and show you what I've marked as states 8 through 10.
Yes. Yes.
Are these 3 photographs?
So is this better, June? Testing 1, 2, testing 1, 2.
Fair and accurate representations of how the vehicle appeared that day?
Yes.
Judge, I'd asked to introduce states 8 through 10. No objection.
States 8 through 10 are admitted.
Publish 8, please. All right, can you got a pointer. Show us what you're talking about as far as the way the window was?
Part of it had broken out, part of it was still intact, but right there looked like a little rounded area.
All right, and was this void, large void that we see in the window there before the door was opened?
Yes, yes.
Okay, so you said you were able to reach in and unlock.
Yeah, I
the
reached
car.
in, the door was closed. I reached in through that broken area, unlocked the car, and then ran around and we entered from the other side to pull out, turn off the car and pull out the keys.
All right, and during this time was EMS already en route?
Yeah, I could hear them. I could hear them coming down the street. They were almost there.
Okay, and were life-saving efforts made to try to help Mr. Markel?
Yes, when I was on the passenger side, I pulled out a gym bag or something that was in there, pulled it out, and set it on the ground so they can make better entry into the vehicle to extract him.
Okay. And did he ever regain consciousness or say anything during the time you were
Not
there?
in my presence.
All right. Publish 9, please. Publish 10, please. All right. Do you see the half part of the eyeglasses there in that photograph?
Yes.
Could you indicate with your pointer?
Yeah, right there.
And is that where you observed them, or had they fallen out?
They had fallen out. One was in his lap and then one was on the floorboard on the driver's side.
All right. And what about the cell phone that we see pictured to the left of the
That
eyeglasses?
was in his left hand.
Was there a safety search done of the house?
Yes, after EMS was removing him, then myself and a couple other officers, we took the keys that were in the car. The person door from the garage into the house was locked. We unlocked that, did a search of the house, found no one, nothing amiss.
Any indication that this was a burglary, a robbery?
No,
Any obvious signs of a struggle?
no.
No further questions.
Cross-examination for Mr. Sims. You may step down, Mr. Sims.
This
Yes.
witness is released, Your Honor.
Thank you. Please call your next witness.
Joanne Maltese.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You may take your seat. Please speak loudly and clearly for the jurors.
Please introduce yourself and spell your name.
My name is Joanne Maltese. Joanne, Joanne, and Maltese, Maltese.
Are you employed, ma'am?
Yes, I am.
Are you employed as law enforcement, in law
No,
enforcement?
I am retired Tallahassee Police Forensic Specialist.
How long have you been retired from, it's Tallahassee Police Department, right?
Yes, a little over 8 years.
What were your duties when you were employed there?
Duties as a forensic specialist is the documentation, collection, and preservation of evidence at a crime scene.
How long did you do that type of work?
Done that work for probably 15 years.
Okay. And were you doing it back on July 18th of 2014?
Yes.
As part of your job, did you respond to 2116 Trescott Drive on that date?
Yes, I did.
Right. And what was your job once you arrived at that particular scene?
That particular day, I was called to document and collect evidence at a crime scene.
Publish 10, please. Is this the scene that you're referencing?
Yes, it is.
All right, I'm going to approach and show you states 11 through 17 as well. Just have you look through those and tell me if you recognize them.
Yes, I do.
How do you recognize them?
I took these photographs at the scene.
All right, Judge, at this time, I'd ask to move into evidence states 11 through 17.
11 through 17 are admitted.
Publish 11, please. Publish 12, please. Did you collect the eyeglasses shown in State's Exhibit 12?
Yes, I did.
That appears to be half of a pair of eyeglasses. Did you collect both halves?
Yes, I did.
I'll show you what I've marked as states 121 and 122. Do you recognize those?
Yes, I do.
Are those the two halves of eyeglasses collected from this crime scene?
Yes, they are.
Judge, at this time, I'd ask to move into evidence states 122 and 123.
Any objection? States 122 and 123 are admitted.
Publish the next exhibit, please. Did you collect this eyeglass lens?
Yes, I did.
Where was it located?
I believe that one was the floorboard of the driver's area.
Was there another piece of eyeglass lens also collected
Yes,
you
there
that
was.
day?
Yes, there was.
Okay, where was that piece found?
That was the other optical was on the driveway, or I'm sorry, the garage floor right below the driver's area.
Showing you 123 and 124. Are these the two pieces of lens that you collected that day?
Yes.
Move into evidence 123 and 124.
Any objection? No, Your Honor. States 123 and 124 are admitted.
Did you take any swabs or attempt to get any fingerprints from the scene?
Yes, I did.
And what efforts were made on those fronts?
I processed the entire exterior of the vehicle for fingerprints. There was an area that was lifted, but it did not have fingerprints of value to compare. As far as the swabbing, all of the exterior and interior door handles, as well as a phone that was collected, and the doorknob from the garage to the interior of the house.
What were the results of those efforts?
Those I would not know. It'd be sent to FDLE lab for analysis.
Did you find any fingerprints of value to send to FDLE lab?
No, I did not.
Publish states 14, please. Approaching with states 125. Do you recognize 125?
Guys, you can tell a lot by a person's personality by looking at their wallet. Just FYI.
Yes, I do.
What is this item?
This is going to be a brown wallet with its contents that were found in the glove box of the vehicle.
All right, and did the wallet contain Dan Markel's driver's license?
Yes, it did.
And in the exhibit, there's no cash, but there's some cash pictured in the photograph.
Yes.
Was there cash that was seized as well?
Yes, there was.
All right, so based on this, didn't appear there was any effort to take Mr. Markel's belongings.
Correct.
Okay, any evidence that the house was broken into or anything was taken from the house?
Not that I could determine.
Published state 16, please. And 17. And then back to 16, if you would. What efforts were made to document this? What is it that we're looking at?
We're looking at the front driver's door window that was shattered with a hole in it.
Okay. And what did you do to try to document this?
The glass was very fragile because it was broken. So prior to doing anything to it, besides fingerprinting, I would have put clear tape on both sides, the interior and the exterior, just to hold it in place for transportation and collection.
I'm approaching with what I've marked as states 126. Is this the glass that you were able to remove from the vehicle?
Yes.
Is it in the same or substantially the same condition as when you seized it?
Yes.
Move into evidence states 126.
Any objection? No, Your Honor. States 126 is admitted.
Publish. And the glass evidence, is that consistent with a gunshot?
Yes, it is.
All right, did you, as part of your job, have an occasion to photograph Wendy Adelson's vehicle?
Yes, I did.
Was that done the same day that you collected this other evidence?
Yes, it was.
Where did you photograph her vehicle?
Her vehicle was towed to the Tallahassee Police Department.
I'm going to approach and show you what I've marked as states exhibits 18 through 21. Do you recognize 18 through 21?
Yes, I do.
Are those the photos you took of Ms. Adelson's vehicle?
Yes.
Move into evidence 18 through 21.
Any objection? No, Your Honor. States 18 through 21 is admitted.
Publish states 18, please. Publish 19. Publish 20. What is this item?
This was on the front passenger seat of the vehicle, and it is a bottle of alcohol and a receipt.
All right, and did you take a closer photo of the receipt? States 21, please.
Yes.
And what does that show about when the alcohol was purchased?
On 7/18 of 2014 at 12:49 from ABC Fine Liquor and Spirits, or Fine Wine and Spirits.
Did you also go to the hospital?
Yes, I did.
What were you asked to do at the hospital?
Document and collect any evidence.
At the time that you responded to the hospital, was Mr. Markel deceased or still alive?
He was still alive.
I'm going to approach and show you what I've marked as states exhibits 22 through 24. Do you recognize these exhibits?
Yes, I do.
How do you recognize them?
I took those photographs at the hospital.
Are they fair and accurate photos of how Mr. Markel looked that day?
Yes.
Move into evidence, states exhibits 22, 23, and 24, Your Honor.
Any objection? No, Your Honor. States 22, 23, and 24 are admitted.
Publish 22, please. This is how Mr. Markel appeared,
Yes.
and this was done on the 18th.
Yes.
Cross-examination.
No questions, Your Honor.
Very well. Ms. Maltese, you may step down.
Yes, Next witness is excused, Your Honor.
Please call your next witness.
The state calls Dr. Clark.
Oh my gosh. Look
Dr.
at
Clark,
that.
Please raise your right hand, sir. Do you swear or affirm the testimony you're about to provide will be the truth?
Yes, I do.
You may take your seat. Please speak loudly and clearly.
Sir, please introduce yourself and spell your name.
I'm Dr. Anthony J. Clark, Anthony J. Clark, Clark.
How are you employed?
I'm currently employed as Associate Medical Examiner for the Georgia Bureau of Investigation, Division of Forensic Science in the Central Regional Office in Macon, Georgia.
What are your duties there?
I work as an Associate Medical Examiner. I perform what's called the autopsy and forensic autopsies and death investigations.
Was there ever a time that you worked here in Tallahassee as an assistant medical examiner?
Yes.
What time periods did you do that?
It was from 2007 to 2023.
All right. And how many autopsies have you performed during the course of your career?
It's over 8,000 now.
And what is the education and training that you have that qualifies you to do that type of work?
I obtained my Bachelor of Science degree from the Massachusetts Institute of Technology. I did the 2 years of animal research before moving on to Jefferson Medical College in Philadelphia. I graduated from the college and then traveled over to the Britain General Hospital in the Britain, Connecticut, and did a 2-year general surgical internship. I then went to the Hartford Hospital in Hartford, Connecticut, and did 4 years of anatomic and clinical pathology. I then traveled from that program down to Atlanta, Georgia, where I did a 2-year forensic pathology fellowship at the Fulton County Medical Examiner's Office in association with Emory University. I am board certified in anatomic and forensic pathology. I have medical licensures both in the state of Georgia and Florida.
Have you ever testified as an expert in the area of forensic pathology?
Yes, I have.
How many times?
Several hundred times.
Tender Dr. Clark as an expert in the area of forensic pathology, Your Honor.
Does the defense wish to voir dire the witness?
No, Your Honor.
Is there any challenge to his ability to provide an opinion?
No, Your Honor.
Members of the jury, the witness will be permitted to testify before you today in the form of an opinion in the fields of both medicine and forensic pathology. You may continue.
Doctor, did you conduct the autopsy of Dan Markel?
Yes, I did.
When was that conducted?
We performed it on July 19, 2014, and we started at 11:55 hours.
Where was the autopsy conducted?
At that time, we were in the Tallahassee Memorial Hospital morgue.
Did you take photos as part of your autopsy?
Yes, I did.
Would use of those photos assist you in your testimony?
Yes, they would.
Would they assist the jury in understanding your testimony?
Yes, they would.
States 25 through 34.
So those of you who are just joining us, I will not show images of the deceased face or do that kind of stuff, but some of the photos I will show. I'm depends on what it is. Okay, just warning.
Take a moment to look through those and let me know if you recognize them.
That's on their end, not mine. That's a
Yes, ma'am.
folder.
Fair and accurate photographs that were taken during the autopsy of Mr. Markel.
Yes, they are.
Moving to evidence, states 25 through 34, Your Honor.
Any objection?
No, Your Honor.
States 25 through 34 admitted at this time.
Publish 25, please.
Before you publish, if the parties can briefly approach.
More hair on his chin than most people's head. I know, will y'all quit talking about food? Now my hearing aids are squealing. Uh-oh.
Jury room.
Why are you crying and shaking? You're not allowed to give. All right, guys, let me tell you something. The judge is not going to put up with her getting out of control.
A brief break before we continue with the examination of Dr. Clark. The bailiff will take you to the jury room.
I think they're going to, I don't know, are they going to give her an opportunity to get herself under control? Just saying. I will. I don't know why it came down. Oh, that's why. Give me a sec.
Mr. Zellman, Ms. Fulford, if your client needs to use the restroom, this would be a good time to do so.
Okay, we're going to hop over here real quick and get going.
I am told that the wayward witness is here, Mr. McDermott.
Yes, Your Honor, I have made contact.
Has the state had an opportunity to make contact if they so chose?
We have not, and we don't need to.
Okay. Is that witness up?
Yes, Your Honor.
Is that witness in custody?
Yes, Your Honor.
Okay. My general understanding is that the sheriff's department prefers to have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters while we're taking care of that we need to take up before we get the witness on the stand? Anything from the state?
Nothing from the state.
Anything from the defense?
Nothing from the defense.
Okay. Yes, sir. So just to be clear, Mr. McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness, or do you want me to make an attempt to get her to answer directly first?
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such.
In other words, attorney, that's a question you should have known the answer to.
Good morning. Ma'am, if you'll come over here to the witness stand.
I like this judge.
And she might need some assistance getting up onto the witness stand and situated in the chair.
She's shackled.
Thank you very much. Okay.
And prison clothes.
And so I think we're ready for the jury, Deputy.
Oh, they held her in jail overnight. Those are jail tops, and she's shackled. Wow. Wow, y'all. That's kind of interesting.
Defense calls.
If you can, please raise your right. Okay. Ladies and gentlemen, if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Waddell, Waddell.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Waddell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenberger?
I did.
And do you know the Patton family?
I do.
Carl and Norma? And how did you know them?
My parents grew up with them
And did you live next door to them at one point?
as a child.
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
Why did it smell?
Well, people just have a smell,
What was the smell like?
like a person. It
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling me?
Are you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about facts. You remember speaking with me on the phone a couple of weeks ago?
Yeah.
And you remember telling me that the smell pervaded the house and
I
the
did.
car,
Got it on the car.
and
Got
it
it on the
stuck
house.
on everyone in the house,
It did.
including Melissa. Did you remember telling me that people bullied her for it,
They did.
picked on her? You remember telling me that Melissa had some kind of, it's not a leading question, Your Honor, unless it suggests an answer.
I'm gonna overrule and allow it. Go ahead.
Do you remember telling me that Melissa had some sort of skin condition that caused her to have marks on,
Vitiligo.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What do they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I look back at it, I'd say autistic.
I'm sorry.
I said, if I had to look back, I would say autistic. She
Okay,
would be autistic.
but you're not a doctor, right?
I'm not.
So you can't diagnose her with autism.
No.
But what made you arrive at the conclusion that she may have been autistic?
Just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's,
she quiet?
sure.
Was she shy?
Yes,
Was she reserved?
she was.
Did she sometimes react?
She whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Of a baby.
infantile for her age?
Yeah.
You described to me a period of time in which you would visit her. Do you remember describing a time to me when you would visit her almost every day,
Every weekend, yeah.
and that you would be locked in the room with her?
Yeah, growing up.
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door, so that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer. I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it was started at about age 7,
I'm sure it started early.
went
yeah.
up to about 12?
Yeah.
Okay. You said her sister was locked too,
He's right there.
and she was locked up too?
Mhm.
And
I'm sorry. Was that a yes?
Yeah, my mom used to sneak out with her and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes?
Yes, it is. Terry Archer.
Thank you.
what was your father's name?
Bobby.
And you said that your parents were wealthy
They are.
and that they paid to be involved in several activities with you.
They did.
What kind of activities?
GYOP. Georgia Youth on Parade. Girl Scouts.
You remember telling me that anything you did, Melissa
did.
had to do,
That's right.
and that your mother paid for it. You remember telling me that looking back on the way she was treated, being locked in a room and being deprived. Well, let me back up. When you and Melissa were locked in a room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah. You're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get, what was that? We're thirsty.
Okay. You remember telling me that looking back, you would consider that she had been abused and neglected.
Yes.
Today, if someone were treating their child like that, would you call defects?
Relevant, Your Honor. Objection.
Probably.
Hang on one second. Sustain. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
They moved away? Okay. And about what age were you at that point?
I'm not quit hanging out with her when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
And how did that happen?
Objection. Relevance.
Sustained.
Okay. May I approach, Your Honor?
Sure.
They're not liking the objections, which I understand to a point, but you can object. It's okay to object. I find it interesting how this woman is responding to his questions. She desperately does not want to be there. I get it. It sucks, but at the same time, you got to, you're ordered by judge to be there. You got to go. Getting a lot of, there we go. I'm getting a lot of phone stuff. So they will drive her home. When she's done with testimony, she'll be released at that time. Her punishment for not coming in under her own for initiative is that she had to spend the night in jail. Yep, she's not being hostile at this point. So that's a good thing.
Dane, move on, please.
Do you remember telling me that I caught myself? Was there a time that Melissa did drugs with you?
No.
Okay.
I was doing drugs.
Okay. And because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but that's just for the record. You got to let me finish my question and then you answer. Okay. All right. Do you remember something?
Okay, now we're going to go back over to the trial. We're back in court. And Miss Drama Queen looks as if she's gotten herself back under composure. No, she was not in jail. They had to go to her home to pick her up. She did not want to come in. But when you get brought in from another state, I don't know. I guess I can look it up, but I could have sworn they said she was in her home.
Your
So I'll look it
examination
up.
of Dr. Clark at this time.
Yeah, that's what I thought.
Publishing 25. And doctor, you should have a pointer. All right, explain what we're looking at in states 25.
As part of the examination, particularly in gunshot wounds, we like to know whether the bullets are still in the body or how big.
Okay, this kind of stuff I will show.
How badly they are broken up, etc.
Look at the
So we
swollen
get
right there.
X-rays, and this X-ray, this is an X-ray of the head. You can see the top of the head here, the jaw, right side, left side, and these really bright spots here and here are the bullets that we recovered from this individual. They come out because they're very dense. The X-rays bounce off and turn them white here, just like bone. It's fairly dense. These are the bullets here.
Through that.
Publish states 26, please. How many bullets were in Mr. Markel's head?
There were 2 bullets in his head, and you can see on this one here that hit the left cheek, actually fragmented a little bit. And then we had a bullet inside the head, back to the left side, right side, excuse me, right side.
States 27. What are we looking at here, doctor?
This is actually the identification photograph of the individual. We like to get them cleaned up. We'll put the identifying tag underneath their chin, the case number, the date, and usually my initials. And you can see that there has been quite a bit of damage here, particularly in the left side of the face. We have a gunshot wound here that's labeled number 1 in the autopsy report. And this is number 2, labeled number 2 in the autopsy report.
By labeling them 1 and 2 respectively, are you opining that that's the order in which those shots were fired?
No, the numbering system in the autopsy report is just for me to discuss during the trial.
Publish 28, please. What does 28 show?
So this is what I call gunshot wound number 2. And you can see it's quite irregular. It's not a nice round hole you'd like to see, but the way it hit the bone, it caused a lot of damage and tearing in this area here. You can see that there's some what we call raccoon eyes or hemorrhage around the eyes. There's quite a bit of swelling going on here. Also in this area here, you see a lot of minor superficial abrasions that vary in size. Some are much bigger and some are smaller. You can see it's all over the cheek here, so and the ear and the side of the neck here. This is what we call pseudo stippling, and this usually happens after the bullet goes through a door or a window or hits concrete and causes those items, the glass or the wood or the concrete, to splinter and cause small particles to fall out, to shoot out and hit the individual's skin. So this isn't true stippling, which is due to gunpowder. We'll see an example of that in a minute. But so we have large areas of pseudo stippling around the left side of the face, the left side of the neck and ear.
So each of those small red injuries represents a piece of glass striking.
Piece of glass, yes, ma'am, or part of the bullet that fragmented off the main part of the bullet.
States 29, please. What does this one show?
Again, we're looking at the left side of the neck here. Here's the left ear. You can see that this pseudo stippling is quite extensive. Also, you'll see that there's kind of a purplish discoloration here because of where the bullet track went to. It caused a large amount of bleeding into the left side of the face, where you saw that huge distortion of the left side of the face, and then drained down into the neck.
States 30.
Okay, this is going to be gunshot wound number 1. It's right between the eyebrows, closer to the left eyebrow. Again, it is distorted. It's not a nice little round hole because of the shelf of bone that's there. It's called a glabella. So it causes an irregular entry wound. And now we're seeing a much finer area of stippling across the forehead here. This is much different from what we're seeing on the left side of the face. This is true stippling or gunpowder stippling from the barrel of the gun directly.
How does firing a gun cause this pseudo stippling?
The stippling.
Stippling.
Okay, when the firearm is discharged, out of the barrel comes the bullet, of course, hot gases, soot, burning and unburned gunpowder. What causes the stippling is the burning and unburned gunpowder. It actually it's a particulate that strikes the skin and abrades it. It doesn't burn it, but it hits it and abrades it, or scrapes it. So that usually with a handgun, we can see the stippling out to about 18 to 24 inches. This to me looks a lot closer than that, but all we're seeing is the stippling here.
So the presence of this evidence suggests that the muzzle of the gun was quite close to Mr. Markel's head when it was fired.
Yes, I'm thinking inches. Yes, ma'am.
States 31, please. What does this show?
Okay, this is giving you a perspective of the 2 gunshot wounds here. What I call labels 1, what is label 2, the pseudo stippling on the nose, the fine stippling on the forehead, the hemorrhage around the left eye, part of the raccoon eye pattern.
States Exhibit 32.
This is the left forearm, and what you see here is kind of a ring of soot, partial ring of soot here, and some stippling on the forearm here too.
What is that consistent with?
That to me is suggested that that arm was up near the gun when it was discharged. That's at one point in time. And most likely the one gunshot wound that went to the center of the head here, that arm was up in a defensive type thing or a reaction type thing. And the soot, the stippling is actually not from the barrel, but when you're talking about a revolver, you have a cylinder where the bullets are. You have a space between the cylinder and the barrel. It's called a cylinder gap. And soot and gunpowder can come out of the cylinder gap and cause this kind of pattern.
So again, consistent with the firearm being very close to the victim?
That's correct.
And also, is it consistent with the victim at least having enough wherewithal of the impending danger to raise his arm in defense?
In my opinion, yes, ma'am.
All right. And you said that the number that you order the shots for purposes of your reports does not necessarily mean that's the order of the shots that were fired in this case. Do you have an opinion as to which shots were fired in what order?
Yes, after discussions with the investigators and looking at the scene photographs, the first shot went through the closed car window. So the first shot would have been to the left cheek area, which traveled from the left cheek just before the left ear, hitting soft tissues, fracturing the jaw, fracturing the left cheekbone. Again, this is maybe slightly incapacitating, maybe stunned him, but would not immediately put his lights out. Okay, so that is where all the
oh, he said it.
Glass shattering.
Put
Glass
his
is not there
lights
anymore.
out.
The second shot is to the forehead,
Sorry. Hi, June. Welcome, June. Sorry, I got a little excited there. Put his lights out. What a delicate way to say unalive.
Where the actual gunpowder can strike the skin and the hand was raised somehow into the vicinity of that cylinder gap.
And that's the second shot is the one that was not survivable.
That's correct.
And was there any amount of medical attention that could have assisted Mr. Markel, say if it had gotten there sooner?
Well, these are pretty devastating injuries, particularly the gunshot wound in the brain.
Did you collect the projectiles from Mr. Markel's head?
Yes, I did.
I'm going to show you States Exhibit 127 and 128. If you will publish 33, please. Ask if you recognize 127 and 128.
Yes, I do.
How do you recognize those?
These are the envelopes that we place these bullets in with the identifying marker labels and where they were from. Both one's from gunshot wound number 1 and one's from gunshot wound number 2.
Are they in the same or substantially the same condition as when you collected them?
They appear to be so, yes, ma'am.
Move into evidence 127 and 128, Your Honor. And is this a photograph of one of these projectiles removed from Mr. Markel's head?
Yes, ma'am. This is the one from gunshot wound number 2 to the left cheek area. If you remember on the x-ray, it had kind of a barrel shape to it. I don't remember, but you see the barrel shape here.
And for the record, that was 33, now publishing 34. What does this show?
This is
Would you be able to turn it? Upper left, maybe. Again. Thank you.
This is the bullet that we pulled from the right side of the brain. And the x-ray is getting a little pretty deformed. You can see that we taken one picture, one aspect of it here. Here's the identifying label.
What is meant by the term cause of death?
That is how that person died.
All right, and is it part of your job as assistant medical examiner to determine a cause of death?
Yes, ma'am.
And were you able to do that in this case?
Yes, ma'am.
What was the cause of death?
Gunshot wounds of the face and head.
And what about manner of death? What's meant by that term?
Manner of death is how what were the circumstances that eventually led to the death.
And do you have an opinion as to the manner of death?
Yes, I do.
And what is it?
Homicide.
No further questions.
Cross-examination, Dr. Clark.
There you are.
Judge, this witness can be excused, and this might be a good time to take our lunch recess.
Very well. Dr. Clark, you may step down, sir. Have a good day. Members of the jury, we are going to take our lunch break at this point. As you have been previously instructed, I'm just going to remind you again, you are not to discuss this case with each other or any other person. During your lunch break, you may eat together if you choose to. Again, you may converse about any manner of things, but this case. Does everyone understand this instruction? Please raise your hands. And for the record, the jurors have raised their hands. Please return at 1:15. Enjoy your lunch break.
Okay, so we're going to go over here and we're going to go to this trial.
Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
Okay. And do you remember that there was something that led up to her running away from home?
Her sister had a steel baby.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
Okay.
How do I know that?
Sorry, they're having a sidebar thing.
Concerning emotional responses. I do feel it is important at this point, Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as best possible, you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts. The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well. I do not wish to do this in front of the jurors at all, but it's very important that you are able to control your emotions. Do you understand what I'm saying? Does either party need to be heard before we before we go into the lunch break?
No, Your Honor.
All right, please report back at 1:15 as well. I believe we have 3 other witnesses that we can possibly get through this afternoon.
All righty then. Now we're going to go over here.
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, Your Honor.
Thank you. Ms. Hilton, questions for this witness?
Yes.
Nothing burger again.
Do you remember telling me that when you knew Melissa and hung out with her, that her mother would not let her have anything like makeup?
Mm-hmm. You said a yes.
Yes.
Thank you.
And what did she do instead?
Use color pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks?
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I say that?
Can I show you a transcript of our interview?
Sure. I never said that.
Would you let me play the audio?
Sure. I must have been high.
I must have been high. Oh my God. She's got cuffs on, so yeah. Maybe she was.
Permission to share, Your Honor?
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you just asked.
So the joke is, what's a skeleton's least favorite room? The living room.
I can imagine she was traumatized.
She was traumatized. She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use color pencils because her mama did not give her those things.
Oh.
You know, like she, would have to use, I hate to say it, but like socks for pads and shit like that. You know, because her mama neglected.
I guess it is. I was high.
No further questions, Your Honor.
Thank you. Ms. Hilton?
Good morning, Ms. Markel. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his questions. Have you? Is that a no for the record?
Maybe she was in. Ooh, maybe they had to go get her because she was in custody because she's withdrawing. Oh, or she's in a rehab facility. Either way. I rub my eyebrows off.
And have we ever talked on the phone?
No.
Okay. And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
I thought it was you.
Oh, no problem.
Go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes.
Okay. And so you were her next door neighbor, correct? Melissa's next door neighbor.
As a child.
And as a child, that from between the ages of 7 and 13?
No.
What were the ages?
Ages of 2 to 7.
2 to 7. Okay. And your parents are friends or were friends with Melissa?
Are friends.
And you said you spend time at her home every weekend, correct?
Yes.
And you just testified that there was an odor in the home that you didn't like. Is that fair?
So yes.
Yes.
Thank you.
But every weekend you still go to the house?
Yes, I love him.
And I think you testified earlier that your mom would have you take Tina out the window.
She would.
Okay. But your mom still let you go over there every weekend.
She did.
Now, you said that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and then just like a girl youth group. Is that the third thing you just said?
Something like that.
And it's safe to say that her mother will let her go with you to do these events. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington?
She did.
And so her mother would let her leave from Stockbridge? Is that a yes?
McDonough.
From McDonough and come see you in Covington?
She would.
How far is that?
30 minutes.
So it's safe to say Melissa had to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know?
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Okay. Now, is it fair to say that the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the Pattons would attend?
Yes.
What type of event was that?
Holidays.
And you talked about Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No.
Would she ever just stop talking to her children?
No. Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times?
No.
No, you didn't, or no, she
Yes.
wasn't? I'm sorry.
Yes, she's not bright.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You described her as a type that would not fight?
She don't.
That she was very naive?
She was.
Not a smart thinker? Mm-mm.
Not a smart thinker.
You said that she's dependent on whoever she is with.
That's right.
That she would not be the leader in a relationship.
She would be.
Matter of fact, in your friendship, she kind of follows you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess very short. He wouldn't let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98.
Do you recall telling Mr. McDermott that was around Thanksgiving 1998?
Something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone?
He did.
And he wouldn't let you speak to
He wouldn't.
And he was controlling her ability to talk to you?
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood
Objection.
Sustained. It's true.
When there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
Court's indulgent. Sure. No further
Okay,
questions.
thank you. Mr. McDermott, any additional questions?
Yes, ma'am. You just told the state council that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
Nope.
Um,
You said defense.
Okay. Permission to play some audio, Your Honor?
She said you said defense.
Okay. So I did tell you.
Just making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that.
Okay. Thank you.
Afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know.
you know, it's what I say. And I hate to burst your little bubble. I'm just telling you, like, I do heroin every day and I'm going through withdrawals. And that's the whole point. I didn't want to come here. So I don't know what this would be.
Were you on heroin when you talked to me on the phone? You're on heroin right now?
Only because I'm locked up. Sweating to death.
Just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that?
I didn't.
Okay. So you.
So maybe they got her out of the house while she's high. They locked her up overnight. So now she's starting to go through withdrawals. That makes sense. So they did pick her up from the residence. She's in jail in contempt of court. They forced her to stay there because they had to drive a very long way to pick her up. And therefore, now that she's not had her fix in almost a day, she's freaking withdrawing. Oh.
You don't know what she was thinking or doing after that age?
No.
No further questions, Your Honor.
Thank you, Ms. Hilton. Anything else?
In that Thanksgiving 98 call that we just talked about, do you recall telling defense counsel that the Pattons were at your family's house for a family function? Is that a yes?
Yes.
And that it was during that family function you asked about
her,
about Melissa, and you said, "Give me a number so I can call."
I did.
No further questions.
Mr. McDermott?
No further questions, Your Honor.
Okay. Ladies and gentlemen, just for some logistics, I'm going to have to ask you to step out for just a moment. I'll be right back as quick as I can.
So they're going to remove the juror so they can remove her. They're going to hightail her back to home. And then the moment she walks in the door at home, she's going to get freaking high again and go on with her meth addict life. What a horrible
Clear, you
thing.
may be seated. Deputies, if you'll assist Ms. Waddell, she's excused as a witness. Thank you, Ms. Waddell. I was just going to say, I trust that her release will be processed as quickly as possible. Mr. So I understand what's going to happen when I call the jury back in. Does the defense have any other witnesses, or is the defense planning to rest?
Defense arrest, Your Honor.
Okay, well, I'm going to need you to do it formally in front of the jury. I'm just asking in advance. Does the state still have planned rebuttal?
Yes, we have two witnesses for rebuttal.
Okay, and do you have them ready to go outside the door?
One is right outside the door, and the other is our DA investigator.
Okay. Okay. Okay, so we're ready for the jury to come back in then, and we'll have the DA rest, and, or excuse me, the state will rest, and the DA can take up its rebuttal. Is that a yes, Ms. Hilton?
Yes.
Okay, is that a yes, Mr. McDermott?
I'm sorry, Your Honor. Question?
Okay.
Question again, please.
Are you ready for us to come in and proceed in the manner I indicated, which is that y'all are going to rest once the jury comes back in and the state's going to take up its rebuttal?
Yes, Your Honor.
Thank you.
Okay, so we can zoom. I wouldn't put anybody on because I don't think the state will be. I don't think the state did a very good
You're
job
coming
of
up to the
proving
witness
this
stand,
case.
and before you, once you get there, if you'll
I
turn
think it's going to be a not guilty or hung jury, or if it is a guilty, it's going to be a fight.
and face the deputy and raise your right hand, he'll swear you in.
You swear to honor the testimony that you're about to give, truth, the whole truth, and nothing but the truth, so you got it.
Just be careful of that ledge, and then scoot up to the microphone and state and spell your name for the record, please, sir.
My name is Alton, middle initial B, Calhoun, A-L-T-O-N, again, B, C-A-L-H-O-U-N.
And good morning, Detective Calhoun. How are you?
I'm doing fine.
I want to direct your attention specifically to April 7th of 2003. Did you have the occasion on that day to speak with Kimberly Cameron?
Yes, I did.
And how did you make contact with Ms. Cameron?
I made contact with her, phone contact with her.
And who, at the time, did you know who she was?
I knew that this was a very close friend, a very close friend of Melissa Waffenbarger, and also Chris's Waffenbarger's sister.
And did you speak with her on that day over the telephone?
Yes, ma'am, I did.
And what, if anything, let me ask you specifically, was she able to tell you about her relationship with Melissa?
Yes, ma'am.
And was she able to tell you about Melissa's feelings towards her brother?
She shared that, yes, she was.
What would she tell you?
She shared that they had problems as a couple, like everyone else. Sometimes they had problems.
Did Melissa ever tell you did Kimberly ever tell you if Melissa was planning on leaving her brother?
Yes, ma'am, she did.
What did she say?
She said that we were speaking, and she indicated that in a conversation that she had with Melissa, Melissa expressed her love for her brother, but while she loved her brother, that she was planning on leaving him.
And did Kimberly ever indicate that Melissa wrote her a letter?
Yes, ma'am, she did.
Did she still have the letter?
I don't know. I asked her about when we were doing the interview details if this was based on something from the letter, so I don't know where the letter may be.
And after speaking with her on the telephone, did you have the occasion to try to meet with her in person?
Yes, and I'll say that the telephone conversation was, the purpose of that was to set up a time that we could come meet, and I can interview her more in detail.
And did you eventually meet with her?
Yes, ma'am, I did.
And when did you meet with her?
Well, that was April 23rd.
And when you met with her, was there anyone else present with her?
Yes, ma'am, there was.
Who was present?
Her mother, Kathy Waffenbarger.
And during that meeting, were you able to speak with Kimberly by herself?
No, ma'am.
Why not?
When I got there, of course, I met Kimberly, and I saw that Mrs. Waffenbarger was there and learned who she was. And I told her that I would like to speak with Miss Kathy as well, but it was my intention to interview her, Kim, and then speak with her mother. And that I would like it. It'd be nice if her mother was to be able to leave, but Kathy made it very clear and say that she was not going to leave. She was going to stay there with her daughter at the interview. So at that point, I had no other choice but to interview them together.
And where did you go to conduct the interview?
I went to Kim's home.
So this is at Kim's house?
This was at her house, yes, ma'am.
All right. I have no further questions.
Mr. McDermott?
Mr. Calhoun, you interviewed a lot of people during this investigation around that time, correct?
Yes, sir.
You interviewed Christopher, didn't you?
Yes, sir, I did.
And you remember making an audio
Yes.
Version of that interview?
Yes.
Do you remember interviewing Don Perone?
Yes.
The neighbor down the street?
Yes.
Do you remember Don telling you he drives a hearse?
Objection, hearsay.
Sustained.
You made an audio recording of that interview, correct?
Yes.
Okay. And you interviewed several other people. You made audio interviews of them?
Yes.
And we have something like 6 audio files that you created.
I'm not sure the number.
Does that sound roughly correct?
That sounds like that.
Okay. And for this discussion with Ms. Cameron, did you audio record that?
Which the initial phone interview?
The one you just testified about right here.
I believe I did. I'm not sure. All the interviews were there. If I recorded an interview, it was in the file, but there were some times where I just wrote things down from my notes.
So if there's no audio in the file, then you didn't do one?
There was no recorded interview. I just went on the notes from that interview. Yes, sir.
So what you testifying here today from the notes you wrote?
Excuse me?
Are you testifying here today from the notes you took on that interview?
Yes. And when I say notes, the notes that I did, the way it happened is, as investigators do, we have notes, a notepad, and you'll just write notes throughout, over the course of the investigation. I then at some time take those notes and transcribe those to the report.
Okay. You mind if I see your report?
Yes. Those would be the 2 pages from that time frame.
So those are not recording anyone's exact words, correct?
No, I just gave a brief synopsis. If you read these notes, you'll see there's just a synopsis of what they said to me.
Okay. And we have no way to check to verify if that's what she actually said.
What's that? Who's that? I'm not sure who you're talking
So
about.
you interviewed Kimberly, correct?
Yes.
And all we have from that interview is your written notes on it.
Yes.
So we have no way to verify that that's what she actually said to you.
I guess that would be correct.
Okay. No further questions.
Ms. Hilton?
Did you have any reason to make up what your conversation was with Miss Kimberly Campbell?
No, ma'am. This was something that I had no reason to make anything up.
Thank you. No further questions.
Mr. McDermott?
No further questions.
Okay, thank you, sir. You may step down.
Thank you, ma'am.
Ms. Hilton, state may call its next witness.
Yes, Your Honor, the state calls Andre Curitan to the stand.
Frank, we'll put those up towards the end of today's lives and we will see. But he has put up for tonight's possible movies, Pledge with Jack Nicholson's or Gift. Both are awesome movies in my humble opinion. So we will look into it. It's also what is available for us and what we can get, because we can't always get every movie. One time.
Thank you, sir. Will you do me a favor, come to the witness stand. When you reach the witness stand before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in. Yes?
He waited a year to report her missing. No, but that's okay. I mean, if you like those movies, we can always, we'll look into them. I am having Chinese food. I'm having lemon chicken. I am deadly allergic to citrus, but this is synthetic citrus on here. The sauce is not fresh, raw. I'm allergic to raw citrus.
Swear in witness.
You swear to affirm the testimony that you're about to give, truth, the whole truth, and nothing but the truth. May I have a seat? Please state your full name for the court, please.
First name is Andre, Andre. Last name is Curitan, Cureton.
And where do you work?
Fulton County District Attorney's Office.
And what do you do for the Fulton County District Attorney's Office?
I'm a senior investigator.
And just describe briefly some of your job duties as a senior investigator.
We mostly, we're assigned to attorneys, anything they need, any evidence to be picked up. We subpoena witnesses and sit with our attorneys as they interview the victims or witnesses.
And are you also required to sit in the trial of those attorneys as a trial may proceed?
Yes.
And have you been sitting in this courtroom for the duration of this trial as it's been proceeding?
Yes.
Right. Now, as a part of your responsibility, you said that you have to meet with witnesses with the attorneys.
Yes.
Do you recall ever meeting with a Norma Patton?
Yes.
Okay. And when you met with Norma Patton, do you recall her ever providing to the state letters and cards?
Yes.
What is it happening with those letters and cards that she provides?
She provided some, no, we made copies of them, or legal assistants made copies of them, so we could have.
And so did she bring originals and the legal assistant all the made copies of the originals?
Yes.
And I'm going to show you what's been admitted at 67, 68, 69, 70, and 71. Are these some of the letters and cards that Ms. Peck provides that you make copies?
Yes, these are some of the ones she brought in.
And then we make copies of?
Yes.
Thank you. No further questions.
Mr. McDermott?
I have no questions for the witness, Your Honor.
Okay, thank you, sir. You may step down.
Perfect.
Ms. Hilton, state may call its next.
But here's my problem. Tonight, I think the Dallas Cowboys play. This chick is going to be watching movie and Dallas Cowboys.
Witness.
You want to stay ahead? No further witness.
No haters.
Mr. McDermott?
No further witness, Your Honor.
Okay. Okay, so that means the evidence in this case is closed. Ladies and gentlemen, there are a few things that we have to take up to get ready for closing arguments and the final jury instruction before you begin your deliberations. And so it's about 10:20. I'm going to excuse you. I'm guessing conservatively about 20 minutes. I'm hopeful that we'll be back in here around 11 just to give you a target for what to aim for. But for now, you are excused. We'll have you back as quick as possible. Thank you.
All right, for your.
So the prosecution and the defense both rest now, but is getting ready to go into closing arguments. Yay! I sincerely hope today we have a verdict.
You may be seated.
I eat so little that we get 2 meals out of every one because I give my son the leftovers. I don't want to insult him by calling him my human garbage disposal, but it kind of is.
So we need to revisit some
I don't
matters
wanna
that we
waste
were dealing with yesterday in order to finalize jury charges. Are there any matters other than those? Are there any matters the parties want to bring to the court's attention that we need to address?
I don't think we have any.
No?
Nothing from the defense.
Okay. So so I have sort of a bullet point list of things that I was supposed to do homework on last night. I have, and so let me address a couple of things. Number one, I have looked at the request from the defense to provide a charge on immunity of a witness. I think that the better course here is to not give it. It's not directly implicated by the facts of this case, and the defense doesn't need it to make the argument that it wants to make. And so I'm not going to give the immunity charge 13180.
That was that right there. They made some big wins here. But real quick, Christopher Wolfenberger's in a wheelchair due to undisclosed medical reason, which has not been publicly detailed in court filings or media coverage. So nobody knows.
Mr. McDermott, you asked me to adjust the circumstantial evidence charge to change the word theory to the word hypothesis. I'm not going to do that. The pattern is the pattern, and I believe the pattern is there because theory is a more accessible plain language word than hypothesis is, and that's why it's been changed. And so we're going to stick with the pattern. I'm not going to give prior difficulties charge. As I consider it legally, I think there is a conflict in, I cannot find case law, and if you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case. And I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for a directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine that a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that I don't believe that there are facts from which the state could present the count 2 felony murder, which were.
That is a huge win, y'all. That is a huge win that the judge says, while I agree again with the state that there is evidence here from which either fact of reasonable inferences from which reasonable could determine that homicide occurred, but she does not believe that there are facts from which reasonable fact finders could even make a reasonable inferences that a weapon was even used at all or what kind of weapon. So that's a huge win for the defendant.
Requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder. We also need a redacted indictment reflecting only that one count of felony murder. what record would anybody like to make regarding that ruling? Mr. Wilson, you're standing.
I would, Your Honor. And
Yes, sir.
I'd like you to reconsider it in light of, I did look for some case law, and I thought what would be very helpful to everybody is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition. And what I found was Richardson versus State, and the site on that is 278 Georgia 548. And it says that if there is evidence of an act, the jury can, and remember, we're dealing with the standards for directed verdict, whether there's a reasonable path for a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294 GA 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence, and that's what we had from Dr. Terry.
Right.
And that was acceptable, and I believe, and that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick, Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is a directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before. He'll do it to her, he can do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on this cycle of violence and what happens. Your Honor, there is a path, and I understand where the court's coming from. But I think when you allow intrinsic evidence that can be used for any purpose, that's what the question is on a directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault. And this is why she died. And that would bring it in directly with the case law. So that's our argument. Your Honor, I think the court should reconsider its motion, or its ruling on the motion, and allow this case to go to the jury, because I think there is evidence. And I know the court was struggling with that extra evidence, but it's there.
A couple of questions. One, I was able to pull up the Courier case. I'm not, the first case you gave me, I don't know if I've typed it in wrong or wrote it down wrong. Can you give me that site again?
Sure can. It's 276.
Wait, say it again?
276.
276.
That's what, I think we all wrote down 278, or at least that's what I wrote down. 276, Georgia 548.
Yes, ma'am.
Thank you. I will tell you, one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered and in a decomposed state, which is evidence from which a jury could find that aggravated assault, of which there was evidence, caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
Well, and I think when you, like I said, when you allow intrinsic evidence, is there a path? That's the thing. Is there a path for a reasonable jury to conclude that violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not really the relevant factor. Is there evidence? And I think Richardson talks at that, and I think Courier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to, and given the standards on a directed verdict, Could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma. That's, again, factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts, from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred. And so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your Honor, I'd
further
also
defense?
point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40. What I need to do is I'm going to, as I said, edit the verdict form. I'm going to email y'all in just a moment. I'll probably have my staff print a final, or more final, unless y'all tell me there's something else to address.
Okay, so now we're going to go into the jury's coming in. We're going into closing arguments.
Specifically to make its closing argument.
Thank you.
And please stay on a microphone, which he will not be doing. So yes, we're going to be dealing with the lack of microphone.
So what's being depicted now is one of the first exhibits that we introduced. That is a photograph of Melissa John Wolfenbach. That's a photograph that was taken somewhere around 1997, a year before Melissa went missing. In 1998. We know that in 1998, she was 21 years of age. So she's roughly about 20 years old at that point. And even though she hadn't gotten a chance to live a very long life, she was a mother at that point. She was a wife. And when I see that photograph, I see a smile, but I also see hope. I see hope when I look at that photograph because of what she must have thought about her children, what she hoped for them, the life that she hoped to live. And I think about the 27 years that has passed and how long that is to wait for justice. So that 27 years, that's a long time to experience life. That's a long time to fall down and get up, and fall down and get up. That's time to experience and have memories with your children. Children that don't have a memory of Melissa, not Joseph, not Christina. That's an opportunity to have and create memories with your grandchildren. That's 3 grandchildren that you heard Christina testify. She's got 3 boys. There's opportunities. That's what was missing. That's what has been missed. That is what has been taken away from us. The opportunity to have a life, to have those experiences. And she deserved that, even if she didn't want to spend it with this defendant. Even if she wanted to leave him, she still deserved to have the opportunity. She was manipulated, she was intimidated, she was abused, and she was coerced to give up her children. I believe that's what the evidence shows. I can tell you, 27 years later, I would not expect a judge to allow a defendant that had battered his wife to be alone with them and speak to them 6 days after it happened. Roughly 5 to 6 days after they went down to apply for a protective order. 5 to 6 days after the order, and had no contract was in place, the judge lets her speak alone with him. And then on that very same day, I want to dismiss. On that very same day, children go back with mom. And we don't know what was said. We don't know what was said then. We don't know what he said to them. We don't even know if the bruises that were on her from his attack on July 21st, 1990, we don't even know if those had fully healed yet. I can assure you the mental and emotional trauma from that happened. Having to call the police. After a period of time in July, we know she had already been abused and experienced abuse. So when we think about domestic violence and we think about being intimidated and coerced, that's what I want you to think about when we look back at that day July 29th. I believe that it shows that she was intimidated. She was able to be coerced, especially after being beat for a year by this defendant. And I don't believe that she ever intended to give up her children and walk away from her family, her
Your
children.
Honor, I want to object to counsel's repeated use of "I believe." I can assure you, counsel is not supposed to interject personal opinion.
Understood. Mr. Fawcett has offered to rephrase. Go ahead.
Now, the indictment you'll get will have one count of murder, for the malice, murder, the intent to kill, was Don Walker. And this is why we're here, from what was found on April 29th, 1999, and June 3rd, 1999. Skull of Mr. Walker Martyr, his job, within that same vicinity.
Y'all, I don't know what they just did, but that's on them and I can't fix it. I'm sorry.
And a minute from the residence where Christopher Walker Martyr and Melissa Walker Martyr lived. And your judge is going to instruct you that you are duty bound to follow the law, and in your consideration of the law, you should consider certain things you should not consider, such as sympathy for either the victim in this case or the defendant, disagreement with the law, conjecture, dislike of the system, television, public opinion, penalty or punishment. The only thing that you are to decide when you're considering the evidence is whether or not the state has met its burden beyond a reasonable doubt and prove the guilt for innocence of the guilt of this defendant. You should consider the elements of the crime, the law which the judge will give you. You oath that you take as yours, facts the case as presented in the form of testimony, video exhibits such as the video of the defendant hiding, audio exhibits such as the audio of the defendant stating that you have looked for, acknowledging that he took assault, also acknowledging that she was dating someone and seeing someone and staying with someone they might. You also consider the credibility of witnesses. What was it like when they were testifying? How did they answer the questions? You are entitled, you're the determinant of the credibility of not just the state's witnesses, but also the witnesses that the defendant called. You all consider what the defense is. Now, the defendant doesn't have to present any defense. Walk into court Tuesday, Wednesday, say, hey, make him prove it. But that's not what happened in this case. The defense in this case is Carl Patton. Listen to the theory and open statement. The defense in this case is Carl Patton killed Melissa Walker. Other than the fact that evidence came in that Carl Patton committed murders, what other piece of evidence or fact, anything that you heard during the course of this week, what points to that? What other fact would allow you to create that evidence? Other than the fact that he killed someone, the evidence came in that Melissa didn't even know about it. The only thing that's come in about the relationship between the Pattons and their children is that they appear to love each other. That's not so unbelievable. Based off of the letters that Melissa wrote, cards that she wrote, times that she wanted to take her father, Carl, and her mother, Norma, out to lunch. Those are going to be back in the room if you do observe and look at while you deliberate. This case is just simply not about Carl Patton as much as they want it to be. This case is about domestic violence. This case is about intimidation. This case is about loss of control. The loss of control that this defendant had over the custody of his children and over Melissa. No matter how much they want this case to be about Carl Patton, this case has nothing to do with Carl Patton, other than the fact that he asked law enforcement to find his dog. Why does Norma go to the residence of Kathy Wappenbarger looking for Melissa, raising attention to that issue if they're responsible for it? Now, a lot of facts have come to evidence in this case. I would ask you to put weight on more facts, the facts that have been corroborated, like that. You heard that from Norma. You don't have to just take Norma's word for it because you heard that from Christina. She does not have a lot of memory from her childhood. She doesn't have a memory of her mother, but she remembers that day. Because that stood out. Where's my daughter? I could just imagine how that was. It wasn't a calm statement. It was screaming, where's my daughter? Norma probably showed up to that residence of Kathy in a panic. Where's my daughter? That's something that Christine will remember. And that's why you should believe that happened. And that's why that theory is just plain ridiculous.
I fixed it.
Most importantly, common sense is the main thing the graph was used inside of this case. What does the evidence tell you? What the facts tell you? What's been presented? Judge is also going to charge you on what reasonable doubt is and what it is. Judge is going to charge you that the state is not required to prove the doubt of the guilt of the defendant beyond all doubt for mathematical certainty. Reasonable doubt is doubt of a fair-minded and impartial juror honestly seeking the truth. Is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, like Carl Patton. A arbitrary, not supported by the facts. Thrown out, hoping to stick on the wall. Evidence may be direct or circumstantial, or both. Consider the evidence you may use your reasoning and common sense to make deductions and reach conclusions. May be direct or circumstantial. Direct evidence is that which may be seen or heard, otherwise direct sense. So when Christina says, I saw Norma show up to the residence in a panic looking for her daughter, that's direct evidence of her observations. And from that recollection, the testimony of Norma, you can infer that.
Guys, they only have one feed that's going out of there, and all of the media's use that single feed, and it is being provided by Court TV. So nobody else can do anything about it, and even Court TV can't do anything about it because they're not on the microphones.
Norma was sincere when she was looking for her daughter. The types of inferences that you can infer from the facts that have been presented. And then we have the circumstantial evidence. This is exactly what I was referring to. We got direct evidence of tool marks on the bones that were recovered and identified as the remains of Melissa Walkenbarger. Tool marks are direct evidence. Those observations, you'll have those that you will be able to review and look at quite deliberately. We also have direct evidence that the defendant was in possession of assault. Two separate facts. Now we wouldn't walk into court on Wednesday and ask you to convict because there are tool marks on the bones and remains of Melissa Walkenbarger. And we wouldn't ask you to walk in here on Wednesday when we start presenting evidence and convict this defendant of murder because he was in possession of assault. And you draw logical, common sense conclusions. That's just one piece of the evidence that has been presented, but you were able to do that. We have saw around the same time that the wife was missed and the wife's remains were located. The medical examiner says there's the assault that we presented as Exhibit 66 is consistent with the type of marks that he made by that instrument. And in his own statement that he was in possession of it around that time, and in the statement of the box, although they were reluctant to say so, that they never got that saw back. We would not ask you to convict solely based on that fact alone, but that is a fact that you can consider, and those are inferences that you can draw. Reasonable, common sense inferences. So this is what I saw when I woke up this morning. I probably see this a lot more than most people, but when I woke up, this is what I saw. And I had time, so I stopped by to get some gas. And by the time I finished, I got back and I cranked up the car, and I'm back on forward. So I never saw anything going to my vehicle. But during that period, I smelled what appeared to be gas because I cut grass, I smelled gas. There's less money in my account. The numbers on the dial, I hear a clicking sound. And so, even though I never saw any gas going on my vehicle, there are logical deductions and conclusions that I've drawn from all those facts and circumstances. Nobody's going to be able to come and tell me that Santa Claus put gas in the vehicle. So when we ask you to use your common sense and look at the facts, the evidence is what it says. The facts are what they are. In the count of murder, you'll get the indictment. You'll see that it's charged that the defendant with announced court call and cause the death of Melissa Walkenbarger by inflicting homicidal violence. Now, as it's charged, that term homicidal violence, based on the manner in which the remains were recovered, it is impossible for the medical examiner to determine if she was shot, if she was strangled, if she was stabbed, any number of ways that you could commit a murder could have been committed to Melissa Wackenbarger. But you can't tell if someone has been strangled if the neck is missing. You can't tell if they're stabbed or shot in the torso if there's no torso. And what we're able to determine based on the testimony of the medical examiner is that the facts and circumstances which he observed is how the remains were located, the history and evidence of domestic violence in that relationship, the fact there's evidence that someone removed her limbs with salt. All of those facts, and the fact that her testified in her medical examiner, she did not believe that Melissa Wackenbarger died of natural causes. All those are facts that point to homicide violence. In her opinion, was that it was more likely that Melissa Wackenbarger died from homicide. That was her opinion. And that's why the indictment is charged like that, is because of how she was found. But that does not take away from what we have proven based on the testimony. And that is that she died from being murdered. That is called homicide. Just going to charge you with law of malice. It is not guilt or hatred. It is just simply a killing without justification, excuse, or mitigation. It can be expressed, deliberate intention to unlawfully take a life of another person. It may be implied with no considerable provocation appears in all the circumstances of the show and abandoned in the living part. I submit to you the facts and the circumstances of this case, and all the facts and circumstances of this case point to that conclusion as the only reasonable conclusion that this defendant did in fact commit malice murder on the person of Melissa Wackenbarger. The state does not have to prove premeditation to prove murder, regardless of how briefly that malicious intent existed. Malice may be formed in an instant. And if malice was in the defendant's mind at the time of the killing or act, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive admitted for use to determine the defendant's state of mind at the time of the killing, you are allowed to consider it, such as the evidence of domestic violence is lawful evidence of motive. Did he abuse her that year? Did he hit her? Did that happen multiple times that year? That's what the facts are showing. You can use that and those facts and the expert testimony from the domestic violence expert as evidence of the defendant's motive. And all of those things I previously mentioned, the fact that there's an open criminal case that she wasn't able to appear to. The fact that she was seeing someone else, the fact that she planned on leaving, that she had continually left him throughout that year. All of that is evidence of motive. Judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. There's no legal requirement of corroboration of the witness, provided you find the evidence to be sufficient. That means if, when you heard the testimony of Christina and you believed it, you don't need any corroboration for that to be a fact that you consider. That means if you heard the testimony of Christina and you believed her when she said to this defendant, we always talk about going around. When we talk about, you know, how to get rid of everybody, who says that to his daughter, considering how her mother was found. And that's after she says that after Melissa Wackenbarger's remains have been identified. He makes those statements. That's what she remembers growing up. Does that? This defendant. This case went through several detectives that basically continued to work on this case. Detective Calhoun and Detective Shepard. Even through the retirement of Detective Calhoun, he continued to work with Detective Shepard until the cold case unit was created. And then 3 years later, you have this indictment. So from Detective Kelly, when we're talking about just skull is found, to the point where Norma Patton goes to Henry County, and Detective Stott really is the first investigator that starts to really investigate and look for Melissa as a missing person in Henry County. He wasn't able to get a lot of traction with the Atlanta Police Department at that point in '99. We have Detective Stott, who interviews the defendant. Back during that period, it's before 2003, he says, March, April, '99, last time he saw her alive. And you have Detective Calhoun being assigned the case in 2003 when her remains are identified, was assigned to do some additional testing. And Detective Scott testified that he was one of the first persons to begin the missing persons investigation. And that's when the defendant, when the interviewer told him that last time he saw Melissa was in March of '99. And we know that from the subsequent statement in 2021, when he met with Detective Shepard, that's not exactly what he said. He says, go around December of 1998. The only difference between when he makes that statement before 2003, that he saw her in '99 in March, and in 2021 is Melissa's remains have been identified. We know that the remains were located right by his job. And I submit to you that there's a reason why those two statements are inconsistent. That's his mind. Detective Scott only spoke to the defendant. Once the remains were identified, the defendant once the remains were identified, and also began to look into the history. Because the first thing they do in homicide investigation, they look at what was the victim's life like. First thing he saw was there's evidence of domestic violence. And what also stood out is the location of where Melissa's remains were found. We know that from the testimony, Melissa and Chris, the defendant, lived in this area by North Line Street. We know that Action Labs is right here. And here's the junkyard. So we know that the head was across the street from Action Glass, and we know that the extremities are virtually right next door to Action Glass in this wood area. So make no mistake, everyone's a suspect, but at this point, all of the evidence is pointing in this direction, at this defendant. What is the evidence against this defendant? So there's a timeline of abuse in this case that's presented. We go back to the beginning of '98, you know, the testimony of China Patton that Melissa started working with her. It was Virginia Highland Waffle House somewhere around the end of '97. They were working together sometimes on the same shift at the beginning of '98. There was one point when China remembered seeing marks around the neck of Melissa Waffle House. What she described appeared to show marks of someone's hand around Melissa's neck. Immediately, the officer defendant went after the front. And that's when he got into the altercation with Troy Clinton. That's what you heard from the testimony team. And that's the beginning of 1998. When we get to July of '98, and so this is what Detective Calvin is looking at as he's beginning to investigate the case. He's looking at the location of remains and where he lived at, his job, and he's looking at all this information. All the evidence is pointing at this defendant. There's a police report that's created where the officer observes bruising and marks on the person with his walking marker, Melissa. After that, he directs her, the defendant is there. He doesn't wait around. After that, he directs her to go for him, take out a protective order, get you some protection from him. And that's exactly what she did. She went down there in person and applied for a protective order. So those are the records that Detective Calvin had access to. This is a day after that July incident, July 21st. So the next day, July 22nd, she goes to the courthouse and petitioner seeking relief.
Are we on the Waffle House again? What's that? Waffle House picture? I can't see what that is.
Family violence. From him. That's what she was seeking relief from. She was seeking relief from the choking that she had and her sister observed, that Troy told him about. And we had that rule 9 side setting down for this one act, and then we have that where the judge allows her to speak with this defendant. Just days after that. Days after her hair being dragged and pulled. Days after she's been hit. And then that happens. It wasn't just what China said. It wasn't just what Marlon Sutton said about what he observed. There's another person who saw that abuse. Dorothy Jones, Cooley Jones, Dorothy Cooley. She lived in that area. She had known the defendant before she met Melissa. and remember seeing a day where Melissa had shades on and a black eye. When we talk about testimony of the domestic violence expert about humiliation, isn't that humiliating? Walking around with yet another.
That is so true. That is so true. So true.
Another scratch. Sitting up here talking about skin conditions. That's not a skin condition.
Okay, guys, court's supposed to be back at 12:15. Let's see how timely this judge is going to be. I really appreciate a judge who can keep a courtroom running on time. So we'll see. Right now it's 12:09. We'll see what time they come back. Thanks for listening.
Black eye. You should be offended by them talking about skin conditions and kind of pawn that off as reasons why people saw Marshall there. Tina didn't see a skin condition. These marks from this defendant's hand around her neck, that wasn't a skin condition. That was bruising from being choked. The black eye wasn't a skin condition. You punched her in the eye. It's not a skin condition. Mistakes. All the witness statements line up perfectly on top of each other. The witnesses that observed the abuse during this. This is at the interview. So we go from 10 at the beginning of 1998. We go from Dorothy. We go to July, Officer 7. Then we get to the end of 98, and she's still being abused because she's still going back and forth between Dixon and this defendant. She's still talking about the abuse. This is at the end of the year. Last time he sees her, she's being whooped, intimidated, coerced, bruised, punched, dragged down the street the entire year of 98. And I submit to you, that's not the first year it started. It didn't just start in 98. We can infer that this has been going on for a while, not just 98. Dixon, in front of the defendant, after he came to the White House at the end of that year, you gotta leave. You gotta go. What did Dixon see? Them talking, Melissa crying. Kind of like that July 29th day courthouse. Them talking, Melissa crying. Then we got investigator over here. Her testimony that from the mother. The DA's office went to interview the defendant's sister a year before that happened. He knew from that the DA's office was still conducting an active investigation into the death, murder, disappearance of his missing murdered wife. So make no mistake about it. You know what? That had already happened a year before. He knows exactly why the police are at the front of his house. Oh shit, is it bad? He's hiding for 30, 40 minutes. Come out. He's right here. You don't see the video. There he is. Come out, buddy. Gig is up. He had 27 years. It's up. Hiding. And doesn't it look like what you saw? Doesn't it look like he was playing? It didn't look like it was just, oh, no. It looks like he planned to go there. Got there real quick, went out there. They sat out there for what? I don't know, 10, 15 minutes. It's the police. Go hide. Guilty. Detective Shepard. You picked up this investigation. Got those same suspicions. Got one head. All the evidence is pointing to this defendant. But when did you, Chris? See what he has to say. Let's see if this thing is inconsistent. Well, he admits to being fired because the Rock thought he stole assault. But that's interesting. Admitted that he fired him. That's interesting. He admitted that him and Melissa were having problems. Admitted that Melissa was seeing and staying with a guy named Mike. Admitted that he did not look for his wife. Well, here's the thing. Even if he still has 2 young children, very young children. Even if him and Melissa had plan on going their separate ways, wouldn't you think that at some point each one of you would tell his children he would hurt their mother? Wouldn't you think that? Wouldn't you think at some point, for his children's sake, he would have tried to look for their mother? That is a fact I think you should consider, because you look at all those pictures of Six Flags. What is he trying to say? He's a good father? No, he's not. He look for their mother. You can take your kids to Six Flags every day. That does not take away from the fact that you didn't do what you were supposed to do. One, you should have abused her. You shouldn't have hit her. You shouldn't have punched her. You shouldn't have grabbed her and dragged her. You shouldn't have murdered her. That's kind of good father. And then you had that statement they made, the detective, Detective Shepard, and I want you to hear this. So I'm going to take a moment and play it. I want you to hear this, what he says, those points in particular, what he says about the assault, what he says about his efforts to look for his wife, and what he says about his knowledge that she was going to leave him, the problems that they were having, and the knowledge that she had about these days.
Battery 60%. Connected to PHGL5490 TTHC and PHGL5400 3910.
I mean, before that, I mean, where was she working? At that time, the wall, I mean, like, I don't know, 200,000 or more, she wanted to say. Where she was. That's the last time, around the corner. All right, so when was the last time you saw her? And that's the thing, I don't quite remember the last time was, because I remember, like, she would come and go, okay? And we'll say that it wasn't like, we're happy to go lucky. She's sitting right here one day and she was up and gone. And I don't know if that's the way. So you kind of, would you describe your relationship as tumultuous or like on again, off again? You know, it was rocky there towards the end, mainly I think because it was her family so far trying to get back in her head and trying to make her think things and do things. And like what? Man, she never had a relationship with her sister at all. And then that towards the end, I guess everybody has a need for one. Family, want to love and want that type of thing. I think that's where maybe she tried a little to try to get back with them or to do or what. But I don't think it was near what they made it seem like, that she was there all the time, like she was in cards, pictures. And I remember that did happen sometimes when she did, at the time. But the struggle that we had, we had a common level of what we were trying to accomplish. We had several options in our own, which was to go to California. This is a good way to get that and all. She wasn't coming with my mom. She didn't want more than that. She didn't want her to be raised like she was. There was no, we knew that her age was bad and anybody feeling out there in do. Okay, so when was the last time you saw her? So the last actual time I remember was like, I woke up and she was gone. She woke up another night and she left. And I don't know if that was the last time or the last time when I dropped her off the train that she would work. It was exact. Do you remember telling Detective Calhoun that the last time you saw her, you were driving up to your house on Brookline and saw her walking down the street? And that was the last time you saw her. I don't know what it's saying now, but it's possible. Okay. I just don't. So that, basically, you said that was the last time you saw her, and she said she's going to the train station. Something that, like, I'm not saying we're verbatim, that's what you said, but it was something along those lines. But does that sound like it's accurate? Again, it could be. I don't know. But you remember that incident, or do you recall that happening almost about the home driving up and her walking down the road? Is that ringing bells? I mean, that's usually the way it happens because there's only one way. If there was, she would walk to the train station and try to go to work or something. Or I get a ride, or she, sometimes she just wanted to walk. We're not talking about like train station far away. We're talking about here at the end of the road, right? Yeah, it's in the city, so I understand. But talking about that specifically, do you remember that day specifically? Did you remember one of the? Well, I would like to ask you, what was she wearing? Do you remember? Did she have a purse with her? The last time you saw her, when you
came back home and she wasn't there, where was her stuff? She didn't have a car, she couldn't move, so it was still there in the house.
I mean, if she left it just like that, there's no like this small. I mean, kind of the same thing I did. I mean, when Austin Drive was moved, my grandparents was gonna sell the house and everything. You know, when I left, I didn't take hard enough. I don't live alone. Whatever little.
After the last time you saw her, or back when she left, did you tell her family? Did you tell your family? Did you tell her that your wife left?
I mean, she left many times before that. When she was leaving, I never knew that was the last time I was gonna see her. If I did, I would have, you know, freaking kept her.
After like a month or two, you could think that was.
You know, after a while, I was thinking that she split and moved on. I mean, there was, you know, she was maybe seeing the guy and everything that was up there, or I know that she was living with in Hubert, or no. I can't remember the last one was Hubert, or she told me.
Was she seeing somebody?
I don't know if she was seeing somebody, but there was this dude, and I would say his girlfriend, that sometimes that she would stay with him in like a tiny lodge out that way. And
how did she know this?
She worked with him.
Was it the girl or the guy?
I want to say the guy and the girl both worked there, but I could be wrong. I know the guy worked there, but I know that it was a couple, you know, because then there was one time that they had called me and said that they were moving and she had to go over to something. And she had to do something else.
This was before the last time you saw her, right?
Well, that's
what I'm saying. I'm just wondering.
Oh, that was
I'm not misunderstanding you.
Right.
I'm not trying to trick you or confuse you.
No,
I just want you to remember.
Hey, I'm trying to figure out,
You know, I did over there, I was, so that's why I'm here. I don't know. I just want you to be accurate. All right, so year goes by, you still don't tell anybody that you don't.
I mean, I'm figuring that she's already done. I mean, we were always talking about changing things, and you know, she had the stuff there. You know, and she got to the point where she was unhappy with me. I'm not trying to push myself in anybody's life that doesn't want me there. And I never look at my daughter. Everything's going there. I try to push. And you know, looking back at it now, I was wrong. All the way around with both of them. Maybe I shouldn't try to push forward, try to do it. But
You said you lost your job, your job, the last time you lost your job.
man, this guy, now, there's a lot of things going on right there with that. But, and I do now the same thing pretty much I did then. I mean, I work on both players and things on the side. And there was a guy that I don't know who stole things. There was a saw that was missing. And I can tell you the exact guy that I borrowed this tool from everything to, I didn't steal their saw. Period.
Why did I?
Because he said I stole a saw. Because the saw was missing. And I lived around the corner and he drove past my house and he seen the back of the boat player on the top of the saw.
So he thought you got something off the car.
You know, and I thought, look, I don't know anything about it. You know, and then there was that, and then there was something where I drove through the toll plaza thing on 400. You know, there was just a bunch of little things that was just last right. You know,
Hello.
you know, there used to be a thing where you go through it. You know, and I was going to understanding.
Yes.
I was going to understanding that, you know, the
You want to stop? Donna Adelson coming back in a minute. Oh, actually, right now. Hold on. Donna Adelson's coming back right now. Let me see what the judge just said. The judge was on the bench. I got Miss Lovely Diane on the phone. Diane, are you going to hop in?
Yes.
I sent you the code already. All right, bye. Oh, okay. Well, he just hopped up and hopped down. So, okay. Now I need to reconfigure all of this. And give me a minute because I got to reconfigure all of this. This is frustrating. It's a little different from here. I'll get it to work when she hops on.
Right. Yeah. Well, we didn't do it. And, you know, if someone's everywhere, I got it several there, but I did the last shot. Did
you ever go up to the Waffle House and get an altercation in the mail?
I don't remember. I saw that on the internet. I don't remember that.
Guys just came up there and beat you up.
It seems like I would remember that, but I don't know.
You got a yellow Volkswagen?
I never had a yellow. What?
You never yelled at me.
I never.
Diane, I would interpret this. It's pretty loud. It's pretty horrible audio. I'll be honest. You may need to get your ears in. How
Okay.
you doing, beloved?
I'm tired.
You've lost weight.
Have I? I don't know.
It's been that long, or it's been that long.
It's possible. It really is. In Alaska, it was get up and go, 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 go. Hi, Tank. It was. But I did not realize how bad I needed the break.
Okay, we're everybody's going to ask update on Margie.
Okay, so let me give that. You know that she went back to the hospital, and it was a good thing that she did.
While you were gone?
No, before I left. She came home on Sunday. Got home. We got her home about 1:30. On the sofa, she laid down and she stayed. She drank. She ate some soup. Did nothing. I continually asked her, bathroom? Nope. You okay? Yep. 4 in the morning, came out, checked on her because she wanted to stay on the sofa. You okay? She said, I don't feel good. Call 911. Did not waste any time.
Wait, do you have something planned on your end?
No.
Okay, never mind. Sorry, it's on my end. I got it. Go ahead.
So anyway, 911 came, took her to the hospital. They did some tests, said, good thing you brought her in. Her kidneys were messing up. And so they admitted her. She was there. And that was Sunday. I left on Thursday. So she stayed in the hospital. They moved her 3 days ago to a different rehab in 45 minutes from here. But they are already being a good rehab. And they are trying to get her on Medicaid because the other rehab used 8 of her days doing nothing. She only gets 20. No, they used 12 of her days. So she will be finished there on the 26th. So, but if Medicaid accepts her, she can stay without me having to pay $200 a day that I don't have, that she doesn't have. So if they accept her, then she can stay. It means they're going to take all of her money, except for $30 for spending, but she's not going to go anywhere. And I told her, you cannot come home until you can use the bathroom. You can, walk and, function. So anyway, and she understood, she agreed. So we'll see what happens. But she is doing so much better. Long story short. Sorry.
Thanks. I hate to do it, but Donna Adelson's, they're getting ready to come in. Let you know where we are. Oh, thank you, Miss Evion. Oh, thank you, Miss Erin. Thank you, thank you, thank you. This is Donna Adelson, Adelson. This is, we are on our 4th witness. We will be, what's the word I'm looking for? I gotta shape this a little better. We are going to be, there we go. In court for the next couple of weeks. So I appreciate you being here. All right. So
I plan to be here hopefully every day. Right now I have nothing. So
Okay,
pray.
great. Oh, sending you so much love. I'm glad your sister's better, Diane. Hope it works out all right.
Yes.
Just so you know, okay, what we're gonna do is I do need to have a one-on-one when we're done with trial today. But because we got my college starting Monday, we got a lot of changes. We're closing the shop. I'm having to move this weekend. It's a lot. I got to go over with you. But the good thing is we got this trial, and so yeah, I will let the deaf people know that you're back and we're ready to rock and roll. I've been having a lot of joint pain, so I'll help you. Just let me know. Okie dokie, here we go. Let me see if I can get. Donna Adelson was just told she can't quiet. She was crying and getting all emotional in trial, and the judge warned her.
Go ahead.
Break the defense advised they've got some objections to my exhibit.
Can you hear it okay?
Next witness, to exhibit 64.
Can you hear okay?
I think so.
And I haven't had time.
The sound has been horrible.
All the ones they're objecting to, but I know the first one is marked as State's Exhibit 64A.
Okay.
This is an email initially from Donna Adelson to Wendy Adelson, and Wendy replied March 28, 2011. It includes content in paragraph 3. This is a discussion of Dan and his parents attempting to spend time with the kids, and knowing that is to Mrs. Adelson. You can read what it says. Defense is objecting to that item. Relevance grounds. Relevance is that Mrs. Adelson hated the victim, and that hatred extended to his parents as well.
Ms. Fulford?
This is while they're still together, Judge. This is 2011. It has nothing to do with Danny. It was a derogatory comment made by my client regarding Danny's parents. Wendy made comments, and Mrs. Adelson made comments, and they're not relevant to this case. This is while Danny and Wendy are still together.
As to whether your client had any animus towards the deceased, is there a time period where it has to be within the divorce?
It's not animus towards the deceased. I'm talking about the comments towards his parents.
Kappelman, as it relates to the comments going towards the parents.
It's relevant, Judge. Goes toward motive. She did not want these children to be with the father and with the father's family. She wanted them with her and her family. And that's what happened.
That's not what this email says.
Right. That's not what the email said. It's not a confession to murder. It's a expression of dislike, which just goes to the motive.
All right. Much of this email does lack relevance or probative value for the jury. However, Ms. Kappelman, does this tie into other messages which otherwise would demonstrate the motive you're trying to prove? Or is this a standalone item?
I mean, there are other emails that express similar sentiments. I don't think they're specifically tied to the visit that's referenced in that particular email.
Are you arguing then that the defendant had a consistent animus towards the deceased?
Oh, yes.
Very well. Over objection, I will permit it only on the grounds that it shows that the defendant had a consistent animus towards the deceased or his family. However, if the defense is asking for a limiting instruction as to this evidence, you may request it now.
We're asking, yes, we would ask for a limiting instruction. This is not directed towards Danny Markel. I mean, if you take a look at it, Mrs. Adelson is complaining that Danny and Wendy have to schlep the boys down to see his parents instead of them driving up to see the boys. It has nothing to do with trying to keep the boys from the family. So I'm not sure what limiting instruction would be effective, but this is as to, it doesn't express any animus to Danny. So I'm not sure what the court would suggest.
His family.
The state's theory is not hatred towards Danny Markel's family. And so I'm
Ms. Kappelman,
confused.
as to the state's theory, please clarify this issue.
State's theory includes that Mrs. Adelson hated all things Dan Markel, and all things Dan Markel needed to be erased from these children's lives, including the grandparents. Now, I know Your Honor has precluded me from mentioning visitation with the grandparents and things like that, but obviously that's always been a part of the state's theory, and I understand that I'm limited from including that, but it is important to show that this animus existed as far back as 3/28 of 11. And this is the first item in the exhibit because it goes back the furthest in time. I think it's important.
We're not going to be wasting a lot of time on this back and forth. This is the point of pretrial motions. On this point, as it relates to the state's theory of the case, that the defendant had animus towards the deceased or his family, it will be permitted on those grounds. If the defense is asking in some way for a limiting instruction to be given, please request it now.
Yes, Your Honor.
What is the limiting instruction that is requested?
Your Honor, I'm at a loss. I think that an instruction that, I mean, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously I disagree with the state's argument concerning this. So I'm open to suggestions.
Be considered for the defendant's state of mind as it related to the deceased or his family.
I would ask that it be related to the deceased's family. It's not to do with the deceased.
Ms. Kappelman. Well, down. Let's go through them.
Yes, sir. State's Exhibit 64D is an email dated 10/26/12. May I approach?
You may.
This email is from Donna Adelson to Wendy Adelson, showing her a list of prospective love interests from the website Mrs. Adelson has identified as potential matches for Wendy. It's offered to show how controlling Donna Adelson was over her children's lives, how much she inserted herself into their private lives. And again, She likes to be in control of who they date and who they marry.
Isn't that every Jewish mother?
Response.
Judge, this is not an email from my client.
Did I say that?
This is an email from match.com to the email address that my client has. It doesn't say anything, the copy I have at least, doesn't say anything at all about Wendy Adelson.
Okay, I'll replace it with a copy that shows the email heading on the top, Judge. It's my fault.
And this was her forwarding this or actually including some sort of message?
She forwards it. I'm not sure if she included a message. She definitely did on the next one, which is also subject to defense objection. It states Exhibit 64I. I'll approach with that as well. Related.
What's the date on that?
The date on that is that one.
1/17/13 today on Exhibit 64I.
As to any questioning of Wendy Adelson as the role her mother played in her life, including screening potential romantic interest, that question certainly can be asked, but as to an exception to hearsay, what is being offered concerning this?
The relevance of it?
Who is that woman? Is that the mother of the
What's that?
victim?
Statement of a party. Relevance is that Mrs. Adelson was very controlling and micromanaging of their children's lives, particularly their love lives, which directly relates to the motive to this offense.
Right.
Eliminated Mr. Markel. You get the idea.
I just can't understand how this would be material to this case in any way, anything that the state has to prove. That, you know, it's not, we just want to bash her reputation or what she did. They got to prove criminal offenses against her. How does her being on Match.com while she's living with her daughter have anything to do with something the state has to prove here? Nothing.
I believe this once again goes to the issue of motive. I understand the defense's position that you disagree. As to this motion, or excuse me, as to this item, this is 64I.
64D and I, Your Honor.
Right. As to whether the defendant in any way possessed a motive concerning Wendy Adelson, or excuse me, as it related to the deceased in controlling who Wendy Adelson may have sought as a romantic interest. Ms. Kappelman, do you have other evidence that's going to tie that to this particular item?
I do have other evidence that Mrs. Adelson, just on the wire, speaking about Wendy's love life and her current love interest and who she wants her to date, and discussing with Charlie Adelson, wanting Charlie to intervene with Wendy and encourage her to date a certain person. So I do think it is a theme that reemerges with other evidence.
Well, as the state of mind and motive, I will permit this evidence to be given over objection. However, as to the foundations for these things, Ms. Kappelman, they'll have to be laid through the appropriate witnesses.
All of these items came from a search warrant executed on Wendy Adelson's Google account. The next item, Judge, is just a moment to locate this. I believe it's 64 RW, an email dated June 27th, 13. And the objection in this case relates to the characterization of Judge Hobbs as a, can't find the quote, but something like a Southern black lady. They just were proposing redacting that. Find the page for your honor. Page 2 of that email. I'll give you 1 and 2. Second page, 2/3 of the way down in the second paragraph, mention of Judge Hobbs. There's no particular relevance to that characterization of Judge Hobbs, so I just don't think it's prejudicial, so I don't know why we're redacting. Whatever your honor thinks on that one, Judge.
I believe the jury could take that as in a very derogatory way. It has absolutely nothing to do with this case, that comment. Nothing. Unless there's another motive I don't know about.
If in some way, since we do have 2 jurors of African American descent that would otherwise impute on the defendant a negative character trait, I will permit the redaction for that reason. Beyond that, the item will be admitted.
Next judge is an email dated April 7th, 2015. I believe what's referenced here is 64HH.
Why did it pause? Did it pause when I left?
This email is an email regarding Wendy moving, and the evidence is going to show that she moved from a more secure location to a less secure location. So the relevance is sort of going to have to be developed as the trial goes on. But the idea is that there was no fear for Wendy's safety. That email is dated
7/15, I believe, is the last date in the chain.
Thank you.
If you have to start the foundation with one witness but enter at a later point, that is certainly appropriate. What is the objection?
Well, Judge, I have a question. The email that I'm looking at that was provided to us on July 15th, 2014 is to Jeff Lacoste from Wendy Adelson.
I believe these are from David Trafton at MiamiRealEstate.com.
That's not what we're given.
Can I show the exhibit to the test?
Please do.
Ada is myrenvinsday.com, a dating site. What is it?
Yes.
Okay, that's all I needed to know.
Yeah, it's a dating site, and my second game. So I had.
Email that we've been handed is April
Tell you
7th,
later.
2015, 4:42 p.m. This is regarding Wendy moving. It had the same security as where she was living with her mother, so less secure. There's nothing in here that indicates that.
I'm gonna ask Ms. Adelson about that. My understanding is it is less secure. They're asking lots of questions, but they're not about security. They're being actively extorted on their threat for their lives. One would expect and would inquire about such a thing.
You may lay the foundation, or at least begin to lay the foundation for that item with when that witness is examined. Going back to the last trial in this matter, when the intent instruction was given, the intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case.
Ada, can you do this?
Specifically,
My hands
as
print.
counts 2 and count 1 that are charged in the indictment
Right back.
deal with matters of intent. I'm going to find evidence that demonstrates the defendant's alleged motive, which goes specifically to intent, is admissible. One thing, though, that is starting to trouble me with those. We had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were provided with, I went through thoroughly and had all of my objections listed. And then was told that's not correct. It's another binder. It's different emails. The binder I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibit you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to waste the jurors' times. At this point, we're 30 minutes behind where it should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016. And it's an email about whether one of the children is sad.
64II, Judge, is an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father. Extremely relevant.
Its probative value is outweighed by the undue prejudice, Your Honor.
Okie dokie. Hey, Matt, come here for a sec.
Compliment again, the purposes of being offered for is going to motive or state of mind. What is the undue prejudice that the defense is arguing concerning this particular email?
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing is her time with the child, and she hasn't seen him sad. And it's 2 years after, unfortunately, Mr. Markel was killed.
Cattleman, if you wish to proffer the testimony from the witness on this, I'll allow you to do so at the presence of the jury, but this one is seeming a bit attenuated.
Mrs. Adelson.
In commenting on how the child is
Sure, Judge, but it relates back to the motive and thinking that it wouldn't harm the children. It was going to be good for the children to get rid of their father. Children have no memory prior to this young age that the father was killed. I think it goes to motive, Judge.
that. I'll allow you to set up your foundation within parts if you need to do so. I'll revisit whether this item can be admitted at that point.
Sir, there's one item that I've added today in light of the opening statement regarding Mrs. Adelson's use of the Skype to facilitate visitation with the father, stated December 18th, 2013. It has been previously provided. It's now marked as State's Exhibit AA.1. While the defense is looking that over, I also have a stipulation of the parties may approach.
Okay.
This will be the first thing. I'd like to have your honor read this to the jury as soon as they come back in. Sorry, Judge, I handed them the wrong thing. I'm gonna have to circle back to that. With that, stipulation, we're ready. No other issues.
Right, as to 64, I believe D and I did rule over motion that these can be admitted with a proper foundation. As to I believe that's the item that the state is going to, 64II, I should say, that's the item the state is going to attempt to lay the foundation for as it relates to motive in this matter.
Yes, sir, I found the relevant portion. It reads from Donna to Wendy here. I'm sorry, from Wendy to Donna. Dear Mom and Dad, here is the phone/Skype plan for the holidays. And she's forwarding a Skype plan from Dan Markel. Please help me do this. It means less stress for me if we just follow it.
I don't know what the relevance of that is. Wendy Adelson sending an email to her mother because her mother takes care of the children very frequently and saying, here's the schedule. Let's do this. It doesn't say Mrs. Adelson has not done it.
I think it suggests that Mrs. Adelson has not done it, or at least that there's been issues and problems with Skype and facilitating Skype is satisfactory to Mr. Markel. So I would ask you to admit it based on the statements made in the opening statement by the defense.
With this wind static, I can't hear well enough to interpret this. I'll wait for Diane to get back.
Well, the opening statement is not evidence. The jurors are not considered as such. As to any foundation that you wish to lay for that particular item, that it was not previously followed, and now Wendy Adelson sent that item to her mother, you'll need to establish the foundation first before it's offered. Please bring in the jurors.
Okay, so they're trying to bring in let's just kind of come all that up.
Limited instruction will be given.
That there was an email talking about the children being sad. They want to admit, but the defense did not want it. The judge is saying yes, only if you lay down the foundation before giving that information. Yes, we're weird, K-Swan. Okay, guys, while we're waiting, I'm going to mute this. I just can't handle the noise. What I kind of mentioned to June, and I don't know if she saw it. Mandy, sorry, Tinkitude, just go and right click on it and just say leave group or delete. I don't know what that is. I don't even see that. That may be between you and me. Let me see. Oh, I didn't mean to do that. To do that. Oh, that's a private chat between you and me. Man, we got some people learning Discord. So that's between you and me. Leave it alone. That's private chat between us. I have one for each of my mods.
Zoom with the evidence this
Good.
afternoon. I'm going to read to you a stipulation that has been agreed upon by the parties. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the projectiles contained in State's Exhibits 122 and 123 were examined microscopically by a firearms expert from the Florida Department of Law Enforcement and were determined to have been fired from the same revolver. Ms. Kappelman, you may call your next witness.
Thank you, Judge. The state calls Craig Isom.
Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. Please speak loudly and clearly for the jurors.
He's a big man. The chair is not a good
Introduce
one.
yourself and spell your name.
Craig Isom, CRAIG ISOM.
How are you employed?
I'm currently retired.
Congratulations. Where did you work when you worked?
Sent to Tallahassee Police Department,
How long were you with the Tallahassee Police Department?
28 and a half years.
Were you assigned to investigate the murder of Dan Markel?
I was.
How long did Dan Markel live after being shot?
I believe my understanding was around approximately 11 hours.
As part of your investigation, were the people closest to the victim interviewed,
Yes,
including his ex-wife, Wendy Adelson?
yes.
When and where did you approach Wendy Adelson?
She was at a restaurant in Tallahassee on Market Street.
What date and time did you approach her at the restaurant?
That was on the day of the shooting, which was July 18th, 2014. July 18th, 2014. It was approximately 2:15 in the afternoon.
All right, so approximately 3 hours and 50 minutes after the shooting.
Approximately, yes.
What did you say when you approached her?
I told her that I needed to discuss something with her in private. She was with two other individuals at the table.
Two ladies having lunch?
3 total, yes.
All right. And when you told her that you need to speak with her, were you wearing police insignia? Did you identify yourself as law enforcement?
Immediately before I identified myself and said that I was there for the purpose of speaking with Wendy Adelson.
Okay.
And I had my badge on that was readily identifiable as a police officer.
All right. And did you reassure her that she wasn't in any trouble? Did you?
Yes, I got her to step away from the table she was eating at, approximately 10, 15 feet out of earshot of the other two individuals that were sitting at the table. And I told her that I needed to discuss with her something that happened with her ex-husband and that her children were not involved. I reassured her because the children had already been checked on. They were still at the daycare and they were fine.
As part of this approach of Wendy Adelson, were there any handcuffs involved?
No,
Any Miranda rights read?
no,
Any use of force at all?
no,
She was not detained or under arrest?
no,
At any time, did you tell her she was a suspect in anything?
no,
Was she a suspect in anything at that moment?
no,
At any time during your interview, did you do anything that would treat her as a suspect?
no.
In fact, you told her several times in the interview that she was not a suspect. Isn't that right?
I did.
Did you ever accuse her of anything?
No.
Did you provide her with a victim advocate?
Yes.
Is that something that your office typically does for next of kin when a tragedy has occurred?
Yes.
Did you allow her to access her phone during the interview?
Yes.
What did you learn about the victim's relationship with his ex-wife, Wendy Adelson?
They had gone through it and were still fighting in a contentious divorce
I'm going to show
regarding
you
child custody.
with child custody.
Including child custody.
All right, I'm going to approach with states demonstrative A. Have you had an opportunity to review this exhibit before today?
Yes.
What is that exhibit?
It's all of the filings from the divorce case between Wendy Adelson and Daniel Markel.
Starting with the petition for divorce and ending at the time of his death. Is that right?
Correct.
And
Okay, Diane, I got you.
filings in here, have you had an opportunity to review them?
Yes.
All right, and did this litigation include arguing over things so petty as a tennis racket?
It did.
Objection, Your Honor. Nothing's been entered into evidence, and we would object to a witness testifying to the contents of the file.
Of the rule, the witness may testify concerning his personal knowledge of the investigation.
Thank you, Judge. As part of these proceedings, did Wendy Adelson seek to relocate with the children from Tallahassee to South Florida?
She did.
Did she say why she wanted to relocate to South Florida?
Objection, hearsay.
Staying, the answer to the call for hearsay unless you have an exception.
I'm going to show you what I've marked as States Exhibit 60. Have you had an opportunity to review States Exhibit 60?
Yes.
Are those the portion of the divorce filings contained in States Demonstrative A that can be directly linked to Donna Adelson?
Yes.
Meaning she saw those items.
Yes.
Objection, lack of foundation.
I believe that's what Ms. Cattleman is doing right now. Overruled.
Move into evidence, State 60, Your Honor.
Yow. Meow. That was a little. That's what she's doing now. Wow. Okay. That's interesting. What I'm Hold on. What am I? Okay, there you go. Judge is trying not to show his thoughts. However, if you watch close, he's a good. I mean, he's hiding his thoughts, but at the same time, if you really pay attention, you know where he's leading. Was it Waffle House? Mm. So let me see if I can zoom this. I am working on the witness list. He's so bored. Look at him. They are all bored. Now that there on this side is, of course, for the prosecution, the victim side of the family. This poor woman here in the middle in the black almost looks like she doesn't feel well. She looks very, and I know she must be like the sister or the mother or someone close. Definitely, but. Okay, Miss Diane.
Yes. It's good to be back. I have missed this.
It looks like you're doing this, but you're doing this.
Yeah, I kind of, where's my fingers?
Well, you can tell they're family members. Look at their faces. I mean,
they're all related.
I mean, they look almost, the woman in the glasses, I would be wearing them if I had the ability to wear darker shaded glasses. I'm going to actually eventually get some like Emily D, because with all the light and the dyslexia and all of that, I hear that the color lenses do help. So I am going to be getting that. Those are a little dark, but she may have a reason. Maybe she's got visual problems. Somebody commented on that earlier. And I'm like, well,
I want to get glasses that are the top glare.
People don't. Sometimes you feel like it. Sometimes you don't.
Almond Joy has nuts. Mounds don't.
P-O-L-O-G-N-A.
I wish I wasn't. Have you ever seen the Wienermobile?
Oh, many times. In fact, I was in an Oscar Mayer commercial when I was 7 years old.
Oh, you was famous.
I was in pigtails, blonde was white. Look what somebody sent me. You ready?
A pickle.
Come on.
I can't hear it.
You can't hear the pickle?
Is it a yodel? It's yodeling? Oh dear. Only way I yodel is with Sound of Music. Oh.
Oh, you and your siblings auditioned for the Oscar Mayer once, and I couldn't remember the jingle. Yes, and my twin brother and I were in the oh my God, it begins with a W, Wiggly, what, spearmint gum, the gum that had always, and they always had twins in the commercial. Well, they did some commercial with male and female twins.
And they did it.
Yeah, I don't know.
What's wrong with those people? Oh.
Yeah, double mint. Two
mints in one.
Yeah. You're real echoey, girl, and I don't know why.
I don't know why either.
Fix it.
I didn't fix it. I didn't fix it. There's nothing wrong with me.
Turn it off. Turn off. No, it's really brutally loud and brutally echoey.
Let me fix this. And how's that? Any better?
It's real. It's like you got an echo.
Well, I'm just special. Am I still echoed?
And you're loud. Guys, we need a sound check for Miss Diane and an echo for Miss Diane.
I'm just trying to make two of
Double mint spearmint.
Yeah.
Hold on. Am I double? Not to you, but she does to me.
I don't. You're not. You're not echoing.
Sounds like you're talking. It's okay. It sounds like you're talking in a can and you're wiggly. Okay, let me disconnect my ears and reconnect.
I got a feather. You got a feather. We got a feather. Hey, 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 hey. Oh, that's what that is.
Let's see if that makes double mint gum.
Double mint.
Okay.
Guess what I did this morning?
You are echoey. What the heck?
I don't know. As long as I'm not echoey with my hands.
Oh no. And it's on your end because I can't control that. That is weird, y'all.
It's weird because I don't know what it is. Well, no, my sound button's up here.
Hold on. Okay, try it again. Talk.
Okay. I'm back.
Keep talking.
All right. How about if I just everybody? No echo. Tinkatoo. No echo here from June. Yes. No.
Wow.
My perspective. Tinkatoo says, no, she's not.
Oh, I can't do it. You're echoing. It's like a knife. Hold on. I'm going to reboot. Nobody go anywhere. I'll be right back.
She right back. Okay. Well, it's the way of the computer. Oh, I wish there was an Oscar Mayer wiener. She's back. That is what's true. Da, 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 da.
Hop back on.
Okay.
That was weird, y'all.
What's that? You can step down, Mr. Ice. Please step outside the courtroom. Sure.
Uh-oh. There it is again. Try and talk, Diane.
Any better?
No.
No. Well, I guess I'll just get up.
I'll mute you.
All right. At this point, I'm nearing becoming inclined to send the jurors home for the day, as we are wasting a significant amount of time on matters that were either previously litigated or now are still being challenged for reasons that could have been handled out of court.
Judge is pissed.
Mr. Zellman, for any item that is being objected to with State 60 that you are claiming has no tie to your client's communications, you need to look through that binder now.
Judge, part of the objection that we're making concerning that is without laying the foundation through a witness with personal knowledge, there is no tie to my client. Anything, and specifically anything post-dissolution, So post July 31st of 2013 that's in here, there's no evidence.
I heard this argument previously.
Yes.
It has been ruled upon.
Yes.
At this point, if the state has multiple witnesses that the foundation can be laid through, your objection will be noted for the record, but we are going to move on. If you need to look through this binder to match it up with specific communications in which you believe no foundation can be laid, you'll need to take the time. But as far as wasting the jurors' time on this any further today, what else does the defense need to look through concerning these exhibits? Before we leave here today, if we need to go through every single state exhibit to deal with any objections concerning them, we will do so, however long that takes. But we're not going to be wasting the jurors' time.
Just a moment.
That is a pissed judge.
Yes.
Actually, I hear a lot of wind noise. Do you have a fan or anything going on? That's weird. I'll work on it.
It's just the Holy Spirit.
No, boo.
Sorry.
This is really pissing the judge off, and it's pissing everybody off.
Kappelman, between, concerning that, Ms. Kappelman, between former Detective Eisen, Wendy Adelson, or any other witnesses, are you going to be establishing the foundation as to the defendant's knowledge or connection through multiple witnesses?
May I have a moment, please?
Go ahead.
I had not planned to do that. I provided this exhibit to the defense. I have not heard anything about an objection, so I had not planned to go through every single piece of paper with this witness. I can do that, but that is going to take some time. I will need a recess to prepare for that. I do have a list of how each piece of paper is related to the defendant, but this witness isn't prepared to go through every single piece of paper in this exhibit.
Are you requesting for me to send the jurors home for the day?
No. I think I've complied with the court's ruling, and I'm requesting that the exhibit be admitted pursuant to that and move on.
There does have to be a foundation as to the nexus between the defendant's either communications or actions and these pleadings. That was the ruling. For what was provided in discovery.
Is that something that needs to be done in front of the jury, Judge, or is that something we could tie up later and move on right now?
You can tie up later, but it will not be admitted until the foundation is tied up.
Okay, Judge, I think that would be my preference then.
Very well, please bring the jurors up. Please direct Detective Ison to come back in and take the stand. Detective Ison, come back in.
Oh no, she's got her emotions very, very much under control now.
Everyone can be seated. You may continue your examination, Ms. Kappelman.
Thank you, Judge. Approach with State's Exhibit 64. Do you recognize State's 54?
Yes,
How do you recognize it?
these are the emails, I believe. I believe these are from Wendy Adelson's computer.
Was a search warrant issued to Wendy Adelson's Google account?
Yes.
And did we receive emails subject to that search warrant?
Yes.
And does State's Exhibit 64 contain fair and accurate copies of emails between Wendy Adelson and Donna Adelson?
Yes.
And if you'll turn to the yellow tab there. In particular, are you familiar with this email? For the record, Judge, this is tab AA.
This is, yes.
Is that an email that was sent from Wendy Adelson to Donna Adelson? On the bottom.
This is from Donna.
Well, okay. It starts out as something from Danny, right?
Right. Dan sends this email to Wendy.
Okay.
And
what
it's
is,
CC'd to another individual.
okay. And what does Wendy do with it?
She forwarded it to her mother.
Okay. And is the content of the email related to what we referred to as the grandma motion?
Yes.
What is the grandma motion?
This is where Dan Markel.
What is the objection?
First of all, lack foundation and it's hearsay at this point.
Overruled as to lack of foundation. The investigator may testify as to his personal knowledge of the investigation. Concerning hearsay, Ms. Kappelman.
Did Mrs. Adelson respond to this email?
Your Honor, did object again. Mrs.
One
Adelson.
moment, members of the jury, the bailiff is going to take you out. Investigator Ison, if you could step down, please, sir.
Oh, gee, gads, not again.
So, not to sound like a broken record, but that part where the jurors need to go home so the issues concerning these documents can be worked through. Concerning that, Mr. Zellman, what is your position?
Judge, I've said all along.
I know what your argument is, but as to the items that the state is seeking to admit today, are there going to be more challenges of this nature? If you have objections, I will rule on them, but we're not going to waste the jurors' time.
Judge, as to 64AA, my client and her husband shared an email address. There's no evidence as to who sent the response that the state is trying to get to.
How many parts of 64 is the defense objecting to?
I'm ready. I'm waiting for the judge to.
Calvin, concerning AA, does the foundation need to be laid amongst multiple witnesses, or is Detective Ison capable of doing this?
As far as to whom the email address belonged, that will have to be tied up with Wendy Adelson.
Well, is there any other parts of Exhibit 64 that need to be dealt with now while the jurors are out of the room? Please look through it.
I'm trying to adjust the sound. This judge is not happy. Let me back it up for the sound.
More challenges of this
Certification.
I think the sound's better now.
Any objections by the defense that need to be handled out of the presence of the jury concerning these items?
There's a couple more, Judge.
Go ahead.
89 Premiere video clips, 90 bus video clips. 119 is a thumb drive containing the raw data from Premiere, and 120 is a thumb drive containing the raw data from the bus.
No objections to those, Your Honor.
Please bring back in the detective.
Foobar! I said foobard. You asked, can I say foobard? I said foobar. What? Talk.
Thumb drive, thumb drive, thumb drive. You know, not.
You're still echoing.
Yeah,
Hang it. Yeah, I have to play with it consistently depending on who's talking. Oh, I wonder who just told Nightbot to throw that up. Who told the bot to put that up? Who? Who told bot to do that?
Oh no.
AA, whichever portion of the foundation you're capable of laying with detective, you can at least start it with that. As to the rest of it, you can seek to admit it if the foundation can be laid without it, or without any other witnesses.
I would have everybody in my chambers and I would be chewing ever-loving airs out. I'd be, come on, boo, let's go, chambers. We're taking a 10-minute break. And we would go in my office.
The one lawyer, his ear would pop off.
I would not want to piss that judge off. He looks like he's been a linebacker and everything else in between. I would not want to piss off that judge. I would not want to upset him. I wouldn't.
Please bring back in the jurors.
I bet that witness is he didn't want to get that many steps in today. He goes, I've already gotten my steps. I don't need no more. Quit sending me in and out. My God, I'm old. You see a pit mix on me? I don't need steps. So quit getting me to walk in. These shoes are made for walking. Walking is what they'll do. Oh, I know that I would be. Huh?
I'm just laughing.
Oh, I know where it's coming from now. Now you're clear.
Yay! What was it? What'd you fix?
Well, we'll see if it's fixed. It's my FX sound system. We'll see if it's, how is everybody else hearing this? I made a change. A verdict, what? I know. Hi, it's not real. Don't spoil it. Even if it comes back, do not spoil the verdict. Don't even tell me there is one. We're going to zoom. Don't spoil it. We have another case we've been following. It's called Wolfenbargner. Wolfenbarger. Some people have been spelling it GAR, so we've all been I was spelling it wrong because everybody else was. Wolfenbargner. Wolfenbargner. We've been calling him Waffle Burger from Waffle House.
Y'all missed me.
We did.
I'm so glad to be back. I enjoyed my time away, but I'm really glad to be back. Them babies were awesome, and they're not babies anymore. AdaKay, one of them said, the bumper cars are exhilarating, and she's 4. Their vocabulary. But while you're safe. Oh.
You look annoyed too.
Me?
Looks like you got Native American earrings on.
I do. That's for you.
Well, I'm disappointed because you should have brought me some eel skin.
Sorry, I didn't. I got nails.
Which is illegal, or an eagle's feather, which is illegal.
I didn't want to go to jail. I wanted to get back. I got nails, woman. I got nails. I know. But it's the first time in a long time.
All right, guys, I'm going to zoom. All right, we're going to take a bet. How long?
State's exhibit his death.
Yes.
Okay, how long before we have another objection? I'm going to put up a poll. Why not? Okay, I'm going to mute you. We're getting ready to start.
Indicated that you reviewed the divorce file as part of your investigation.
Yes.
And that's the court file.
Yes.
All right. And as part of your investigation, did you review the emails that were subject to Wendy Adelson's Google search warrant?
Yes.
And in those emails, was there an email in which the contents of, well, let me ask you first about the motion. Did you review a motion where Dan Markel was seeking to restrict Donna Adelson's access to the children?
Yes, I did.
All right. And that motion was filed with the court.
Yes.
It was pending at the time of his death.
Yes.
And did you find in the emails any evidence that the contents of that motion were sent to Donna Adelson?
Yes.
And is that tab AA of State's Exhibit 64?
Poll started. I'm sorry.
Yes.
And are the contents of that email substantially similar to the allegations made in the court filing?
Substantially, yes.
Okay. And what is the gist of what it is that Dan Markel is requesting?
He does not want Donna Adelson to have unsupervised contact with his children.
Why not?
Because of the statements that are made in here, and that was shown in the court filing, that the children reflected that grandma says you're stupid, grandma says she hates you.
And
Judge.
Woo!
At this time, Judge, I would ask to admit State's Exhibit 64.
You woman,
All
me
parts
man.
Or just the part that does not include AA.
Subject to tying up AA, I would seek to admit the whole thing.
States 64, any objection?
Just the objection previously made, Your Honor.
Concerning States 64, it will be admitted except for part AA and any later foundation that needs to be addressed.
Did, in your review of these emails contained in State's Exhibit 64, the defendant, Donna Adelson, use any strong language against Dan Markel?
Yes.
Did she call him any names?
Yes.
I would ask you to review State's Exhibit 64, tab DD. Do you recognize that exhibit?
Yes.
What email is that?
This is from Donna to Wendy.
And does she call Dan any names in that email?
She calls him Elvis.
How about asshole?
I know it's in here.
Take your time.
Y'all getting ready to learn some bad language, sign language. You're going to learn some bad words in a minute if you pay attention.
Have you ever seen an email where she called him an asshole?
I've seen an email, but I don't see it here.
Okay, let's move on.
Okay.
Tab M, please.
Emma?
M as in Mike.
M.
Did she I guess tell us who it's to, who it's from, and the date, please.
It's from Donna to Wendy, March 6th, 2013.
Does she call Dan Markel any names in that email?
Yes, she does.
What names does she call him?
In
Name.
this particular email, after the first paragraph, it says that she calls him a major fucker.
Please refer to tab Q on May 3rd of 13 email.
Yes,
Does that email, is it from Donna to Wendy?
it is.
And does it reference Wendy's relocation efforts?
Yes,
Does it indicate that Wendy's relocation efforts are extremely important to Donna Adelson?
yes,
Please reference tab V as in Victor, a June 25th email. Are you familiar with the court filing in which relocation was denied?
yes.
Do you know on which date relocation was denied?
June 20th, 2013.
So this is email on tab V as in Victor. Is it 5 days after relocation was denied?
It is June 26th, 2013.
Does Donna Adelson, the defendant, propose another plan to facilitate relocation in light of the court's ruling?
Yes,
So this is done after the court's ruling,
correct.
and relocation is still being discussed.
Yes.
Okay, what does she suggest?
She suggests that the children between Wendy and Dan start attending, or her at least the ruse of them going to a Christian church or a Catholic church.
And to take pictures of it and send it to Dan Markel, right?
Yes,
To strong arm him into agreeing to the relocation, right?
correct. Coercion.
Did Donna Adelson, the defendant in this case, suggest a bribe to Dan Markel to cause him to allow these kids to be moved to South Florida?
Yes,
Draw your attention to tab W. What is the proposal in reference to this bribe?
$1 million.
$1 million.
Yes.
Okay. Were there any death benefits, any monies that were to be gained from the death of Dan Markel?
Yes,
Did he have a life insurance policy?
he did.
What was the amount of the life insurance policy?
One of them was for $2 million.
And a second one for $60,000?
$60,000 from the second one through the law school.
Were there any survivor benefits for these kids in the event of Dan's death?
There was
What are those?
$4,800 a month.
Who gets that money for the disbursement of the kids?
Wendy Adelson.
What about through his employment at FSU Law School? Did he have a pension there?
Got a pension, a deferred comp, 401k,
And an estate worth some money, right?
approximately $300,000.
What was the total value of Mr. Markel's estate?
2.7 million.
As part of your investigation, did you attempt to establish a timeline of the victim's activities prior to his murder?
Yes.
What did he do that day?
At 8:50 a.m., he dropped off his children at the preschool daycare on West Stark Street. From there, he proceeded to go back across town to Premier Fitness gym off of Village Square Boulevard.
Was there any surveillance at the gym?
Yes,
And was that collected by law enforcement?
it was.
Diane, you're really like this?
Judge, at this time, I'd ask to move into evidence.
Is it because you can't hear?
State's Exhibit
Okay, we're fine.
119, a thumb drive containing the surveillance collected from Premier Gym.
Any objection? There you are. Stage 119 is admitted.
And was the raw data or surveillance video collected from the gym compiled in a way that shows what it is we're looking for concerning Mr. Markel?
That's correct, yes.
Was that done in State's Exhibit 89?
I believe so.
All right, Judge.
If you notice, he's struggling to hear because he's really doing this on his good ear. June, I hope your breakfast was good.
At this time, I'd ask to move into evidence, States 89.
There you are. States 89 is admitted.
Were you able to see on this gym surveillance video Mr. Markel's vehicle enter the parking lot of the gym?
Yes,
At what time does he enter the parking lot of the
I
gym?
believe it was 9:11,
sound right?
9:11, yes.
We're talking about AM.
Are we having, Diane, let me turn your mic on. Are you struggling to hear or see it?
I'm struggling to hear. And I took something because of the cramps in my hands and I could not sign. And I think
We're good.
Hit me.
Okay. Well, I'm just making sure because crank your volume up. And everybody knows we have really had a hard time in this courtroom. I've got an app on my thing that's double gain and everything, and we're still struggling to hear.
Yeah.
Remember those ears I gave you?
Yes, but I don't know where they are right now because of everything in my office. Right now, I can't even find. I got more. I got another pair though. I'll be right back. Okay.
All right, I'll keep signing until then.
You said he dropped the kids off at 8:50 and he arrives at the gym at 9:11.
8:50 a.m. is when he dropped the children off, and he signed them in at the daycare. And then at 9:11 is when you see his car enter the parking lot at Premier, all on July 18th, 2014.
And were you able to see anything sinister about the parking lot of Premier Gym on the morning of Mr. Markel's shooting?
Following Markel's car entering the lot, a short time later, a vehicle enters the lot that is similar in description from the next door witness, Mr. Geiger.
What does the suspect vehicle do when Mr. Markel enters the gym?
It parks and no one gets out of the car.
How long does the suspect vehicle stay there while Mr. Markel's in the gym?
I don't recall the exact amount of time, but it's quite some time that the whole time he's in the gym. And even after he comes out, gets back in his car and leaves. That's when the car leaves at the same time.
All right. So the whole time he's in the gym doing his workout, this suspect Prius is in the parking lot.
Correct.
And when he comes out to leave and gets in his vehicle, what happens with the Prius then?
The Prius follows.
Judge, at this time, I would ask to introduce State's Exhibit 89. I'm sorry, I have introduced it. I'm asking to publish it at this time. Thank you.
Exhibits!
Is this black vehicle Mr. Markel's vehicle?
Yes, it's a black Honda four-door. Same car.
And that's Mr. Markel parking right there behind the flagpole.
That's correct.
What is this vehicle?
That will be the suspect vehicle,
And is-
green Prius.
Okay, consistent with the description given by Mr. Geiger.
They said a light colored or silverish, and the car color is a silver pine mica.
Who's that in the blue circle?
That's Mr. Markel exiting his vehicle.
That's him in the red shirt.
That's correct. It's Mr. Markel entering Premier's main doors.
What do we see in this image?
I'm sorry.
What do we see in this portion of the tape?
That's the suspect vehicle, Prius, driving through the parking lot.
At this point, is Mr. Markel inside the gym?
He's inside, yes. This is still in the front section where the car went from right to left.
This is still part of the Premier Gym parking lot?
Correct. Yes, it's just the opposite, camera facing the opposite direction. And it's the car reversing course coming back towards the front doors.
Yep. Okay, now what's the time on the video here?
I can't read 10:30. I think it says 10:38.
Is this Mr. Markel exiting the gym at this
He's
point?
exiting the Premier in the same door he came in. I'm sorry, it's 10:33 on the timestamp.
Thank you.
That's Mr. Markel making his way to the parking lot where his car is parked.
Once he gets in the car, does he sit there a few minutes or is that at the front end?
I'm sorry?
Does he sit in his car for a few minutes at one point?
Just a short period of time. Then his car starts backing up.
Most of the time, you don't know you're being followed. Been there.
Where's that?
That's him exiting.
And will we see the suspect vehicle pull out
It's coming
behind
from the
him?
backside. See it?
Hey, June, go to chat, please. Thank you.
Same suspect vehicle following the direction of Markel's car.
All right, and it exits the parking lot at 10:39 a.m.
Yes.
Okay. And based on what would be the logical route from here to Mr. Markel's home, did you try to get some additional surveillance to see if you could catch the suspect vehicle any further?
Yes.
What was that?
That was the location was the business. No, I'm sorry, it's a bus video off of a bus at McClay Commerce Boulevard and Thomasville Road.
All right. And were you able to actually find some bus video from both before and after the shooting of the suspect vehicle?
Yes.
Okay. And were those the raw data that you collected from the bus compiled into clips similar to what we saw on the gym video?
That's correct.
All right, Judge, at this time, I would ask to move into evidence State's Exhibit 120, a thumb drive containing the bus raw data, and State's Exhibit 90, a disc containing the bus video clips.
Any objection? No, Your Honor. States 90 and then 20 are good.
Permission to publish States 90.
Right.
All right, if you can pause it for just a minute. Can you orient us? Is this the McClay Commerce?
Yes, this is the bus is pointing east. So just beyond that circle is where the flyover starts. If you're going southbound, you can take the flyover to get on Capitol Circle after you pass McClay Gardens and everything. So this car is on Thomasville Road, not the flyover, and it is going southbound.
All right, and this camera is mounted on the bus. That's how we were able to get this image?
Correct.
Okay.
This is a city bus.
Continue, please. The time on this, 10:44 a.m. Is
Correct.
that right? And what is this orange circle?
This is the Prius going the same direction as Markel's car, southbound on Thomasville Road.
Okay, now where are we?
This is southbound on Thomasville. We've gone underneath the I-10 overpass, and we're at Metropolitan Boulevard, and the bus just so happens to pull up right behind the Prius.
Based on the image in this exhibit right here, were you able to deduce the tag number of the Prius?
No.
That would have saved you a lot of
A
trouble,
lot
wouldn't it?
of time, yes. The video could not be enhanced anymore.
Hot.
Does the evidence suggest that Markel had already gone on through past this traffic light?
Correct, because this car was behind Markel's car. So he must have beat the light or got through the intersection before this.
Okay, now can you orient us?
I believe we're now at Thomasville Road, southbound at Benton. And that circle was the Prius in the left turn lane to go from Thomasville eastbound on Benton Road.
And is that the way to Mr. Markel's residence?
Not this time. He turned beforehand. We found out later on.
You found out later that Mr. Markel turned later on.
Yes,
But this is the way the suspect vehicle goes.
Right. He turns left.
Okay, can you get to Mr. Markel's residence from Benton Road?
Yes.
The way he turned?
Yes.
All right, now, can you back it up, please? So the last time we see the suspect vehicle turning off Thomasville onto Benton Road is what time? Hit play, please.
10:40, no, 10:51.
Okay.
Okay, Diane.
And what time does our, pause it, please. What time does our 911 call come in?
11:02 a.m.
Okay, so he was killed between 10:51 and 11:02.
Well, we narrowed it down even more than that. But,
Okay. Tell me how you narrowed it down further.
well,
than
this bus now, this is a different bus, same city bus group, but this is a totally different bus. It's northbound on Thomasville Road. So based on the time, this bus is northbound. The shooting has already happened, and you'll see that the Prius catches up in the same lane as that black vehicle there next to the bus at 10:55, I believe. 10:55. Here it comes.
So that helps you narrow it down to what as the time of death?
10:50. Well, at 10:51, he's in the Prius is in the turn lane. At 10:55, they've already left Prescott and they're northbound towards I-10.
Okay, and you say they. Why do you say they?
Well, here shortly, you'll see what appears to be two different individuals in the front seat of this car.
See something white moving around in the passenger seat?
Yeah, the white shirt, the person in that side of the car seems extremely animated, excited. And the other side, the best view that I've ever gotten is someone's in a black, solid black shirt or upper top.
All right, and this is a slowed down version to try to get a better look at those occupants. All right, what are these orange circles indicating?
These are characteristics of this car that we found to be unique. The passenger side mirror is solid black. These cars have, when they come new, the mirror is the same color as the car, the mirror casing on the outside. This one's been replaced, it appears, because it's black. The circle in the middle of the top of the windshield, that appears to be a sun pass or toll type pass activator. And then the lower bumper circle, that's where a tow hook can be threaded in for towing purposes, but otherwise it has a cap over it and the cap is missing.
Were you able to deduce anything about the year of the Toyota Prius?
Based on the research that we did through Toyota, this was established to be a 2006 to 2009 Toyota Prius, and the color, as I said before, was silver pine mica.
All right. Is it fair to characterize your investigation as having kind of two different veins at this point? We're looking at motive over here and we're looking at the Prius over here.
Correct.
Okay. And you mentioned the sun pass transponder. So we know this Prius, I'm assuming it's not the only silver pine mica Prius between 06 and 09 in the state.
Correct.
All right. So what do we do to try to track down the sun pass transponder?
I contacted Florida Department of Transportation, who administers the sun pass, and wanted to find out, what's the likelihood of that kind of car having a SunPass, and I was overwhelmed with, there was thousands. So that wasn't narrowing down anything very quick.
At that time, was SunPass more affiliated with South Florida, or did pretty much everybody in Tallahassee have one?
No, south and central, anything Orlando south for the most part.
Okay. Did you have any indication based on the surveillance video available as to where the vehicle went after it fled from Markel's residence?
I just know that right here it's going northbound towards I-10 from Thomasville.
All right. Let's watch to the end.
This intersection is Armistead, so this is north of Benton, heading back towards I-10.
Was any cell phone analysis worked on in this case?
Excuse me?
Cell phone analysis.
Yes.
Who performed the cell phone analysis?
Sergeant Corbett.
Okay. And is that something that was going on simultaneously as you doing this SunPass?
That's correct.
Thing? Okay. And did Corbett's work include trying to look for phones of interest traveling in the areas that we know where you found our suspect vehicle?
That and Premier Jim.
And we will talk to Sergeant Corbett later, but based on his analysis, did you have an idea or develop an idea of the route that your suspects may have taken?
Yes.
All right. And what did you do to follow up on that?
Well, initially, because of our large expanse of cars, we started looking for South Florida at any cars going through the interchange southbound at Wildwood, where you get on the turnpike from I-75. That was a bust. It was way too many. We couldn't find anything that was concrete. So once the phone analysis was done, we had a better idea that there was one particular number, and tracking that went southbound on I-75 all the way to Naples, and then crossing over on Alligator Alley, which is still I-75 from west to east, from Naples to Broward County.
And once you learned that it was actually this other route than what you would expect, were you able to do anything with in reference to the toll plazas and the SunPass transponder that you weren't able to do previously?
That's correct.
Okay, tell us about that.
Once we had that established, then I contacted the SunPass administrators again at Department of Transportation. And I explained to them what I had. I said, we got a Prius, a 2006 to 2009, silver pine mica, not that they had that in the records. I says, but we have them going through approximately this toll plaza in Naples, going westbound. And once I gave them that and the time, within a couple minutes of when they would have gone through, they showed an activation with a transponder from the windshield at that toll plaza in Naples in Collier County. And there was only one Prius. And that's what we determined, that it was going back to South Florida and cutting across Alligator Alley.
All right. And were you able to backtrack and find the toll plaza record or SunPass record of the vehicle coming to Tallahassee as well?
Correct. On the 16th of July, that same transponder, we're talking about the sticker on the windshield, that same transponder went through from Broward County, West Broward County, through the other end of the toll plaza. There's one on each end. There's nothing in the middle. But one going eastbound, that same transponder on the 16th of July cut across Alligator Alley and then presumably went up 75, which the phone records will show that. And then the return trip was the first one we found.
And did that help you identify the particular SunPass transponder by like an identification number?
Yes.
And is a particular SunPass transponder affiliated with a particular vehicle through some type of SunPass record?
Yes, it shows the the customer who purchased the SunPass, and they submit what kind of vehicle it is, the tag number, in case the SunPass, the transponder doesn't work, they could still use their credit because it'll take a picture of the tag.
All right. So what did you learn about the suspect vehicle at this time from the SunPass stuff?
It was a rental. It was a rental from a Miami car rental place called Save Gas.
Okay. Okay, well, we'll work on that too.
He looks pleased with himself. So who did?
All right. Now, Sigfredo Garcia and Luis Rivera, those are the two subjects that you establish as being in the Prius. Is that right?
Right.
Okay. And these are their phone numbers that have been associated with them listed beneath them.
Correct.
And we've got two different numbers for Luis Rivera. Is that right?
Rivera had two separate numbers, but his main one was the 570 that was on the rental contract.
All right. And the nicknames that are shown there, are those the nicknames that those two go by?
Correct. Tuto and Tato.
Tuto and Tato.
Correct.
Okay. Were you able to establish any link through people between the two that came in the Prius and the Adelson family?
No.
Okay. Were you able to establish any type, did you develop a theory or any evidence as to why these two people came to Tallahassee to murder Dan Markel?
Well, eventually we learned that the female, Catherine Magbanua, was the mother of Sigfredo Garcia's children and considered each other spouses, to my best understanding.
Okay. And
At
did
the
she
same
have,
time,
go ahead.
same time, we also found out that she had been dating and in a relationship with Charlie Adelson.
All right. So initially, was there any connection between these two guys from Miami and Dan Markel?
None.
All right. So this was the connection that was established, turned out to be Catherine Magbanua.
The only connection we could find.
Okay. And was that done through phone records and ultimately other communication records and testimony?
That's correct.
Okay. Did you, as a result of developing Catherine Magbanua as a potential suspect, investigate her at all?
Yes.
All right. And did that include an investigation into her employment?
That's correct.
What was her employment status around the time of this murder?
At the time of the murder, I
That's
believe
you.
she worked at another dental office somewhere, but post murder, she started receiving compensation from the Adelson Institute.
What is the Adelson Institute?
It's a dental practice, according to online information operated by Harvey Adelson and Charlie Adelson.
Okay. And were the two of them dentists?
Yes, I believe Charlie is recognized as a periodontist.
Did you come to learn what Donna Adelson's role, if any, was in that business?
Yes, she was clerical and kept books for the business.
Did you attempt to procure some employment records from the Adelson Institute to verify Ms. Magbanowa's employment?
We did.
All right, tell us about that.
Myself and Special Agent Sanford from the FBI went to the office, physically to the office in Broward County, Tamarack, and served a subpoena seeking records for the employment of Catherine Magbanowa, and we received nothing at the initial time. Later on, the best I could get from, I believe it was an attorney that represented that dental office, just a list of checks that were paid checks from the Adelson Institute to Catherine Magbanowa, but no W-2, no responsibility forms, nothing that showed what she actually did as being employed at that institute.
What was it, regular business hours when you entered there physically?
Yes.
Was Ms. Magbanowa present when you entered the building?
No.
Did the employees that you have contact with seem to know who she was or what it was that she did there?
The initial person that I spoke to at the desk, at the front desk, she had no idea who this person was, who Magbanowa was. The other person that came up to the front, she said she knew the name, but did not know what her responsibilities were with the company.
And the person that knew the name, who is that?
Erica Johnson, I believe.
And I'm going to approach and show you 68. Recognize 68?
Yes, this is all I received as far as any type of records for Magbanowa and her relationship with the Adelson Institute.
Right. And did the records include any job description for Ms. Magbanowa?
No.
Any employment application?
No.
Schedule?
No.
Timesheet?
Nope.
W-2 forms or tax filing records?
Nope.
Any performance evaluations?
None.
So only the checks.
Only the checks.
According to those checks, during what period of time was Catherine Magbanowa on the Adelson Institute payroll?
From September of 2014 all the way, this particular one shows March of 2016, but I believe it goes further than that into May 2016.
Right. So it starts shortly after the homicide, about 2 months?
Yes. Actually, the homicide happened July 18th, and the first check was dated September 18th.
For what pay period?
I don't see the pay period on this one.
But presumably she'd be paid for a pay period that had
2 weeks
concluded.
prior, according to the way this is laid out.
All right, and we are going to learn more about the bump or the undercover operation, but is it fair to say the checks terminated shortly after the undercover operation in 2016?
Yes.
Did you notice in your review of that exhibit, the documents provided by the Adelson Institute, that some of those check numbers were consecutive?
Yes, I did.
Who signed those checks?
Donna Adelson.
All of them?
Everyone.
Were you ever able to develop any evidence that Magbanowa was physically going to the Adelson Institute during these pay periods?
Never.
Any evidence that she performed some service offsite for that business?
Nothing was established that showed that.
Any evidence of any contact with any patients?
No.
And you were, we'll learn later, listening to some of her phone calls, right?
That's correct.
When was Catherine Magbanowa arrested for her role in this murder?
October 1, 2016.
Were you present for her arrest?
I was.
And was she allowed to contact her lawyer from the arrest scene?
Yes,
Did you speak to her attorney as well?
I did.
Who was her attorney?
Tara Kawas.
What happened after that phone call?
After Ms. Magbanwa was placed into a car for transport to the Broward County Jail, way less than 20 minutes later, I received a phone call on my phone.
Because lack of relevance, he's about to testify to something that has nothing to do with my client.
Disputed objections. Ms. Kappelman, please lay the foundation as to this matter in this trial. Overruled.
Go ahead, sir.
So so let me back up. So while Ms. Magbanwa was detained on scene where she was arrested in the daylight hours, she was allowed to place a call to her attorney. She spoke to her attorney. I spoke to her attorney, and I asked that Ms. Kawas, the attorney representing her at the time, that she contact her client, Magbanwa, at the Broward County Jail, and if in fact she wanted to cooperate with the investigation, to call me back.
So you were interested in getting information from Ms. Magbanwa?
Correct.
Information about the other parties involved in this case?
Yes.
Okay.
What I mean by cooperation is if she wanted to provide testimony about other players in this. And so I told Ms. Kawas, if you'll talk to your client, obviously out of my presence, and if she decides to cooperate, call me back and I will go to the Broward County Jail and meet.
Did that happen?
No.
What happened instead?
Well, like I said, within less than 20 minutes from that conversation, I received a phone call from a gentleman that identified himself as David Marcus. Instead, he was an attorney representing Charlie Adelson. And he asked that if Charlie Adelson was to be arrested, if I would just contact him.
There's relevance, and this is not co-conspirator admission.
Specifically as a co-conspirator aspect, Ms. Kappelman, you need to keep the examination focused on that. Members of the jury, as to the last objection, I will sustain it. You may continue, Ms. Kappelman.
So you speak to Kawas and your next phone call is from Charlie's lawyer?
Correct.
No further questions.
Cross-examination.
Don't go to sleep, Diane.
I was seeing carrots. Don't ask me why, because I don't know. But I saw this big tub of carrots. But thank you.
Diane, do I need to put you in the hospital?
Maybe. Oh.
All right, it got real quiet in chat. Everybody, everybody start I know everybody's listening. Let's do this. Let's do a real quick. I'm going to play some music for a second. Everybody get up and stretch. Here we go. Okay, dokie. Okay. I just wanted us to take a little breather. It's getting a little intense in here. It's awfully quiet. Diane is back from Olaskia.
Oh, so beautiful.
I bet it is this time of year.
We
She
took a
used to live there, and
ride.
she used to live there, and I remember when there was so much snow, she couldn't even get out of the house.
That's right. And I'd go outside and go, I live in a Christmas card. We took a ride one day, beautiful, toward Denali. I got pictures that'll take your breath away.
Good, send them to me in instant messenger. All right, back to court. Look at the photographer sitting there. That's interesting.
I was looking for a 5-hour.
Afternoon.
Don't have one. I need one.
Okay, so at the time of this investigation, when it began, how long had you been with the Tallahassee Police Department?
25 years.
You'd spent vast majority of your career as an investigator detective.
No, I've probably spent most of my career as a street officer.
Okay. At the time of this, how long had you been a detective?
6 years.
Diane, I got to handle something. I'm going to have you keep signing.
Okay.
And you continue to be the lead for Tallahassee Police Department on this investigation until your retirement, correct?
Correct.
Now, it's important when you're conducting an investigation, especially a homicide investigation, for you to be thorough, correct?
Yes.
You don't want to leave essentially any stone unturned.
Yes.
Obviously within reason.
Yes.
You talked about your agency beginning to obtain cellular phone records of the Adelson family pretty early on, correct?
Mm,
You started getting them in July?
yes.
Okay. And you learned that Wendy Adelson's parents, my client and her husband, lived in Miami, correct?
I believe at the time it was Coral Springs, but
They had a place on Miami Beach?
well, I know that they ended up at Miami Beach. I don't recall at the time of the homicide if they were living on Miami Beach.
Okay. But you knew that they were in South Florida?
South Florida is correct.
Okay. And so as your investigation continued and you started looking into, you made the connection between the two individuals who drove up here, Sigfredo Garcia and Luis Rivera. You made that connection to Catherine Magbanoa, correct?
Right.
And you made that connection to Charlie Adelson, correct?
Correct.
And then you see these large cash deposits into Katie Magbanoa, or you see Katie Magbanoa's unemployment status.
Right.
She's still paying her bills in South Florida.
Yes.
Okay. Now, you also mentioned that you contacted the SunPass Authority.
Yes.
Okay. Did you ever, you'd already made a connection between the investigation and the Adelson family at this point, pretty quickly.
I wouldn't say that.
Okay. Well, over a couple years. By the time June of 2016 comes, comes about, you've already made that connection.
Oh, yes. By that time, yes.
Okay. And you contacted the SunPass Authority for my client's SunPass records, correct?
No.
No, you didn't. Did you contact the Turnpike Authority for construction records for the Turnpike?
Construction records?
Yes.
No.
What about for I-95 or 595?
To my knowledge, there is no, and I believe I established that with the FDOT, Florida Department of Transportation, that there was no toll system on 95.
Okay. I was asked about construction records on 95.
I did not inquire about construction records.
What about accident records?
Accident records?
Yeah.
No.
Isn't it true that my client and her husband shared an email address.
I believe they did.
You learned that during your investigation. In fact, I think Wendy said that, didn't she, in her interview with you?
I don't recall whether she said it.
Where is, do you have some?
Ada, pause it.
Yes, ma'am.
Before I had the conversation, I don't have that now. Where did it go?
Are you talking about through your computer or?
Yeah.
Okay, so you have to go into your search bar and search live captioning, and then it should pop up.
Okay, tab search.
My father was stationed in Anchorage, Alaska. I hear it's beautiful. I do want to go up there.
Oh, I want to go when you go. We'll have a ball.
We might do that. Make it a girls' week.
It would be fantastic. Okay, come on. Where are ya? Search bar. Search tabs.
You identified emails that are contained in State's Exhibit 64, correct?
Yes.
And according to your testimony, these are emails between my client and her daughter, correct?
Yes.
Not yet. Where are you?
And in some of these emails, my client called Danny Markel bad names.
Yes.
She never actually said she hated him, did she? In any of these emails?
That came through the grandchildren.
Okay. At the time, the grandchildren were 3 and 4.
I don't recall the age. They were young.
And you also testified about a bribe. You are not a family law attorney, are you?
No.
Okay. And you have no idea whether or not it's permitted for one party to offer any sort of financial incentive to another party when it comes to relocation.
That's not in my realm.
And you also testified about Mr. Markel's life insurance policy, pension, and you said that those funds went to his children with Wendy as a custodian?
Some of them, and some of them was Dan Markel's sister as a custodian.
Okay. Did my client receive any financial benefit in the form of Danny's life insurance, his pension, or anything else?
Not that I could tell.
Going back to those emails, especially the one the state highlighted concerning the Catholic Church and dressing the kids up, Wendy didn't take those suggestions, did she?
No.
You testified just now concerning your attempt to obtain employment records for Miss McVanowa from the Adelson Institute. It's a small business, right?
It appeared to be.
Just a handful of employees?
Yeah, there was only 2 there at the time.
You don't know whether or not any of the employees had a written job description?
No, I do not know that.
You don't know if any of the employees' files had evaluations or job reviews?
I didn't see that. I would think with that type of business and working on people's mouths and so forth, that there would be a little scrutiny involved.
But you don't know if they kept those records for any employee.
I have no idea. I was only seeking and only had cause to seek for McVanowa.
And when Miss McVanowa was arrested, you testified that you received a call from someone who identified himself as Charlie's attorney, correct?
After her arrest, the gentleman that called my number he identified himself as an attorney for Charlie Adelson.
Not Donna Adelson.
Not Donna.
Now, is it unusual in an investigation like this for a defense attorney to contact you about whether or not there's a warrant for their client's arrest?
I wouldn't say that. If I can, it was shocking to me that within that short a time frame, the only way that this person would have knowledge would be from Magbanwa's attorney. So there would be contact between Magbanwa's attorney and this person identifying himself as Charlie's attorney in a short, very short time. No media, nothing had been divulged.
So what you found unusual was the short time frame, not the phone call itself.
No, it was immediate, and I'm basically telling Coas, if your client wants to cooperate, contact me. Don't call somebody else that's a co-conspirator, their attorney.
You didn't receive a call from anyone identifying themselves as Donna's attorney in that instant, did
No,
you?
sir.
Okay. Ms. Kappelman asked you about what has been coined that grandmother motion. Again, you're not a family law attorney.
Right, still not.
And so although you read the motion,
yes,
and you're educated, absent having some legal knowledge, can you interpret what is being requested in the motion?
I believe so. I think it's pretty plain.
Okay. I'm glad you said that. Now, I want to go back to the emails, and I'm going to use the board. The emails that you testified were between my client and her mother.
I just if we needed to take a break.
I'm going to show you 64 EE. Let's see. The sender of this email is not Donna Adelson, is it?
No, it doesn't. I don't know who it's from. It's not showing it.
Okay. It's an evite.com invitation.
I've seen those.
Okay. You don't have any personal knowledge as to how these are generated, do you?
Someone has to go through this program to get it set up and sent out.
But you don't have any personal knowledge as to how that's done, do you?
No.
The next page of EE, it's August 30th, 2014 email to Wendy. Ah. The sender is donnaharvey@gmail.com, correct?
That's correct.
Whose name is next to that?
Harvey Adelson.
That's not Donna Adelson, is it?
I believe that's her husband.
Next. It's an email dated September 12th, 2014. And the sender is saying that Lincoln will attend Tot Shabbat with his grandpa, Harvey Adelson. Isn't that what it says?
Yes, it does.
Who's it from?
It's from donnaharvey@gmail.com.
And whose name is next to that?
It says Harvey Adelson.
I'm going to show you 64FF. This is, again, from Harvey, DonnaHarvey@gmail.com, correct?
Yes.
Whose name is there?
Where it says from?
Yes.
It says Harvey Adelson.
Wendy, this is the information on work order for repair of TV Friday, July 18th between 8 and 12. Love, Dad. My client's not Dad, is she?
I wouldn't refer to him as that. I don't think she would either.
This is still part of that same email, the Geek Squad schedule. Would you be willing to accept a sooner appointment if one become available? Do you see that language?
Yes.
What's the answer underneath that?
Yes.
Nothing further, Your Honor.
Redirect examination. Go ahead.
Defense pointed out, hey, Harvey and Donna share an email address, right? DonnaHarvey@gmail.com. Some of these are signed Dad.
Right.
Are some of them signed Mom?
Right.
Okay, and drawing your attention to this one on May 3rd, 2013, including the statement, the most important part of your divorce is relocation. On page 4 of that exhibit, well, let me start by going to the very end. Inconveniently, the way this printed, love you. Who signed that one?
Mom.
All right, and on page 4 of the exhibit, just a moment. State's Exhibit W, this is one from Thursday, June 27th, 2013. It's signed Mom and Dad, right?
That's correct.
Okay. And this one, all right, so we've got some from Mom and Dad, right?
That's correct.
No further questions.
You may step down, Mr. Rice. Will he be retained? You may be recalled at some point in the trial if you may contact with the attorneys. What's that? Am I under the rule? Yes, sir. Thank you, Judge. You're welcome. Members of the jury will take a break at this point briefly. The bailiff will take you to the jury room. Everyone can be seated. Just a reminder for the gallery while the testimony is taking place. If you step outside of the courtroom, you'll need to wait until the examination of that witness is complete. We will resume at 3:50.
How are they to resume at 3:50 when it's already 3:50 their time?
Okay, stupid.
I'm just like, what?
Okay. All right. How do I find this up here?
Where you're in the Apple, right? Wherever you search for files or whatever, the main search, just put virtual captioning.
Oh, right.
No. Live captioning.
Okay.
Put live captioning.
All right. Just a second. I'll do it. Live captioning. Down here, maybe. Let's take a look. Join the chat. Okay, let's do it this way. Need help.
Okay, so I have a few announcements to make. So while Miss Diane's doing that, I'm going to do this. Ladies and gentlemen, we are going to be watching the movie tonight at 8 p.m. Central Standard Time, The Pledge, per request of Frankie Leroy. Now, if you're not in our Discord, pinned at the top comments is the announcement, and we also have the link to get into our Discord. Y'all, it is a fun way to interact. We love watching that, okay? So now we're going to hop over to this other trial. Stop it. We're going to zoom past some of this because it got real repetitive. They went through their burden of proofs. They are in verdict watch. So we're going to start here. This is the state's rebuttal. I got to fix the sound. That's the best I'm going to do. Hold on.
That's what I'm told. I have to do it. I know where to go.
Okay, she's talking. She's making the closing. The sound is hell and it's horrible. I know, Miss June. I really want to go though. I want to do Alaska tour, but I also I want to go to there. I would love to do a camp out. I'd love to do fishing. I'd love to do a lot of things. But anyway, what I'm going to do is we're going to get to this part of the video. The sound is horrible. I'm doing the best I can. My apologies.
But now that the media's been on it,
Is it too loud?
Now that the road is leading to him,
Is it too loud?
he says her parents did it. And that's convenient. Let's blame the individual who was accused of accused of killing multiple people, and let's blame him.
What do you think happened to us?
2023, the Phoenix police with Kevin Wolfenberger, investigation continues. And then here he is, hiding behind the wine rack in here. And he's hiding just like he told his daughter. When I have to go on the run, that's what he told him. I have to do it. I know where to go. You saw Christina here. She had no reason to make that up. And that's exactly what he did. Had a makeshift place to go hide. Now they said that we want you to do a legal logic. No, we don't. We want you to follow the path. Physical abuse in 98. Mom sees her last time in November of 98. She wants to leave him. He borrows a reciprocated assault, never returns it. She does not call her mother for the holidays. He does not appear for the March battery. She doesn't appear for the March battery trial. Carl Patton goes looking for his daughter. He abruptly leaves the neighborhood without telling anyone, leaving all of his clothes. Her head is found on April 29th, across from his job, severely decomposed. Extremities found in June, across from his job. He's the only person familiar with that neighborhood. His mom doesn't know where to go. What did Ms. Patton say? The only time we went up there is when we was gonna pick her up. They're not familiar with Atlanta. He is. Cut marks on her bones appear to be done by reciprocated assault, consistent with the type that he took from the job. Her torso never recovered. Could it be because she was pregnant? He never reports his wife missing. Reported missing by her mom in January. Mom's reluctant to give information. He lies to police in September. Never speaks to his children about their mother. Body parts found in ATL. No other family resides here. This is where everything is found, from the house to his job to the location of the home. This is not a legal logic. We're not asking you to jump. We're asking you to follow the path. And all the evidence leads to one conclusion. He's guilty. Now, ladies and gentlemen, we might not have all the puzzles. We wish we had her torso. He was clever enough not to leave DNA. But what we do have is this. You can still see this dollar bill, even with all of the missing pieces. You still see that the path leads to only one person, only one conclusion. Now, sometimes things are challenging, and this is going to be hard for you all to see. But this young lady right here should not have been left like that. This young lady deserves to have raised her children. This young lady deserves to have lived a life. This lady deserves to have continued to work, to be a part of her children's life, her grandchildren's lives, but she is not. The defense has operated on what if this, what if these possibilities, what if. We want you to focus on what evidence came out of the trial, what the reasonable conclusion is, and you will not be telling him something he doesn't already know. For 27 years, he's known what he has done. For 27 years, he has sat and hid from justice. We are imploring you, we are asking you, don't listen to these fabricated stories for what the defense is telling you. When you follow the truth, when you seek the truth, there is only one true result. That this defendant, Mr. Walter Barber, is guilty of murder. And we're going to ask that you do that. Evil prevailed when the men and women failed to act. I'm asking you to act. We are asking you to act. And we are asking you to find the guilty. Thank you.
Thank you. Ladies and gentlemen, I'm going to, in a moment, just give you the charge of the court, which is that law that I promised when I first swore you in to be jurors in this case. And I, too, have a PowerPoint.
What?
I do that. So.
The judge has a PowerPoint? I've never seen a judge do a PowerPoint. How many of y'all have seen the judge actually do a PowerPoint? What?
So that people process things differently. And so some people hear things better and understand it by hearing it. Some people, it's helpful for them to see it. You will have a copy of these jury instructions with you in the jury room while you deliberate.
Thank you.
What, Miss Diane?
I'm still stuck. I'm not finding it.
Ladies and gentlemen, you are considering the case of the state of Georgia versus Christopher Wolfenbarger. Now, the lawyers have referred to some of the governing rules of law in their arguments, and if there is any difference in the law that was stated by the lawyers and as stated in these instructions, you are governed by these instructions. Nothing I say in these instructions indicates that I have any opinion about the facts. You, not I, have the duty to determine the facts. You must perform your duty as jurors without bias or prejudice to any party. The law does not permit you to be controlled by sympathy, prejudice, or public opinion. All parties expect that you will carefully and impartially consider all the evidence, follow the law as it is now being given to you,
No,
and
I
reach a
don't have
just
it.
verdict, regardless of the
It's just a
consequences.
paper.
Excuse me.
Don't
You
be
were
great.
selected and sworn to try the criminal case of the state of Georgia versus Christopher Wolfenbarger. The Fulton County Grand Jury has indicted Christopher Wolfenbarger for murder. I will now read you that indictment. In the state of Georgia, in the county of Fulton, in the Superior Court of said county, the grand jurors selected, chosen, and sworn for the county of Fulton, in the name and behalf of the citizens of Georgia, do charge and accuse Christopher Wolfenbarger with the offense of murder. For the said accused in the county of Fulton in the state of Georgia, sometime between the 10th day of December 1998 and the 29th day of April 1999, exact date being unknown to the grand jurors at this time, did unlawfully and with malice aforethought.
Okay, I think part of this is cameras. I think they have multiple cameras in the courtroom, and I think they're bouncing back and forth, and that is causing the feed problem.
Caused the death of Melissa Dawn Wolfenbarger.
All right, we're back in court here. Sorry, guys. We're just going to go. I'll stop this. We're going to go into jury verdict. Well, maybe not. Okay, we're just going to go back here.
I would like some clarification on the hearing that is going to be conducted outside the presence of the jury regarding State's Exhibit 60. My takeaway from our sidebar was that I was going to authenticate every single page. The defense has now advised me they only have limited objections to State 60, so I would ask for some clarification on what we're doing there.
Starting 60, the defense can be heard.
I think we resolved that with the court's ruling already, Your Honor.
I believe Ms. Kaplan just brought it up because there might have been a discussion while I was in.
No.
Ms. Fulford thought that she was referring to some.
I thought you were referring to the email.
Oh, no, I'm referring to the divorce.
State Exhibit 64 has been admitted, with the only exception being AA for right now.
Right. That was my bad. I thought that's what she was referring to when I said
Okay.
hers.
Y'all.
As to State 60, the foundation has begun with the detective as to any other witnesses that you intend to link up the parts of the foundation with. You are certainly permitted to do so.
Is there an objection to it right now being admitted?
I believe the objection was foundation as to showing emails or communications that link up exactly with what the pleadings are.
Yes, sir. And will that be in reference to each pleading or just select pleadings?
Mr. Zellman, Ms. Fulford.
Judge, my understanding from the court's ruling is that the state could lay the foundation as they move through their case. And with that ruling, I mean, obviously we like them to establish foundation, but I'm not objecting to what has been presented as 60 other than the foundation, which, as you indicated, they can prove up along the way as long as they complete it by the end of their case in chief.
Well, until the foundation is complete as to State 60, it's not admitted.
Understood. Okay, I am going to go forward with Mr. Rivera at this time, Judge. If we finish before 5, I'm hopeful that I'll be able, outside the presence of the jury, to conduct that hearing regarding the foundation and admissibility of that exhibit. Would that be acceptable to the court?
That's fine.
I'm not sure I'm going to be ready. I'm working on that, but just wanted to have clarification on what I was working on.
Please bring in the jurors.
And can we have Mr. Rivera brought in?
You want to brought in now?
Want to have him seated before we bring him
You can
in?
bring in Rivera first. You can bring in the jurors. You can take a seat for right now, Mr. Rivera.
Ada, I got some things I got to get done. So I can, yeah, I will see you tomorrow.
Well,
What
we're going to
time
have
you
a
start,
movie night.
9?
I sent you a link in Discord. Okay, just
I can't hear you. I don't have my ears on.
Okay, I sent you a link to the movie night in Discord tomorrow morning. I think it's 8 your time.
Okay.
No, 9 your time. I'll send it to you.
Okay.
It may be 9 your time. It may be
all right.
8:45. I'll send it to you. Bye, love. Thank you for joining.
Yeah, well, we still need to talk. So give me a
I'll call
call
you
later.
later.
Love
All right,
you.
bye, love.
Bye, everybody.
Everyone can be seated. Mr. Rivera, please raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
Take your seat. Please speak loudly and clearly.
Yes, sir.
You may examine.
Sir, please introduce yourself and spell your name.
Luis Rivera, Luisrivera.
Mr. Rivera, where are you from?
I'm from Puerto Rico.
Okay, but were you living in Miami back in 2014?
Yes, ma'am.
How long did you live in Miami?
My whole life.
You were born in Puerto Rico, though?
Yeah.
Okay, but moved to Miami at what age?
2 years old.
Have you been convicted of a felony?
Yes, ma'am.
Including the murder that we're here about today?
Yes, ma'am.
It's 5 felonies, sound correct?
Yes, ma'am.
And you're currently incarcerated?
Yes, ma'am.
Is that for this case or this case and another case?
Both. Well,
Both. So it's a federal sentence and this sentence.
the state case.
What did you plead to in this case?
This case, guilty
Guilty to what?
to second-degree murder.
If you can speak up, Mr. Rivera, that'd be so.
Guilty to second-degree murder.
Thank you.
One more, Mr. Rivera.
What was your sentence on the second degree murder?
19 years.
Okay, and that was concurrent with your federal sentence, right?
Yes, ma'am.
Okay, and what did you have to do in exchange for getting a 19-year sentence?
I cooperate.
What does cooperation mean to you?
Well, telling.
Telling on who?
I'm a co-defendant, Garcia, Katie.
All right. Did anybody ever tell you what to say?
No, ma'am.
Has anybody ever told you anything other than to tell the truth?
No, excuse me?
Has anybody told you to say anything other than the truth?
No.
Has anybody promised you anything other than the sentence that you got in exchange for cooperation?
No, ma'am.
Did anybody ever tell you, oh, you have to testify about a specific person to get a deal?
No, ma'am. Not at all.
Have you been offered anything on your federal sentence from doing this cooperation on this case?
No.
As part of your negotiation or your lawyer's negotiation of this case, did you give up what's called a proffer, a recorded proffer?
Yes, ma'am.
And even back then, when you gave the proffer, did anybody tell you what you needed to say there?
No, ma'am.
Were you hired to participate in the murder of Dan Markel?
Yes, ma'am.
Who hired you to be involved in the murder?
Well, I got it from my friend, Dudo Garcia.
Is that Sigfredo Garcia?
Yes, ma'am.
How did you know him?
Childhood friends.
So to cooperate and get this deal, you had to turn on one of your best friends.
Yes, ma'am.
Who enlisted Sigfredo Garcia to be a part of this murder?
Katie,
Who's Katie?
his wife.
Is that Catherine Magbanua?
Yes, ma'am.
Do you know who enlisted her to be involved in this murder?
Not really.
Was it a murder for hire?
Yes, ma'am.
Did you know that somebody was paying Katie?
Yes, ma'am.
And Katie was the one that brought the money to you all, right?
Yes, ma'am.
And what was the purpose of this murder as you understood it?
That they wanted the kids.
Who wanted the kids?
Wendy.
Okay. And did you understand that you were killing the father of the kids so that Wendy could have the kids?
Yes, ma'am.
Have you previously referred to a dentist being involved?
Yes, ma'am.
Who was the dentist?
Charlie.
And how was he related?
Katie's boyfriend, side piece, whatever you want to call him.
All right, so Katie was the wife of Garcia, but also the girlfriend of the dentist?
Yeah.
Did you have any contact with the dentist ever?
No.
Did you have any contact with any member of the Adelson family?
No, ma'am.
Everything went through Katie, right?
Yes, ma'am.
What did the dentist, if you know, have to do with the lady in Tallahassee who needed her kids?
I don't know nothing about him. I don't know nothing about that family.
Who was in charge of getting the money after the job was done?
Katie.
How much were you to be paid for your part in this crime?
35.
$35,000?
Yes, ma'am.
Did you know the total amount that the job paid?
No, not really.
Did you know how much Garcia got?
40, I believe.
$40,000?
Yeah.
And did you know how much Katie got?
No, I don't know. I can't remember. But I think it was like 40. I think it was total was be like 100, something like that.
Okay, somewhere in the neighborhood of $100,000.
Yes, ma'am.
Was it a one-time payment or was it a payment that occurred over time? It's what you got.
No, it's a one-time payment.
What did you know about the man that you came to Tallahassee to kill?
I don't know nothing about him.
How did you know who to kill?
Constituto Garcia.
How did he know?
Katie.
Did he have some information about the man you were here to kill?
Yes, ma'am.
Tell him what that was.
I was a piece of paper with his picture on of his face and the address.
Picture of Dan Markel's face?
Yes, ma'am.
And the address of what? Where he lived?
Of his house, yes.
Did you and Rivera refer to each other? I'm sorry, you and Garcia refer to
That's not enough money for me to unalive anyone.
each other as brothers?
Yes, ma'am.
Movement evidence states 45, Your Honor.
Objection.
No, Your Honor.
States 45 is admitted.
Is that you and Mr. Garcia?
Yes, ma'am.
Please silence your phone.
Have you ever been to Tallahassee before you came for this case, related to this case?
Never in my life.
How many times did you come to Tallahassee related to this case?
This case twice.
So were you with Sigfredo Garcia both times?
Yeah,
Was that one time in June and one time in July?
I believe so.
Okay, and July was the time, second time was when the murder happened, is that right?
Yes, ma'am.
Was it just the two of you on both of these trips?
Yes, ma'am.
Objection states 44.
Objection.
Introduce states 44, Your Honor.
States 44 is admitted.
Publishing states 44. Who's this right here?
Garcia,
And this?
Katie,
Who's that?
my baby mama.
Your child's mother?
Yes, ma'am.
What's her name?
Jessica,
Okay, and that's you there?
yes.
Was this picture taken before or after the murder?
I can't remember.
At the time of the murder, was Katie with the dentist? Was Katie with Garcia? Was she with both?
Both.
Were you at the time of this murder living with Jessica Rodriguez?
Yes, ma'am.
There's an address on the rental car contract, 1515 Northeast 135th Street, number 14. Do you recognize that address?
That's my apartment. Yes, ma'am.
All right, let's talk about the first trip that occurred in June. How did you get here for that trip?
Well, we rented a car.
Who rented the car for the June trip?
The first one.
Yeah, if you remember.
I can't really remember. Been so long.
But one of you, either you or Sigfredo?
Yeah, I think it was Fredo. I rented the Prius, so I never rented on the truck. On the
Okay,
car.
so Garcia rented the car for the June trip, but it was a rental car that y'all brought up here.
Yes, ma'am.
Okay, and did you take the same route on both trips to get to Tallahassee?
I don't remember.
Okay, and did he have the paper with the picture of Dan Markel on both trips?
Yes.
And what did you do on the first trip?
We drove by here and we just followed him around to see where he lived and shit. But
Okay, were you planning to kill him on the first trip?
I don't remember.
Okay, did you have a gun on the first trip?
Yeah.
Did you have a gun that you procured specifically to kill Dan Markel with?
Yes, ma'am.
And was that a gun that you bought off the street?
Yes, ma'am.
You bought it.
I bought it.
Okay. And were there any other guns in the vehicle for that first trip, if you know?
I think we had two.
All right. And what was the other gun?
It's a 38.
Whose gun was that?
Garcia.
On that first trip in June of 2014, did you and Garcia go to Markel's residence?
Yeah.
And did you lay eyes on him that first trip?
I believe I passed by his house and scoped him out.
You said you followed him. Do you remember where you followed him on the first trip?
Yeah, I followed him to a daycare.
How long were you here that first trip?
Maybe I don't remember.
A couple days sound right?
Just a couple of days.
Why wasn't Dan Markel killed on that first trip, if you know?
If I remember, I wasn't gonna do nothing in front of no kids. But
He had the kids with him,
yeah, yes, he did.
but for whatever reason, it didn't happen on that trip.
We lost him. I believe we lost him.
Okay. And when you didn't get it done on that trip, was anyone angry at you?
At me?
Yeah.
I don't think so.
All right. Did you hear at some point that y'all were going to have to come back if you wanted to get the money and finish the job?
Yeah.
All right. So you did come back in July. Is that right?
We came back.
And that's when you came in the Prius.
Yes, ma'am.
And you rented the Prius, right?
Yes, ma'am, I did.
And that phone number that you wrote on the Prius rental agreement and wrote brother, that was Garcia's phone number?
Yeah, I think.
You took phones with you to Tallahassee for both trips, right?
Yeah.
Did you turn your phone off for the actual murder?
Yeah, I did.
What about Garcia? Do you know if he turned his phone off?
When the murder happened?
Yes, sir.
Shit. Man, I don't remember.
Okay. Did you stay in Tallahassee for a couple nights when you came here the second time?
Yeah, we stayed there for a night or two, I think.
Okay. Did y'all rent a hotel room?
Yes.
Do you know how many guns were with you on that second trip?
Nah, just one.
You only remember one gun on that trip?
Yeah, I can remember one.
And that's the murder weapon?
Yes, ma'am.
The one you bought on the street?
Yes, ma'am.
What type of gun was that?
A 38.
That's a revolver?
Yes, ma'am.
Do you remember an incident where there was a shot fired into the floorboard of the Prius?
Yes.
Could you tell the jurors about that?
Well, we was driving and Garcia put the gun out and shot the gas line in the car.
Through the floorboard of the car?
Yes, ma'am.
Passenger side or driver's side?
Passenger side.
Okay, and that was the murder weapon that fired that shot?
Shit. Man, I don't remember.
Okay, but he was messing around with some gun and fired it into the car.
Yeah.
And were y'all driving in the car when that happened?
Yes, ma'am.
And did it disable the car?
It's, the car started stopping. Little by little, it just started slowing down.
Okay, and that's the Prius, right?
Yes, ma'am.
How did y'all get the car going again?
We seen somebody that he knew and stopped him and took him to the auto place to get a piece of hose to put it back together.
And the guy that you saw that he knew, are you talking about a local drug dealer here that y'all met on the first trip?
Yes, ma'am.
And that person assisted you in getting some way to fix the car?
Yes, ma'am.
Who was good with cars, you or Garcia or both?
Garcia.
All right, so he was able to make a repair to the gas line?
Yes, ma'am.
Did you follow Dan Markel again during this second trip?
Yeah.
Did you follow him to the daycare?
Yes, ma'am.
Did you actually see him drop his children off at school that morning?
Absolutely, yes.
Did you follow him to the gym where he went inside and worked out?
Yes, ma'am.
Was there a reason the murder had to be done on the day that it was done?
I believe so. I believe he was about to leave.
Who was about to leave?
Markel.
About to leave town?
Yeah.
How did you get that information?
I got it from Tudo,
Where did he get the information?
from Katie,
How did she know?
Wendy.
You think Wendy talked to Katie and told her Dan Markel's travel plans?
Yeah.
Were you present for that
No.
phone call? Okay. But somehow you learned that Dan Markel was leaving town the day after he was killed.
Yes, ma'am.
So it had to be done that day or he'd be gone.
Yes, ma'am.
Okay. And that came through Garcia to you from Katie.
Yes, ma'am.
And when you say Wendy, did you know who Wendy was at the time that all this happened?
No, ma'am.
Okay, but you did know there was a lady that you were helping get some kids back in Tallahassee.
Yes, ma'am.
Were you the driver of the green Prius?
Yes, ma'am.
Have you had a chance to see the gym video and the bus video?
Yes, ma'am.
Are you driving the Prius in those videos?
Yes, ma'am.
What happened when you got to the driveway of Dan Markel?
Well, I pulled up right behind him, and Garcia jumped out and shot him.
How many times did Garcia shoot Mr.
Twice.
Markel? Did he shoot him? Where was the victim when he was shot?
He was inside his parking garage, and his sitting down the driver's side on the phone.
And did Garcia shoot him through the window, if you know?
Through the window.
How long would you say you were in the driveway?
Just seconds.
How was it decided which one of you would be the shooter?
Because I wasn't going to do it.
You didn't want to be the shooter?
No.
On the bus video, we see somebody in a white shirt kind of jumping around in the passenger seat. Is that Mr. Garcia?
Yes, ma'am.
Do you remember what was happening when he was doing all that jumping around?
I think he was trying to hide a gun. If I'm not mistaken, he was trying to hide it.
What did happen to the gun?
It got thrown away
Thrown away where?
in the ocean somewhere.
All right, who threw it in the ocean somewhere?
He did.
All right, was that on the way back to Miami?
Yes, ma'am.
At some overpass somewhere between here and Miami?
Absolutely.
Where did you go after the murder? Go home?
Now we had to stop somewhere to eat. Then we went home.
Did you stop at an ATM?
I don't remember.
I'm gonna show you states exhibits 38, 39, 40, 41, 42, and 43. 38 through 43.
Yes, ma'am.
Are these images fair and accurate photos of you pulling through an ATM?
Yes, ma'am.
And the date, July 18th, 2014?
Yes, ma'am.
Pembroke Pines, is that on the way home from Tallahassee?
Yeah.
That's you at the ATM. Are you the driver?
Yes, ma'am.
And who's that in the passenger seat?
Garcia.
Move to publish states, I'm sorry, introduce states 38 through 43.
Any objection?
No objection.
States 38 through 43 are admitted.
May I publish?
You may.
Is that the vehicle you were driving the day the murder was done, sir?
Yes, ma'am.
Publishing 39. Is that you at the ATM machine?
Yes, ma'am.
States Exhibit 40. Is this Mr. Garcia? Is he your passenger?
Yes, ma'am.
States Exhibit 41. He's the passenger that was jumping around when we saw the car in Tallahassee on the bus video?
Absolutely.
Do you remember when you turned your phone back on after the murder?
Not really.
Do you remember who was the first phone call that either of you made after the murder?
Garcia.
Who did Garcia call?
Katie.
And were you able to hear Katie on the other end of the line when he was talking to her?
Yes, ma'am.
And were you interested in that phone call?
Yes, ma'am.
Because she was going to be the one to get you the money, right?
Absolutely.
And was that phone call in reference to letting her know it's done and she's going to get the money?
Yes, ma'am.
When did you get the money?
Saturday morning.
Was that the next day?
The next day.
Do you remember that on that Saturday morning you got a call from Catherine Magvanoa?
Yes.
She was looking for you to give you the money, right?
Yes, ma'am.
And was that unusual for her to call you?
Not really. She never calls my phone.
She never calls your phone, but she couldn't get a hold of Garcia,
She
right?
couldn't get a hold of him, so she got in contact with me.
Okay. And at that time, wasn't Garcia living with another woman?
Yes.
And that was the woman that goes by the nickname Shrimp?
Yes, ma'am.
Okay, and that's where you ended up rousting him out of, right?
Absolutely.
To go get your money, right?
Yes, ma'am.
Okay, so he wasn't living with Katie as a family at that time.
Nope.
Okay. So when you say that Katie was with both of them, do you mean just that Katie was always kind of off and on with Garcia?
Yes, ma'am.
So she has other boyfriends, sometimes he has other girlfriends, but they always find each other again?
Absolutely.
One moment, please, Your Honor. All right, tell us what happened when you got your money. How'd you get it? Where'd you get it?
I was in the barbershop, and they pulled up to my house, Katie and Garcia, and they called my phone. They I think my baby mama called me. Well, they came to my house.
Okay,
I was-
Katie and Garcia brought the money.
Yeah, I was in a barber shop, and
Okay.
Katie and Garcia, they went to my house and brought the money.
All right. And do you know where Katie got the money from? Were you there when Katie got the money?
No,
But you knew that she was supposed to go get it,
absolutely.
and she did.
Yes, ma'am.
How much did you get?
35.
Was there anything unusual about how your payment was packaged?
Yeah, it was weird. It was all stapled.
Was it
seen that
cash
before.
money?
Cash. all
Okay,
hundreds.
stapled how? All hundreds.
All hundreds, $1,000 stapled.
Stapled into bundles of $1,000 each.
Yes, ma'am.
Have you ever seen stapled money before?
No,
Did you and Garcia buy anything with your cut of the money?
I just bought a motorcycle.
46 and 47. Moving to evidence 46 and 47, Your Honor.
No objection to the defense.
No objection.
They are admitted.
Publishing States Exhibit 46. This yellow motorcycle, whose is that?
Garcia.
Is that something he bought with the money that was the proceeds of this murder?
Yes, ma'am.
Okay, and what about this vehicle back here?
Yeah, he bought that one too.
He also bought that with his cut of the money?
Yeah,
And States Exhibit 47, what about this motorcycle right here?
that's mine.
Is that what you bought, or part of what you bought with your money?
Yes, ma'am.
How long after the murder did you guys make those purchases? Days, weeks, months?
Probably like a month.
Did you make any changes to your cell phone after the murder? Did you dump your cell phone?
Man, I don't remember.
Did you meet with investigator Newland from my office to see if you could recognize some voices on some recorded telephone calls?
Yes, ma'am.
And did Mr. Newland play some calls for you and have you initial on a sheet if you could identify the voice on the
Absolutely.
sheet on that call?
Yes, ma'am.
States Exhibit 136. Is this it? I'm going to show you what I have marked as States Exhibit 136. Do you recognize this exhibit?
Yes, ma'am.
And are these your initials here?
Yes, ma'am.
And does that mean you're verifying that the highlighted name, you know that person and that is their voice
Absolutely.
on the particular call that reference?
Yes.
Judge, at this time, I'd ask to move into evidence 136.
Objection. 136 is admitted.
One moment, please, Your Honor.
Take your time.
Did you know where the dentist lived?
Nope.
Did you know that the dentist had a safe full of money?
Nope.
Did you know that the dentist was going to be paying for at least part of this murder?
No.
And if you had known that the dentist had a safe full of money, would you have driven all the way to Tallahassee to do the murder to then get the money?
No.
What would have been a better idea?
Overruled, he has knowledge of his own actions and what he was thinking at the time.
What-
Answer the question.
What would you have preferred to do to get the money?
I would have went and robbed them myself.
Did you suggest to Garcia on the way out to Tallahassee that y'all could just go to whoever had the money and rob them instead of doing this murder?
I had mentioned something like that, yes.
But that Garcia said that wouldn't work, right?
No.
Nothing further.
Cross-examination.
Good afternoon, Mr. Garcia.
Excuse me?
I said, good afternoon.
Good afternoon.
I just want to make sure I understood your testimony. It was your testimony that the first trip you came up on, you scoped out Mr. Markel's house, correct?
Yes, ma'am.
And that he was going to be taking his kids to school. So when he came out with the kids, you're trying to follow him to the school, correct?
Yes, ma'am.
And you got lost. He lost you.
Yes, ma'am.
Okay. And the second time that you came up, you knew he was going to be taking the children to school. And so you followed him to the school, correct?
The daycare, yes.
Yes. And then you knew he was going to be going to the gym, right?
I didn't know he was going to the gym. I just followed him.
You followed him to the gym.
Yeah.
Okay. And then you followed him to his house.
Yes, ma'am.
And that's where he was killed.
Yes, ma'am.
And the woman who wanted him to be killed, past you and Sigfredo and Katie, the woman who wanted him to be killed was Wendy Adelson, correct?
Yes, ma'am.
It was she wanting her children, correct?
Absolutely.
Mr. Garcia, I'm going to show you what has
Mr.
been-
Rivera.
Oh, I'm so sorry. I am so
Twice.
sorry. I apologize. Mr. Rivera, I'm going to show you what's been marked as Defendant's Exhibit 50. Could you take a look at that and tell me if you recognize that?
Yeah.
And what is that?
Like a profile of everybody's face.
Okay. And did you make some marks on this for me and then sign it on March the 11th of 2025?
Yes, I did.
You just hold on to that for a second. Mr. Vera, when we met with you that day, taking your deposition, I presented that to you. You gave us information about what had happened, pretty similar to what you talked about here today, correct?
Yes, ma'am.
And when we were done talking about those things and some information about Sigfredo and Katie, I presented you with what's in front of you as Defendant's Exhibit 50, correct?
Yes, ma'am.
And I asked if you would put the number 1 and circle it next to the person you know as Katie, who you said was in charge of this whole deal, correct?
Yep.
And did you do that?
Yep.
All right. And then I said, would you put a number 2 next to the person you say did this killing?
Yes.
And you did that, correct?
Yes, I did.
And that was Sigfredo Garcia.
Yes, ma'am.
The first one was Katie McBanois, correct?
Yes, ma'am.
And then I said, would you put a number 3 next to yourself on the paper? And did you do that?
Yes, ma'am.
And you're the one who got the gun that was used to kill Danny Markel, and you drove the car that day. You didn't shoot him, right?
Yes, ma'am.
Okay. And then I said, if you would, please put the number 4 next to the man who was killed, and you did that with Danny Markel, correct?
Yes, ma'am.
And then I said, if you would, put the number 5 next to the lady that wanted the man killed. And did you do that?
Yes, I did.
And was that with Wendy Adelson?
Yes, I did.
And then I asked you if the 2 people on the top of the page who have their pictures there and the names Donna Adelson and Harvey Adelson, you see those on the top?
Yes, ma'am.
I asked you, as far as you know, were they involved in any of this? And you said no, correct?
Yes, ma'am.
So I asked you to put X's next to the people who on that page were not involved in this.
Yes, ma'am.
And you did that.
Yes, I did.
Thank you. Just one moment, Your Honor. I don't have anything further.
Redirect examination.
No, Your Honor.
Is Mr. Rivera released or will he be recalled?
He needs to remain under the rule, Your Honor.
Very well. Mr. Rivera, please do not discuss your testimony with anyone else. The bailiff will take you at this time. Parties can approach.
So I think that's going to be it for today. Honestly, it's 4:41 their time. I do know that he thought that there was only a certain number of witnesses that's going to come up. So there's a big chance that this may be done for the day. So we are in a verdict watch, but we don't have any video for it. So it's weird.
The jury, at this time, we are going to go into recess for the day. The same instruction that you have received since the start of jury selection, not to discuss the case with anyone else or to look at any information about the case. Once again, I'm going to remind you of this. Please report on Monday morning at 8:45. We will anticipate getting started by 9 o'clock. Enjoy your weekend. We will see you Monday. Yes.
I need to create a sidebar. I think I'll do that now. I'm prepping day to Mondays. I don't forget. Don't forget, y'all, we have we do have, oh, by the way, I want to say hello, everybody, and thank you so much for joining. We are going to have a movie night tonight. It's going to be The Pledge, 8 p.m. Central Standard Time, 9 p.m. on the East Coast, and 6 p.m. on the West Coast. Hopefully, y'all can come join us in Discord. What? Oh, Tinkatude. You funny, Tinkatude. That'd be funny. That real funny. So Wolfenberger they will go back into jury deliberations Monday.
Report at 9:15, and by the time everyone has reported, we'll expect to get going with the trial by 9.
So we'll be here at 8.
Have a good weekend. Once again, do not discuss the case. Do not read or seek out any information about the case. Have a good night.
Have you noticed that yesterday was a striped shirt just like this one, but she had a yellow sweater? Her style, I don't know. I don't know.
Ms. Kappelman, the witness is here this afternoon to start that, or you need to do that on Monday morning?
I can start that this afternoon, Judge. We're just not prepared to go through the whole thing yet. We've been working on it since the issue arose through about 10 minutes ago. So.
All right. If we can start at 8:30, have the witness and go through it smoothly. We'll give everyone an opportunity to get some rest from the weekend. Do you all prefer to do it that way?
Yes, Your Honor. Thank you.
Judge, I did fail to introduce one of the ATM still images, Case Exhibit 37. Would it be acceptable to move to admit this?
If you're relying on the same foundation provided by Mr. Rivera, unless there's an objection. No. States 37 is admitted. Briefly before we leave today, just to go through what has been admitted and has not, it cannot hurt. I have on my chart state exhibits 1 through 34 as admitted, 37 through 47 admitted, 55 admitted, 67 and 68 admitted, 64 admitted with the exception of AA, 88, 89, and 90 admitted, 119 through 128, 119, 120, 122, 123, 124, 126, 127, 128, and 136.
Was one missing between 119 and 128, Your Honor?
On my list, I have 119, 120, 122, 123, 124. I believe there was testimony from Miss Maltese about the eyeglass frame and the car, but I'm not sure if 121 was admitted.
What happened, Judge, is Ms. Kappelman said that that's what she was requesting, but then when she said, I'd like to admit State's exhibit, it was 122 and 123.
So I will move 121 into evidence at this time, Judge.
Is there an objection?
No objection.
And
After 128, Your Honor, you showed what else?
after
What?
128.
Where? I couldn't find it. I was searching.
Now we have a demonstrative A and a demonstrative D, which have been used. And
Yes.
advised the court no longer accepts demonstratives. Would you like to make those items court exhibits for?
Can you send the link, please?
Yes. And the foundation for 60 is ongoing at this point, also as to 60.
Can you do me a favor? State of confusion. Put the link in so we can watch the verdict. I'm not finding it. Thank you. Thank you so much.
All right. 8:30 on Monday morning, we will go through any predicate or foundations that need to be addressed prior to the next witness. Have a good weekend, everyone.
Got it. Got it.
And has the verdict been?
And just change her name.
I did it.
All right, for the jury. President accounting for you, Your Honor.
Thank you all. Please be seated. Will the foreperson please stand? Good afternoon, sir. My understanding is that the jury has reached a verdict?
Yes, the jury has reached a verdict.
Okay, and was that verdict unanimous?
Yes.
Okay, and has the verdict been filled in, signed, and dated by you as the foreperson?
Yes.
Okay, will you please hand it to the deputy? And then you may have a seat, sir.
How long was it, y'all? Does anybody know the time?
Will the defendant please rise? In the Superior Court of Fulton County, State of Georgia, the State of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. Count 1, we the jury find the defendant not guilty this 22nd day of August 2025. Will the state and defense counsel please come up and look at the verdict form and confirm that you have no objection to the form or legality of the verdict?
He's a free man. I didn't think they proved it. I honestly, guys, I felt like this is where guilt and innocence is not clear. I don't think the state proved
Counsel for
it.
the state, counsel for the defense, is there any reason that I cannot release
Look at
the
the
jury?
family.
No, Your Honor.
Okay. Members of the jury, I'm going to take just a quick moment to thank you for your time and for your attention to this process. It was
Look
a
at-
long 2
look at
weeks,
the wife.
but I appreciate that you were here each day ready to pay attention and to do your job. Thank you very much for deliberating, for being here, and for being willing to serve as a juror to your fellow citizens. I will also tell you, ladies and gentlemen, that in just a moment, I'm going to release you from further service as a juror in this case. I want to let you know that when you are excused, you are free to go. Enjoy your weekend. I want to let you know that you may be contacted by people about your decision in this case. You're not required to talk to anyone about your decision in this case. You can if you choose to. I often encourage people to, if you're comfortable talking to lawyers about your decision, to do so because it helps the lawyers understand what motivated you, what was persuasive to you, et cetera. It helps them understand and be better lawyers, right? So I always encourage you, if you're willing to talk to the lawyers that are involved in the case, it's always a helpful process. And so I encourage you to do so if you're comfortable. But if someone contacts you and you tell them you don't want to talk to them, you're not obligated to talk to them. And if someone bothers you or continues to try to talk to you after you've told them no, you need to let my office know, and we will make sure that that person does not continue to bother you, okay? Ladies and gentlemen, the last thing I will say is just that if you need any written proof of your service here as jurors, in this case, we're happy to provide you with any written documentation. And if you should have any issues with that, also let my office know and we'll do what we can to assist you. Thank you again for your service. You are excused. Have a good weekend.
All right.
But the thing is that the lady, the wife, and the husband team, that they are very much so probably going to be the next ones they look at if they do anything further.
Thank you all. Please
Now
be
watch
seated.
him stand up. Hallelujah!
Mr. Wolfenbarger,
Look.
You have been found not guilty of the charges against you in this indictment, and the court therefore adjudges you not guilty of the offenses charged and orders that unless you are being held on some other charges that you be released. Anything else that I need to take up from the defense?
Am I released right now?
I believe you have to be processed through the jail to actually be released to the street. There is paperwork that has to be done. Anything from the state? Okay. This matter is adjourned.
Okay, so we're going to keep an eye out and see in the next minute or two if we have any interviews going on. Then we'll sit here and we will do the let's see who has it.
Options is.
Okay, so we'll keep an eye out just real quick and give it a few minutes and see what's going on. So what are y'all's thoughts on this? I mean, wow. That was a shocker. I know. Well, they do that all the time. It's habit. That will be funny. If he walks out of jail, I'm going to laugh my butt off.
And it also says any evidence of.
We need to clear out.
So I'm looking to see if there's anything coming up for him. But he was found not guilty, but that does not mean he didn't do it. There's just not enough evidence. There just was not enough evidence to convict. So today we've heard through multiple people in the Donna Adelson trial. Give me a second. I've been taking notes. My thoughts is that I think him possibly, yeah. I feel it was a correct verdict. I very rarely do I say this, but I do feel it was a correct verdict. Yeah, I don't think they're going to ever get justice. I really don't. And that's the sad thing. We're not going to get justice. Thank you so much, June, for setting up the movie event. I greatly appreciate it. So let's real quickly do a quick overview. No, I'm not upset with that verdict either, June. I think that this is one case that I can sit there and say they didn't have evidence to prove it. They could not prove it beyond a reasonable doubt. And that's on the state. I felt this was a real crappy trial, honestly. So day one, Leon County Courthouse in Tallahassee, Florida. Stephen Everett, Donna Adelson, age 25, is charged with first-degree redrum conspiracy and solicitation of redrum for the victim of Dan Markel, an FSU law professor and ex-husband to Wendy Adelson. The prosecution, Sarah Kathleen Dugan, called Donna in her opening statements, called Donna the domineering matriarch and the mastermind behind the 2014 redrum to hire plot. She alleged that it orchestrated the unaliving and the removal of Markel as a barrier for relocating her daughter and her grandsons to Miami. Also claimed that Donna offered Markel $1 million to allow the move and help plan his red room when he refused the $1 million. I would have taken the $1 million in cash and then I would have said, nope. But, that's extortion. So, yep. They also highlighted her perseverance of never give up. They previewed evidence, including the wiretapping, family communication, Donna Adelson's attempted flight to Vietnam in 2023. Now, the defense, Jackie Fulford and Josh Zillman both spoke. They called the prosecutor's case a sensational story built on a movie in theory, but not the evidence. Argued that Donna was a grieving grandmother, not a criminal or a conspirator. Emphasized that poor Charlie Adelson, not Donna, paid the hitman and coordinated logistics. They also challenged the idea that Donna Adelson's age and demeanor matched the prosecutor's mastermind label. No. They also displayed a visual board mapping connections between the convicted and co-conspirators Charlie Adelson, Catherine Mabanua, Sigfrido Garcia, and Luis Rivera to argue Donna was not a part of that inner circle. So, that is how that was. Let me go to my witness list. So we have, it's pouring there again. Oh my gosh. Oh my gosh. I'm so sorry. Yeah, I believe too, it's too much time to have passed. So we have Detective Craig Isam, lead investigator in the Tallahassee PD, walked the jury through the timeline of Dan Markel's red room, and he established the procedural foundation. Oh, no, thank you so much. State of Confusion, you're awesome. The agent Jason Newland, FDLE, intelligence and analyst, interpreted a wiretap excerpt from the 2016 and 2019 wiretap. He previewed Donna's code language. Dr. Heather Markel, Dan Markel's sister, emotional testimony on the family loss of custody and flight. What? Oh, yeah. Wendy Adelson will be testifying. Charles will be testifying. So it was a good afternoon, but the biggest enjoyment out of all of this for me, and I couldn't believe what we were seeing, was the debacle and the defense's objections and causing more delay. The judge was very, very adamant and clear that he was not happy with the situation. And that was very interesting. They were, like I said, they were very, very unhappy about it. And I don't see any interviews. If we do, we'll probably see them tomorrow. But anyway, it was a very interesting time. I'll say that. I will say that. Let me get this on stage so we could do the giveaways. Remember, if you do win something with me, it is your responsibility to communicate with me with your addresses and names, emails, and phone numbers so I can contact you and get your prizes to you. I say that time and time again. I just want to make sure everybody would get their prize. Okay, we are going to go for we're going to go for the drawings. Let me see what I can do. We'll do this. All right, let's get ready. Good luck, everybody. is it going to be? Frankie Leroy. Woohoo. Since we had that many shares, I'm going to draw again. We had a lot of shares, and thank you so much for sharing today. That is one way people can get and find out about Angela. Thank you. I love your little thing. We only had one sub, so that automatically goes in. All right, this is the I liked. Thank you guys so much for sharing. It really helps promote the channel. Liked does too. Miss June. Miss June. Who's going to be next? Angela, you won again. Okay, I'll do it again. I always like to have it. I mean, if you win again, that's fine, but I want to get another person. And if it lands on a mod, we do it again. K-Swan, you're a mod, we'll do it again. Yes, too many objections. I mean, the defense is really scrambling, I feel. All that June. Hello, Miss June. I just feel that the defense was just being petty today, so we'll see how it goes tomorrow. Congrats to all of our winners. Congrats, winner, chicken dinner. Now, we're going to see. We're talking about when to move the studio. But this weekend is going to be real busy. We're going to be moving out of this location, transferring the studio to my home, along with the entire contents of this office. So it is going to be very busy. Do we have, is this the first, I need to look at my calendar real quick, make sure, see when we have our next. Okay, we're good. So next members only live is going to be on the 5th. Trying to do something fun with that. I don't know. We'll see what we can come up with. So yay. All right, we're good. Wolfenberger, I got to edit that because Wolfenberger is done. They are finished. Save, so get that off my list. Monday, we have Sarah Boone will be in family court, so I know we're going to be hearing about that. And then Connor Bowman is going to have a hearing on, was it a hearing? On the 28th, and then we have Donna Adelson all week. Yay! So everything looks good. I'm so blessed. But I want to say thank you so much for K-Swan and Tinkitude. But June, I mean, all three of you, thank you so much for your hard work. And we are looking for more mods. We are looking for more people to join our fabulous team. And we'd love to have you. If you are interested, just reach out to me in Discord. Don't forget, please. We love hostessing movies, and we're doing this movie tonight. We'd love to have you come on. Just go into Discord, go to the movie under voice. You'll see movie night. That is the title. And you can join us for a movie, and it doesn't cost you anything. You get free movies, just the popcorn snacks, maybe. That will be all. But once again, thank you guys so much. You have been a huge blessing to me. This may be the last, I don't want to cry. This may be the last time you see me in this room. Depends on how we can get everything going. I'm trying not to cry because I love this room. My sister decorated. And it's going to be hard, but I'll be in my home and I'll have a nice big office in there, bigger than this. And it'll be a lot lighter in color. It will be a totally different theme. It may be something that I have to work on and build on. So I look forward to new places, new environment. It's going to be some changes. So pray that I can dismantle all this and reattach everything. Y'all have no idea. Cables are your nightmare. They easily break. They can easily break. You just unplug them and plug them back in and they don't work. So be very prayerful that I can get everything up. I may be doing this from the iPad. Just saying. Boone is back in family court. Now, we won't be able to see that unless they televise it, but I don't think they will. So there you go. All right, mods, y'all grab dinner. Everybody grab dinner. We'll meet you 8 o'clock my time, 6 o'clock West, and 9 East for a fabulous movie night. We'll see you later. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.